thought they were up there. Hello and welcome to Trial TV Live. I am the Squeegee of Justice. How's everybody doing today? I'm a little distracted because not more than 2 minutes ago, this was filled with, there we go. That was filled with little monkeys climbing up and down, and they were jumping from the top. So, and Richard, they're loving your scratching post right now too. They're over here. So, anyway, how's everybody doing? Thank you for joining us. We are continuing our coverage of Florida versus Donna Adelson. We are into day 8. Jennifer, yes. Will Donna testify today? That's a good question. Good morning, Mel. Good to see you. Carol, good morning to you. Sharon saying good morning. Good to see you guys. Patsy, my dogs are wondering why I'm up so early. They are still on the bed. Barry, think they'll have enough witnesses for a whole day today? Yeah, they should. Let me get to our witness list. So here is. Let me come over here. All right. So, actually, let me just make sure that. All right. We have a. Hold on a sec. Let's get you into the courtroom. We have a seal going on. All right, hold on a sec, guys. All right. Okay, there. Just in case they come in, because the jurors are supposed to report at 8:30, and then they start at 8:45. So sometimes sometimes Judge Everett and the attorneys talk before, so I just want to make sure we don't miss anything. Okay. And we got closed captioning. Okay, we're good to go. All right, so Barry, back to your question. Let's see. And this came from Sherry. So you can thank her. This is, let me see here. Let me go over here now. All right, so here's their witness list. And there are 2 pages, so this is just page 1. Okay. So we can take a look at this. So yesterday we had 8. There were 8. 8 witnesses took the stand. I don't know if you guys are going to be able to see this. Let's try this. All right, so here's the witness list. Let me zoom in a little bit on that. Okay, so here's their witness list. Now this is just a portion of it, so I'll show the other part. So James Todd Murphy, Wendi, which we know is not going to happen because that was already ruled upon. Susan Brotman, Richard Shagrin, he testified yesterday. Ann Cunningham testified yesterday. Ron Gutterson, he testified yesterday. Lisa Carey, Timothy Kelly. Yep, Tim Kelly, he was the realtor. He testified. Kristen Adamson, Maricel Descalzo, Tara Karas, that's Catherine Magbanwa's attorney. She represented her in the other 2 trials. Linda Bailey, probably that's Esquire. She's a lawyer too. That's probably, it says expert next to her name. So Eddie Varnes, he testified. He was the private investigator. Josiah Roloff and Kelsey Gouet, she testified yesterday. So they're from Spokane. So Kelsey testified she was the digital forensics. Tarona Khan, she testified yesterday. She was also a private investigator. Craig Isom, we know him. He testified for the state as well as Jason Newland. And then Charles Adelson. All right, so there's that. And then this is the other part of it. Let's see, where is that? Is it here? I think here's the other. Okay, here's the other part of it. All right, so Sherry Bennett, Chris Corbett. Chris Corbett we've heard from before. Patrick Sanford, he's the FBI agent who did the bump. Catherine Magbanawa, of course. Luis Rivera, we know. Yindra Mascaro. Joanne Maltese, Jessica Rodriguez, Felicia Hills, Bryce Google. That person's last name is really Google. And then expert witness, expert to disclose upon retention. So they're going to try and protect that person's identity. Sarah Newhouse, custodian of records. We've got a couple custodian of records and all witnesses identified by the state. So there you have it. So I think they have enough people on their list, right? It seems like they have enough people on their list to fill a day. What do you think? What do you think, Barry? Do you think they have enough people on their list? All right, so that's witness list number 2. Let me just jot that down. So this is defense witness 2, and then this is defense witness 1. So defense witness 1. This one. All right. Then I got another screenshot. What was this other screenshot? What is this? Okay, that's old. I think that one's old. Probably throw that one away. Just trying to get my desktop in order here. I took another screenshot of the possible, let's see. Maybe I didn't take a screenshot of it. Okay, I did not take a screenshot. Let me get a screenshot of this.
Ms. Kaplan,
I'm not accusing the state attorney's office of doing anything. I'm merely advising the court what transpired. Mr. Campbell advised that when somebody from the sheriff's office went to speak with this officer, the officer expressed to that superior that they were no longer willing to speak with us. And was no longer available, in fact, that the officer was going to be on leave.
Well, we can bring in Under Sheriff Google. However, at this point in time, this does not invoke the court to need to go through a Richardson inquiry. The witnesses that you're referring to, have they been disclosed to the state?
It's not by us, Your Honor, because again, we have not had a chance to speak with her.
Do you intend to call these individuals?
If we can confirm the information.
These are not answers. If you're not actually intending to call a witness that has not been previously disclosed, at this point, I do not have to engage in a Richardson hearing on this matter. But as far as witnesses that you may be investigating or you may speculate to have relevant testimony, until you disclose them, until you actually intend to call them, there's really not much I can do with this. If you wish for me to hear from the Under Sheriff, I will. But as far as perfecting a subpoena and speaking to these people who are either not under subpoena or not listed witnesses, there's not very much I can do.
Judge, it is the defense position that between 12:30 and when we got to the jail shortly before 5, somebody from the sheriff's office spoke with this officer and convinced her that it was not in her interest to cooperate with the defense. We are asking for the court's assistance because the rules...
To do what exactly?
So that we can at least speak with her to find out if she has anything that's admissible.
The court has jurisdictional authority limits. For someone who is not under a subpoena, I just can't compel them to come here, go there, or do certain things. There is no subpoena for this individual. If they choose not to speak with you, so be it. But please bring in the undersheriff. He can speak to these matters that you've raised.
Thank you, Your Honor. Judge, if I may, whatever happened after we spoke with the officer yesterday afternoon, even if we had a subpoena ready to serve, they have represented to us that she is not available to be served. Without the court's assistance, we cannot accomplish that.
Well, and this goes to the timeliness of the witness itself and the fact that it's occurring in the middle of the trial. But that part of it, again, there's certain things I cannot assist with. And the Sheriff Google, please raise your right hand, sir. Do you swear or affirm the testimony you're about to give to be the truth?
Yes, sir, I do.
If you can just stand in front of the court reporter instead of taking the witness stand. If you can explain to me what occurred with, I believe this is one of the correctional deputies that may or may not have testimony concerning this case. Please explain what happened with them to the best of your knowledge.
To my knowledge, I was approached by Captain Georgia Dent, who has spoken with Deputy Franklin, and Deputy Franklin informed Captain Dent that she had received a phone call from inmate Addison's attorneys, and they were advising her that they were going to be at the detention facility later that afternoon, which was on yesterday, and they wanted to speak to her. So she was inquiring with Captain Dent if she actually had to speak to them, because she was saying that she didn't know what they wanted to talk to her about. Captain Dent then came to me and gave me that information. I then talked to our general counsel, the agency's general counsel, and we were in agreement that she could speak to them if she so choose voluntarily. If she did not want to speak to them, they would have to have a subpoena to compel her to speak. So after speaking with General Counsel, I spoke back to Captain Dent, and she relayed that information to Deputy Franklin.
Did you or any other person in a position of authority over this guard instruct them not to speak to the defense?
No, sir.
Any examination for under Sheriff Google by the defense or state?
Not from the state, Your Honor.
Good morning, sir.
Good morning.
It is our understanding that Officer Franklin is now on leave and not available to be served.
That's not my knowledge. I have no clue about that.
So she is available to be served?
I would think so. I'm not aware of her being on leave.
Thank you.
Yes, sir.
Sheriff Google, there's no more inquiry that I will make of you concerning this topic. I appreciate you being here this morning.
Yes, sir. Thank you.
Concerning the other witness, who is not the guard, was the defense able to make contact with this individual?
Just a moment, Your Honor. Judge, the information that we provided to Your Honor was purely to put it on the record that we had followed that information. After discussions amongst Ms. Fulford and I, we had decided that we were not going to pursue that given the status of that individual and the misinformation we believe we were being given.
Right. As to the, I believe, second witness, is this person going to be disclosed, or are you going to seek to call them as a part of your case?
No, Your Honor.
As to the guard, If you need to follow up with a subpoena for this individual, if they have chosen not to speak with you, you need to do so with all haste. The jurors at the time of selection were told this would be 3 weeks, that it could possibly go longer, but 3 weeks is what they were told. For today's witnesses, let's go through that before the jurors are brought into the room.
And I apologize, I did not have a chance to prepare a list. At least for this morning, our intent is to call Kristen Adamson, Linda Bailey, Sarah Newhouse, and Marisol Descalzo.
For this afternoon.
This afternoon is up in the air, and that's going to require some additional conversations with our client.
During the lunch break, that will be your opportunity to have any final conversations concerning whether she will in fact testify. We'll give the jurors a longer lunch break if necessary to accommodate this. Instead of an hour and 15 minutes, it will be an hour and 30. After that, we are going to have to go on the record concerning is she or is she not testifying.
Yes, sir.
Please bring in the jurors.
Your Honor, I know that 3 of the witnesses are here. Mr. Scalzo's flight does not arrive until a little after
10 o'clock, you said.
Yes, sir.
Oh, Ms. Kappelman, I neglected to give you an opportunity to speak. If you actually wanted to be heard, please do so now.
Yes, sir. I'm good. Thank you.
All rise, jury entering the courtroom.
Good morning, members of the jury. Good morning. Everyone can be seated. We are going to continue today with the defense's case in chief. Mr. Zellman, you may call your next witness.
Thank you, Your Honor. The defense will call Kristen Adamson.
Please raise your right hand. Good morning. Do you swear or affirm the testimony you will give today will be the truth?
I do.
You may take your seat.
Thank you.
You may examine when you're ready.
Thank you, Your Honor. Good morning.
Good morning.
Can you please introduce yourself to the jury?
I'm Kristen Adamson.
Hey, Ms. Adelson, how are you employed?
I'm a lawyer.
What type of law do you practice?
I practice family law, and I have done so for 37 years.
How long have you been practicing?
37 years.
Okay. Are you board certified?
Yes, I am board certified in marriage and family law by the Florida Supreme Court.
What's involved in becoming board certified?
And I've been board certified since 1996. I had to take a test on family law, and I had to pass a peer review by judges and my colleagues in the Florida Bar Family Law section. I have to recertify every 5 years, so I've had to also do that every 5 years. I'm coming up, I think 2026, I will be in my thing again where I'll have to recertify.
Have you received any other accolades or awards throughout your career for your work in family law?
I was heavily involved in the Florida Bar Family Law section on the Executive Council for a long time. I am a fellow in the American Academy of Matrimonial Lawyers, past president of the Florida chapter, and I am a fellow in the International Academy of Family Law Lawyers as well. All of those required board certification prior to being allowed to be a fellow, as well as another test nationally and locally, and written tests and oral tests as well.
And how long have you been a member or a fellow of the American Academy of Matrimonial Lawyers?
I have been a fellow since 2020, and I was president in 2012.
How long have you been a fellow in the International Academy of Family Lawyers?
Approximately 5 years.
In your work as a family law attorney, did you have occasion to represent Wendi Adelson?
I did represent Wendi Adelson in the end of 2012, I believe it was, 2013, and part of 2014.
Would you call her divorce a bitter custody battle?
I would not. That's not how I would characterize it.
How would you characterize it?
She had a relocation case where she desired to go to Miami. All relocation cases are a little bit more difficult than just regular custody cases because we almost always have to have a court determination on a relocation case because, unlike almost all other family law cases, relocation is a win-lose thing. Almost everything else in family law is sort of a split the baby. Relocation is not. So we did have to go to court on that, and that going to court always is a little bit harder, but in general, this was more or less after that a run-of-the-mill kind of parenting issue kind of case.
Is it unusual to seek, in your practice, has it been unusual to seek relocation?
No, not at all. I have two right now.
Now, speaking to Tallahassee, why is it not unusual?
Why is it not unusual?
Yes.
It's not unusual because it depends on why someone is here in Tallahassee. Tallahassee has a lot of students with the university. They may graduate with a degree, have children, expect to be able to move somewhere else after they graduate. One person wants to leave, the other person doesn't want to leave. The two cases I have right now that are not here in front of this court, so they're actually, one of them settled. But one of them, the mother received a potential job offer in North Carolina. The father lived here. She wanted to move to North Carolina. All of his family was here. Her family was not. She wanted to move somewhere else, so that was one. And another one that I have right now is a person wants to move to Pensacola. My client wants to move to Pensacola because her family is there, and the father does not want to because his job is here. So it's almost always about moving to be close to your family when a marriage dissolves. I mean, that even happened with my sister when she divorced in Florida. She moved to Atlanta to be close to my parents. It's a very common thing for people to want to move to be near their parents, no matter how old they are.
Now, do you have parents who attend client meetings?
I do. And it doesn't seem to matter whether my clients are 20 or 40. I have many cases where a mom or a dad or sister or somebody comes to almost every meeting I have, including mediations, and they're heavily involved in the divorce of their sibling or their child, regardless of age. It's just something, families tend to be enmeshed in their other families' divorces. They do. I usually let them come to mediation because sometimes it's important to hear how the mediation is going so that they don't try to armchair quarterback it after the mediation.
Understood. Now, you indicated that you typically have to go to court for relocation. How difficult is it to get court approval for relocation?
Well, I always tell my clients in Leon County that even though, according to the statute, there's no presumption that someone should be able to leave or not leave, I do think that there's a presumption against relocation. And I always tell my clients that it's a very hard thing to obtain a relocation. That you have to have kind of special circumstances, and there's a whole laundry list of statutory criteria that you have to meet to try to be able to relocate. And so we sit down and we go through the statutory criteria and determine whether or not you'll be able to do it. Most of the time, I tell them it's a 50-50 shot at best. Sometimes a little bit more, sometimes less.
Did you have that conversation with Wendi Adelson while you were representing her?
I did.
Okay. And did you advise her of that same information?
I did. Basically, I told her that if this is something that was important to her, this was her one shot at it. If you get divorced and then try to relocate afterwards, you're probably not going to win unless something really substantial comes up and changes it. So if she wanted to try to be able to relocate, this was her shot at it at best.
So in other words, is it not that it's easy, but is it easier to try to obtain relocation in the initial proceeding or in a modification?
In an initial proceeding.
Okay. Now, the standard for a modification, what is that?
Standard for a modification is a substantial change in circumstance. And at the time that I had Wendi's case, there was also another component which no longer exists. But at the time that I had Wendi's case, you had to prove there was a substantial change in circumstances, that it was in the best interest of the child for a modification, and that it was detrimental to the child not to modify. That detriment part does no longer exist. Now you have to just prove there's been a substantial change in circumstance and that it's in the best interest of the children. But at that point, you would have had to prove that it was detrimental in some way to the children to modify.
Is that why you advised Miss Wendi Adelson if she wanted to try relocation, she should do it at the front end?
Yes. Proving detriment is hard to describe to clients because they don't understand how substantial that really has to be. It has to be very substantial. Children are failing in school, children are potentially being neglected or abused, or there's alcohol or drug or mental illness.
Okay. Have you ever been successful in convincing a judge to grant relocation?
I personally have only won one case in 37 years for relocation.
So, would you say it's difficult?
I think it's difficult.
Okay. Now, even though you've only gotten court approval for one with the client, have you been able to successfully negotiate for relocation in other cases?
I have been able to negotiate relocation in other cases, sometimes through help of mental health professionals who will interview the parties and the children and make recommendations. Sometimes we'll have a guardian ad litem appointed to make a recommendation. We'll have a parenting evaluation or something like that makes a recommendation. And if you have those things behind you, then it does help, because most people don't want to go to a judge if you have a mental health professional that says, oh yeah, relocation would be great. So we have been able to do it in that way. I also have been able to have relocations when you have an older child who really wants to relocate and the other parent doesn't object, or sometimes you have, like in my sister's case, which I actually shouldn't have, but I did represent my sister. She moved to Atlanta, and then her husband was able to obtain a job in Atlanta and move up there to her former husband. So we negotiated all those things.
And I think you said you explained all of this to Wendi.
I did.
Was she aware that the chances of success were low?
Yes, I mean, I told her that this was her shot. I thought she had some good reasons. I would never have someone file a relocation if I didn't think they had a shot at it. So I think she did have a shot at it for many reasons, but including the fact that her parents were down there, that Professor Markel had a very flexible job. He had family in South Florida. These were very little children at the time. We did not have the presumption of 50-50 parenting, and she had done most of the parenting. There were lots of reasons I felt like she had a really pretty good shot at it. But I did tell her it's not going to be easy.
Okay. Now, let's talk about family law rules of procedure generally. Do the rules require the exchange of certain materials in dissolution proceedings?
Yes.
And what are those?
We have mandatory disclosure in divorce and modification proceedings, including custody and just regular divorce. And pursuant to the Florida Supreme Court rules and 12.540, we have to file a financial affidavit under oath that the parties and lawyers and their paralegals help them fill out. We also have to provide a laundry list of documents that keeps getting larger. It's bank statements for 3 years, it's retirement statements, it's deeds, it is credit reports. I mean, it's a very large, voluminous amount of documentation that we have to exchange with the other party, the other counsel.
And when completing the financial affidavits, specifically when you completed Miss Adelson's family law financial affidavit, did you gather records in the process of completing that so you could disclose everything appropriately?
We did. We gathered all those records and we exchanged them. And gave them to opposing counsel. Sometimes what does happen is the other side has all the records. For example, tax returns, we have to exchange tax returns for 3 years. Sometimes the father or the husband might have all the tax returns, the wife might have all the tax returns, so you do rely sometimes for the other side to provide the documents that you should have. But
Now,
that does happen.
Do you have to list all assets on the financial affidavit?
Within reason, you do have to list your substantial assets. Sometimes I have people that want to list minutia assets, de minimis assets. We don't really do that. We try to keep it as global as possible. We don't list everybody's clothing but we list all the cars, generally speaking. But financial affidavits are also a work in progress. We can amend them. And that is part of what happens when you go through a dissolution. Sometimes more documents come to light. A lot of times when people are getting divorced, they're not always in their best mind, and they're not always working as well as you'd want them to, so it takes a lot of help to get a lot of these documents sometimes. So we amend financial affidavits, and I always tell them, don't worry, we'll amend before we go to court. If we have more documents that come up or we find out more information, or you change jobs, we have to do that.
What about non-marital assets?
We generally list non-marital assets as separate if we have knowledge of them. Non-marital assets can be very clean, where you absolutely know something's non-marital, or they may not be, because what people don't always understand, it's an education process as you're educating your client as they're going through divorce. Simply because it's in your name alone does not mean it's non-marital. So it can be in your name alone and still be marital if you have obtained it during the marriage. However, sometimes it can be both, and we have to separate things out. I know with Wendy's case, that was one of the things that happened, is she had an asset that was potentially marital and non-marital because she owned some of it before the marriage, and then she had some of it after, she contributed some of it after the marriage. So it's hard to determine how much initially, and we sometimes have to hire expert witnesses, financial witnesses, to come and help us determine what part of this is non-marital and what part is marital. For example, if you have a retirement account and you've contributed to that retirement account before the marriage, everything you contributed before the marriage is yours. It's not marital. And whatever increase in value due to the market is also non-marital. So if you have $100,000 in a retirement account, you get married, that $100,000 theoretically, except for 2009, that $100,000 continues to grow, so you're entitled to the growth on it too as non-marital. So that's why sometimes it gets very complicated and we can't determine it initially when doing a financial affidavit, but we do try to determine it by the time we get to court, at least.
Okay. Now, I want to back up a little bit. What happened with Wendi Adelson's relocation?
She did not win her relocation.
Can you tell us what happened at that hearing?
So we had a hearing on the relocation. We put on Wendi Adelson, and she testified about the reasons that she wanted to move. She did have a job offer in Miami. We put on the lawyer from the law firm that had offered her the job. He testified about what the job would be, how much more money she would be making, and the flexible hours, et cetera, et cetera. We put on all of that, and then at the end of our testimony, the judge asked to speak to counsel, which happens a lot, and she took counsel out. It was me and Professor Markel's lawyer, and she told us she understood why Ms. Adelson wanted to move. But she wasn't going to allow it because she didn't think she had met her burden of proving it was in the best interest of the children.
During that hearing, or after the judge made those comments, did Wendi go out in the hallway to speak to her parents?
Well, after she made those comments, I went to both Mr. Duggar and I went to our respective clients. We told our respective clients what the judge had said. And basically, if the judge had already determined this without hearing from Professor Markel, we didn't really have a chance of winning this at all because she'd already heard the best case of our case. So I talked to Wendi about that, and then Wendy's parents were there, and I actually spoke to Wendi and her parents, and then she went and spoke to her parents again, I think, if I can remember. It was a long time ago, but I think she spoke to her parents outside of my presence as well.
Did Wendi ultimately stipulate to the withdrawal or the denial of that petition with prejudice?
So what happened at that point was we went back into court. The judge denied Professor Markel's motion to dismiss because he had filed a motion to dismiss our pleading. She found our pleading to be sufficient, so she entered an order denying his motion to dismiss. She entered an order that we stipulated on the records that we would agree to the denial of the relocation. And then she entered another order where we all stood there and worked through with the judge what the temporary visitation would be for the next summer and the next several months before we got to another agreement.
And at this point in time, I believe it was approximately the third week of June of 2013?
Yes.
Okay. And what was Wendy's reaction?
At that point in time, I think she was upset that she wasn't going to be. I mean, nobody wants to not win their case. She was upset. She was always calm during all of my meetings with her. She understood. She's a lawyer. She understood what I was telling her in terms of the legal ramifications. I think she was resigned to it. We did speak a few times after that because we had to get geared up for the next round of this. We had already gone to mediation before that, and we had not been able to agree at the mediation on the relocation. So we knew we had to go to another mediation. So I talked to her several times about the next mediation, which would be dealing with all the other parenting issues and the financial issues. So I did talk to her quite a bit after that, and she seemed resigned to it.
Now, although the court denied the petition, would it have been possible for Wendi Adelson to offer Mr. Markel any financial incentive in order to convince him to change his mind?
Well, we hadn't finished the case. We still were going to go to another mediation. It's always possible. I tell everyone that even after an unsuccessful mediation, people settle their cases on the eve of trial all the time in some way or another. They do. And it's always best if you can settle your case and not leave it to a court. You have much more control if you are the decision makers rather than the court.
Is there anything improper or illegal with one party offering a financial incentive to the other party to obtain relocation?
No, and I actually have negotiated that in the past,
Now,
and since that time as well.
Subsequent to that hearing, did you have another mediation on the dissolution, the distribution of assets, and the parenting time?
We did, and at that mediation, we came very close to settling it, and we were there for quite a long period of time, but we did not settle it at the mediation. I think we settled it within a week after the mediation, where opposing counsel and I exchanged a lot of phone calls and because we had gotten very, very close at mediation, and we were able to resolve all of it within a week of mediation.
Now,
Before we had a court trial set, I believe, and so we were able to do it before the court trial.
Thank you. Prior to adjourning mediation, did an issue come up concerning a potentially non-marital asset that Miss Adelson had?
It did.
And what asset was that?
It was if I remember correctly, it was the Charles Schwab account that we had listed on the financial affidavit in the marital portion, and then on the non-marital portion, we had listed Charles Schwab non-marital portion to be determined. And we went into mediation in that way, not knowing exactly what was marital and what was not marital.
Now, I know in our pretrial discussions you indicated, can you typically talk about what happens at mediation?
Mediation is confidential, and that's one of the things I tell my clients is that the mediator can't be called to testify about what happened in mediation, and I can't testify about what happened in mediation, et cetera, et cetera. So the theory behind that is that people will be as open to negotiation without fear that it's going to come back in court and hurt them in some way in front of a judge. You can't talk about the settlement offers that were made. For example, in mediation, if they say, oh, but he offered to pay child support above and beyond child support, and then we don't reach an agreement, you can't come into court and say, but he made this offer. So it keeps everybody moving forward and not worrying about what the offers are.
Is there an exception for disclosing what happens in mediation if you're ordered to do so by the court?
There is, and there's also an exception about what happens in mediation if the marital settlement agreement is asked to be set aside for some purpose, like fraud or overreaching or something like that, then the terms of it and the mediation would potentially be able to pierce that veil of confidentiality.
But for our purposes, in order to talk about what specifically happened concerning that asset in mediation, do you need the court to order that you disclose that information?
I would certainly like the court to order that. I don't want to fall foul of any mediation rules. I can tell you that my client has waived that confidentiality. The mediator, who was a friend and a lovely person, Joe Boyd. He is not with us anymore, and Professor Markel is not with us anymore. So a lot of people in that mediation are gone, and Ms. Adelson has waived confidentiality.
You're beating me to the punch, Ms. Adelson. With the waiver of confidentiality by your client, I will order you to testify on the subject matters being inquired into. The state may cross-examine as to all subjects as well. You may continue.
Thank you very much, Your Honor. Ms. Adamson, can you tell us that Charles Schwab account that you mentioned, how was that addressed at mediation?
So this became sort of a last-minute little dust-up during the mediation. So what we did was we called the Charles Schwab account representative. And this is not uncommon in mediation. And I had Joe Boyd, who was the mediator, come in and talk to the Charles Schwab account representative. So it wasn't just me talking to the representative and telling the other side what had happened. I wanted the mediator to actually do it and to hear it. And so he talked to the Charles Schwab representative, who outlined, in his opinion, what the possessory status of that Charles Schwab account was, who owned it when, where it was, how it had been separated into multiple accounts apparently, and which ones were marital and non-marital. And then he went into the other room. We're not in the same room. We're in Ms. Adelson and I are in one room, and Professor Markel and his lawyer are in another room, and the mediator is going back and forth between the two rooms. So in our room, he listened to what the Charles Schwab representative said, and then he went into the other room and told them what he had said. And after that mediation, Mr. Duggar and I discussed the fact that it actually happened, and everybody felt comfortable with what was marital and non-marital. And that was when, along with other little things about the parenting and other loose ends being tied up, we were able to actually have a marital settlement agreement. The Charles Schwab account, in all its different permutations, was listed in the marital settlement agreement, and Professor Markel had almost $500,000 worth of non-marital Charles Schwab accounts of his own. So he had non-marital money as well.
So based on what you've discussed, Mr. Markel was aware of the non-marital status of that portion of Wendi Adelson's portion of what she would get.
He was.
And as you said, shortly thereafter, that case was settled.
Within a week, I think, ish.
Shortly after the divorce was final, did Wendi invite you to get her groove back party?
I don't remember when the party was, whether it was a month or 2 or 3, but she did invite me to a party in her new, I think it was an apartment or townhouse. I don't remember what it was exactly, but she invited me to a party. It was called Wendi Gets Her Groove Back, and I had several friends I knew of Wendy's that were there as well, and it was just sort of a Wendy's in a good place, come celebrate my new life party. Yeah, in Tallahassee.
Throughout the course of your representation, could you tell us the total amount of attorney's fees and costs that you incurred in this case?
I think the total amount of costs and attorney's fees, we did take a couple depositions. We had 2 mediations. One was ordered by the court on that relocation case, and then that was a pretty short mediation. It was only a couple hours. The other one was much longer. I think the total attorney's fees were probably about $30,000.
And costs of?
That includes costs and everything, I think.
Okay. Now,
I know that sounds like a lot, but it wasn't that much compared to a lot of litigated cases.
Okay. Now, litigated cases have multiple evidentiary hearings.
Correct.
Did this?
No, we had. I don't don't believe we actually had any evidentiary hearings. The only other hearing that we really did have was post-dissolution.
So aside from the relocation, prior to the divorce being final, there were no contested hearings.
There were no contested hearings.
Now, subsequent, did the marital settlement agreement require that Mr. Markel pay Wendi and yourself certain sums?
So, according to the marital settlement agreement, Professor Markel kept the house. So he was supposed to pay Wendi for her part of the house. And all the other assets were divided equally, so that he kept an equal amount, she kept an equal amount. He was supposed to pay, I think it was about $120,000 for his part of the house within 60 days. He had the money because he had more than $500,000 in non-marital assets, and he had also marital assets as well. He was supposed to pay me $10,000 in attorney's fees because he made a lot more money than Wendi did, and it's based upon, attorney's fees is based upon who has more resources, and he had considerably more resources than Wendi did. So that was part of the agreement. He was supposed to pay me $10,000, he was supposed to pay her $120,000, all within 60 days of the agreement, which was July, sometime 2013.
July 31st?
I think that's right.
Did Mr. Markel pay the sums that he was obligated to pay under the settlement agreement?
He was supposed to transfer, if I remember, from one of his Charles Schwab accounts to Wendi, the money. He gave her $50,000 of the $120 in a pretty timely basis, and then he just didn't pay the rest. And I don't like to file enforcement hearings on things like that because it takes a long time to get to court. It's not fun. It's just kind of, so I was pretty much once a week or once every other week asking opposing counsel if Professor Markel was going to pay.
Did he pay?
He did not.
What did Wendi ask you to do to enforce that?
At some point, I wrote a letter, I believe, to opposing counsel. So this was, first it's a bunch of emails and phone calls, and then it's a letter saying, please pay, so we don't have to file an enforcement. A part of our marital settlement agreement, if we have to file an enforcement and we win, which we would have because he had to pay, then he would also have to pay additional attorney's fees for doing that. So then it just becomes more and more money that he's owes and he's not paying theoretically. So, and this was all on property issues. So unlike custody, we're not going to be able to, or child support, we can't put him in court or in jail. We're not going to be able to put him in jail or anything like that. We're only going to have to be able to go after his assets and things of that nature. It's a lot easier if people will just pay. So I finally filed a motion for enforcement saying he'd only paid $50,000. He owed the other money, and he owed me money, and I asked for a court hearing on all of that.
Okay. Sounds like it was pretty straightforward motion that you filed.
It was pretty straightforward. It was probably 4 or 5 paragraphs.
Okay. Did that prompt Mr. Markel to pay?
No, I did not.
What happened?
So then Mr. Markel hired a new lawyer. And his new lawyer filed a responsive pleading to that my motion, basically saying that he shouldn't have to pay because Ms. Adelson had breached the marital settlement agreement.
How did he allege that she breached the settlement agreement?
He filed multiple motions, but this first responses and motions, this first one, basically, if I remember correctly, was all about the money. and he said that he shouldn't have to pay because she had hidden the Charles Schwab money from him, and he used to have power of attorney, so he knew that she hid the money, which doesn't make sense, because if he had power of attorney, he would know what the money was. So it didn't make sense to me. But anyway, that she had hidden that money, and that she hadn't told him about several other of her retirement accounts, and therefore the marital settlement agreement was breached, and he shouldn't have to pay her the money.
So he filed a response, but did he seek to have the settlement agreement itself voided or set aside?
He did not. So, and that is what I told Wendi at the time, is that is not a proper defense for not paying the money. Professor Markel, it was pretty obvious that he had actually written this pleading himself, and the lawyer just signed off on it. It had footnotes, which is not something litigation lawyers would do. It was voluminous, and it was very personal about what was going on in Wendi and how I don't think at this point he alleged that he might have alleged that she had committed fraud. But an appropriate pleading would have been for him to file a 12.540. I know it's kind of technical, but basically if you think that an agreement is reached and it is not in good faith, or there's assets that were not provided, then you must file within a year for a 12.540 to have the whole agreement set aside. You can't just say one good breach is another. And I filed a pleading basically saying that his motion should be dismissed because it was inappropriate. And
you filed a motion to strike as a sham pleading?
I did. I filed a motion saying this was an inappropriate pleading and it should be dismissed because it was. It wasn't the correct way to go about doing what he wanted to do. And so I then tried to set hearings on those motions so that we could move this forward and everybody could get paid.
Now, in the process of doing this with his responses, did he file subsequently a pleading that further alleged fraud on Wendi's part?
I think he filed at least one or two more pleadings that did that.
And before we get to the final one, you advised Ms. Adelson along the way of what you just told us about the unlikelihood of his success.
I did not think he was going to be successful in his response because it was an inappropriate pleading and it should have been dismissed, which I believe it would have been dismissed. And you can't say, I'm not going to pay you because you breached this agreement by not giving me documents. That just, first of all, there's a lot of case law that says that if a case is heavily involved with mediations and lawyers and all these documents have been produced, you had your shot at it. So he was not going to be able to do that. Plus, I knew that he knew about these assets because we had that conversation at mediation, and I had several conversations with his lawyer afterwards, and the marital settlement agreement listed all these assets that he was claiming he had no knowledge of, and they were already listed on the marital settlement agreement. So it was not, in my opinion, a successful response, and I told Wendi that it wasn't, and not to worry about it.
Now, there was a hearing in February of 2014. I think the records indicate that that Mr. Markel and his attorney were attempting to depose Ms. Adelson. So
what happened was I wanted to take his deposition so I could find out why he wasn't paying. And their response was to want to take her deposition, which I did not believe was appropriate because we were simply trying to enforce a marital settlement agreement, and there's nothing that would happen in terms of that marital settlement agreement that would require him to ask her any questions. So I did file a motion to protective order so that he would not take her deposition. We went to court on that issue in front of the same judge.
And what happened at that hearing?
At that hearing, which we did not have transcribed, which we usually do, but we didn't because it was pretty much a 15-minute hearing, the judge read all of the pleadings, and she said that she was very unhappy with Professor Markel's pleadings. She did not like them. She thought they were a poke in my client's eye, and they were not appropriate, and she never wanted to see pleadings like this in front of her again, but she was going to allow the deposition.
With some limits?
With limits, yes.
Okay.
I don't remember exactly all the limits, but they could only be about certain things.
Now, subsequent to that, did Mr. Markel file an additional pleading concerning complaints that he had about right of first refusal, parenting time, and things of that nature?
So that's the first time, and this is actually almost a year after the divorce, and we're done with the whole divorce. That's the first time that he brought up any parenting issues. And it was a series of issues that he had now about the parenting, and it was that Wendi wasn't allowing him to FaceTime with his children as much as he wanted to, that they weren't allowed to go to be present at the same birthday parties, that if there was a birthday party that he was at, she wouldn't come, things like that. And that she wasn't, I think there was a right of first refusal in it, and that she was letting her mom watch the kids, and he didn't like her mom watching the kids, and I think he alleged that her mom was saying bad things to the kids, potentially about him. I think that was the first time. He also, I think it was that pleading where he went on a little bit more about Wendi and how she should probably be disbarred from the practice of law, and that I should be disbarred from the practice of law. I think it was that one.
As he's filing these things, are you still trying to set a hearing, or set the depositions and set hearing on your enforcement motion?
I've still been trying to do that. There were a number of hearings that got canceled. Some of them I think were because of the court needed to move things. Some of them were because I was trying to work this out still. I'm always trying to work out a case and not go to court if I can. So we were trying to work it out, but he wasn't paying, and I was trying to set hearings on all of this so we could get the money and we could get his motions dismissed because they were frivolous.
Okay. Now, the one motion concerning my client, Mrs. Adelson, he referenced parental alienation. Have you dealt with parental alienation in your practice before?
I have.
And what is that?
Well, it's not actually a recognized legal term, and it's not actually a recognized mental health term by the mental health professionals, but it does happen. I mean, we all know that there are parents who do alienate their children against their spouse by saying really terrible things or trying to put up roadblocks to parentings. And I've had cases that were pretty serious in the past where little children, it doesn't usually impact teenagers. By the time they're teenagers, they've already they want to do their teenage thing. It really truly impacts not children this young either. It's usually like 7 to 9-year-olds that we deal with when we have parental alienation, where they become completely aligned with one parent inappropriately, and not because the other parent is doing something like abusing them or something like that. It's because the other parent truly is putting up these roadblocks. They do use those terms. I've seen it.
Okay. The statements that were included in the March 26, 2014 pleading filed by Mr. Markel that were attributed to my client, would that have resulted in any sort of relief preventing my client from having any sort of unsupervised time with the grandchildren?
No. That's not possible. And I told Wendi that.
Okay. Now, as Professor Markel continued filing things, did you realize that you were going to have to become a witness?
So I can't remember how many pleadings he filed on that regard. It may have been 3. And it was the last one that he filed. I believe it was in May, I believe, where he said that where he became very personal to me, which occasionally happens. It doesn't usually happen with professional people, so I was surprised. But he became very personal towards me and said that I had committed fraud and that I should be disbarred based upon what had happened. At that point in time, I knew that I was going to actually have to be a witness now in this case. And as a witness, you can't be a witness and a lawyer representing your client. So I knew that I had to withdraw. So I withdrew so that I could testify in the case that was going to come up. And I sought a new counsel for Ms. Adelson at that point.
Did that result in the hearing that had, now, let me back up. Had you been able, prior to withdrawing, to schedule the hearing on your enforcement motion as well as Mr. Markel's motions?
I had it scheduled. It was scheduled, but then I had to withdraw because he filed that pleading after it was scheduled. So I had to withdraw, and I called Jimmy Jenkins and asked him if he could please represent Ms. Adelson. He said yes, but he needed more time to get up to speed on that case, so the hearing had to be moved.
Okay. And around this time, were you aware that Mr. Markel had to change counsel again as well?
I did not know that.
Okay. Were you aware that as Mr. Markel is filing these pleadings, including the one in March, that he continued to ask my client to watch the children during his time sharing?
I don't know what they were. I don't know anything about their correspondence. I really only dealt with Wendi.
And on that note, we discussed earlier that it's not unusual for parents or family to be involved in meetings. Was my client, Donna Adelson, involved in any of the meetings that you had with Wendi Adelson during her initial dissolution proceeding or any of the enforcement proceedings after the fact?
She was not involved in any. I never spoke to her except for the one hearing on relocation that she and her husband came to. But even then, it was very brief. They were very nice, lovely people. I didn't, even after even afterwards, they were fine. I had no issues with them, but I never spoke to them. I never emailed with them. They never came to any meetings. They were not involved with me.
Okay. And do you have a recollection of whether my client and her husband were in the courtroom for the relocation hearing, or were they out in the hallway?
I believe they were in the hallway. I don't believe they came in.
Okay, just a moment, Your Honor. Nothing further this time?
Cross-examination.
Morning.
Good morning.
So you said you weren't aware of Donna Adelson's involvement.
She was not involved with me.
Okay.
So no.
Did you know that she was drafting Wendi's filings and having Wendi copy and paste them to send to you?
She couldn't have drafted any of the filings because I drafted the filings.
What she would like to be put in the filings, how about that?
I'm not aware of any of that, no.
Okay. Do you know that she was drafting things for Wendi to put in her filings in Wendi's voice?
Not that I'm aware of.
Okay. Did Wendi, though, give you input on things maybe to put in filings or things that she would like said on her behalf?
Not a lot. I talked to Wendi on a pretty regular basis when I was filing something on the phone or by email. And she was a very good client. in all honesty, where she listened to me and she basically, we have clients that don't. Now we have clients that give you ChatGPT and want you to do ChatGPT pleadings, so there's that. She wasn't that client. She would say something like, well, and my pleadings were very short. I mean, my pleadings were very, very short. They were to the point and like, no, dismiss this, that's not true. There wasn't a lot more going on in most of them.
So you wouldn't have knowledge of Wendi sending pleadings to her mom and saying, let's edit this?
No, because I wouldn't have edited it based on that anyway.
Okay.
I mean, maybe they did, but I didn't do it.
All right.
And I never heard about it.
Okay. So this would have been between Donna and Wendi?
If that happened, yeah.
You mentioned that, of course, she had a shot with relocation, but given the situation in this case being that the kids were raised in Tallahassee, the parents' jobs with FSU, you were not personally surprised when the relocation was denied?
I'm never surprised when a relocation is denied.
Because it's hard to prove detriment at that time.
I'm always hopeful, but
Right.
and I thought she had a good shot, or I wouldn't have let her do it. I mean, I'm not going to file a frivolous motion, and I thought she had a good shot for a number of reasons.
Regardless, though, of what you think, do you ever have clients or family members of clients who have unrealistic expectations of what the courts will allow or what you can do for them?
Yes.
Okay, even given your best guidance?
Yes.
Okay. That's not an uncommon thing.
No, that's why parents are often involved in these cases and come to talk to me about what they think I should be doing. Yes, I get that a lot.
Right, and at that relocation hearing, were Donna and Harvey Adelson possible witnesses?
I've been trying to think about that. I think that that's probably why I had them sit outside, is because they could potentially be witnesses in invoking the rule. However, I think we had come to either the close of our case.
But you wouldn't know that until you were done calling witnesses.
Correct. So that's right. Yeah.
Okay. So that's why they were in the hallway.
That's why they were in the hallway. Yeah.
Okay. Not because they didn't care or they weren't involved.
Oh no, they were very nice. I mean, I met them. They were there when I got there in the morning. They introduced themselves. They were very nice. We did our thing. I came back and told them afterwards. Nobody yelled or screamed or cried or did any carrying on, which sometimes happens. So no, it was all very appropriate.
Okay. Do you sometimes have clients or family members of clients who take the news harder than you do when they lose something in court?
Well, I don't like to lose either, so there's that. I don't like it. That's why I don't like to go to court if I think I'm going to lose. That's why I want to settle things. But sometimes they take it really hard, especially family if they're not there. They do.
Okay. And you said Wendi was upset when she was denied the relocation, but she was calm. Oh, let me also ask you this. Wendi Adelson stipulated to the denial of the relocation after you found out behind the scenes from the judge that it was going to be denied.
Correct.
Okay. And she was upset about it, but calm.
Yes.
She's not screaming.
No.
No, okay.
And I have people do that. I mean, I've had to have my own clients taken by the bailiff out.
I'm sure you've seen it all. And how did Donna Adelson feel about not winning the relocation?
I don't know how she felt. I can only tell you that I came out, I talked to Wendi, and then briefly, as far as I remember, because I mean it was 13 years ago, I think I talked to all of them and kind of told them what happened, what was going on. And, I didn't agree with the judge, but this is the judge, and they get to make the decisions. And I think that Wendi went and talked to her parents without me, and then came back and said, okay, we're good. We can go into court, and we can stipulate.
Okay.
Which is what I had suggested.
So if there are emails of Donna Adelson being upset about and very disappointed and about it being denied or unhappy with your representation for some reason, that's not something she's telling you to your face?
No.
Okay. You talked about Dan Markel not paying what he was supposed to pay according to the settlement agreement. In Dan Markel's court filings, did he give, and I know you don't agree with those reasons, but did he give his reasons for not paying?
He gave his reasons.
Okay.
Yes.
And that included the fact that he was accusing Wendi of noncompliance.
That's true.
Okay. Eventually, did you seek to have Dan Markel held in contempt of court?
I did. It was part of my motion was to have him held in contempt of court and enforced it. That's not the kind of contempt where I can throw him in jail.
Yeah, what does that mean, contempt of court? Can you explain that?
So in a child support hearing or an alimony support hearing, if someone doesn't pay their child support or their alimony, we can have someone held in contempt of court and put in jail if we can prove they had the ability to pay, but they're just not paying, and then the court can put them in jail until they pay the amount they're supposed to pay, okay, because they have it. If it's a property issue, we can't really have them held in contempt of court because it's a property issue, and that was part of why Dan's pleadings didn't make a lot of sense, because he was mixing up property and child issues, and you can't do that. It's strictly property or it's kid issues. In a property issue, it would be a multi-step thing to have him held in contempt of court. He would basically, the judge would have to find that he was not paying, he's willfully not paying, and then...
Could I ask you a different question?
Okay.
I'm sorry.
But even in a property situation, the court could put him in jail ultimately, but it would be multiple steps I would have to go through. It wouldn't be just one step, and it would be difficult.
What ultimately is the consequence of that, is my question.
So ultimately, the ultimate consequence is we would probably get a final judgment against him for the amount that was owed.
Like a lien.
And a lien against, and we would get a lien against the house, and we would, and then I have to do this often, I would send them to a debt collector attorney who would then have to file another suit to be able to collect that money, and then they would probably be able to go into his assets and get the assets. So it's a multiple stage process, which is why I just wanted him to pay the money and not make me do this.
So if it was successful, probably a lien. Worst case scenario, he could go to jail. And then him being an attorney, though, could he lose his bar license, possibly? If he's held in contempt of court? Or at least be in trouble with the bar?
He could. I've had lawyers held in contempt of court over these issues before. I haven't had one lose their license yet.
Okay.
But they could. It is a possibility.
Did you inform Wendi Adelson that you were seeking to have him held in contempt?
Yeah, I'm pretty sure I probably did, because it's kind of a generalized form. It's a motion for contempt and enforcement.
Okay. And then at some point, did he allege that Wendi Adelson should be held in contempt?
I don't know if contempt, I can't remember if he actually said she should be held in contempt. Legally, the way that I was using it, I think his pleadings were much more, Wendi should be disbarred.
Okay.
I mean, that's what he specifically said.
Right.
That she was committing fraud and she should be disbarred.
Would you describe this divorce as contentious?
I wouldn't describe the divorce as particularly contentious at all compared to most of the divorces I had. I mean, we settled it. I don't settle a lot of my cases where we actually go to week-long trials over things of that nature. I think it was like any divorce where there were ups and downs of moments where it was contentious and not fun. But for the most part, we kind of settled it. We settled it after mediation, and it wasn't a problem. I do think that this whole issue of the enforcement got a little contentious. I really didn't understand it because he paid the first $50,000 fine, and then all of a sudden he decided not to pay the rest, and I didn't really get it and know why he was doing that, because the parenting stuff didn't come up for like several months afterwards. So none of what he was doing made sense. I think he just got upset with Wendi or something. I don't know what it was.
Okay, thank you for that information. It wasn't contentious, but you did say that his motions were very personal. His pleadings were very personal.
That's where I think it became contentious, is when he did that.
Was that personal attacks on both Wendi Adelson and you?
Correct.
And he was alleging that Wendi Adelson committed fraud, right?
Yes.
He's alleging you committed fraud.
I did.
It got so bad that you had to get off the case so that you could be a witness on Wendi Adelson's behalf, right?
Correct. That's happened before, though. I mean, I've had that happen before.
And he alleged Wendi should be disbarred, you said.
Correct.
And he's having issues with Wendi's mom, Donna Adelson, even being able to watch the kids, is what you said in one pleading.
One of the pleadings said something about the right of first refusal that he had, and she shouldn't be allowed to have the kids unsupervised, I think, during right of first refusal, because she was saying things about him to the kids, he thought.
And did the litigation between Dan Markel and Wendi Adelson continue even after you got off the case?
Once I got off the case, it was the end of June, and I think that he was gone within a few weeks after that.
So you were supposed to be a witness on Wendi Adelson's behalf, right?
Correct.
Were you ever able to have that hearing?
No.
Why not?
Because I got a call from Jimmy Jenkins when I was in Tampa at something that he was dead. It was pretty shocking.
Does that happen very often in your divorces?
That does not. We've had a few people get murdered, and I've had a few suicides.
Okay.
But it's rare, and I remember all of them.
Right, but not contentious.
Sometimes, I don't know with the suicides, I don't know.
That's all.
Thank you.
Redirect examination.
Briefly, Your Honor. First witness.
You may.
Ms. Adamson, I'm going to approach and show you. I'm sorry. States demonstrative A, I think it's Exhibit 1, page 441 of the demonstrative. And then I'm holding 454. Can you hold that,
Sure.
please?
Okay.
Is that the March 26, 2014 pleading that Mr. Markel filed?
It appears to be.
Can you turn to 454 that I had tabbed?
Yes.
Is that the prayer for relief for that motion?
Yes.
Can you direct your attention to the portion that reflects my client's, Donna Adelson's, time with the children? Does that reflect that Mr. Markel was asking that my client's unsupervised time with the children not interfere with his right of first refusal?
I think you're talking about paragraph 6, where it says, enjoin the former wife from allowing the maternal grandmother to have unsupervised time with the children consistent with the right of first refusal. That was that right of first refusal.
Yes.
And to impose appropriate limitations to safeguard the children from being subjected to disparaging comments about their father.
Ms. Adamson, did you testify that the divorce was not contentious, but some of his pleadings post-divorce were contentious?
I think that's accurate.
Okay. And that his pleadings were personal. He essentially he attacked both Wendi Adelson and yourself.
Correct.
Okay. Is that what caused you to withdraw?
I'm very used to personal attacks. I've had a lot of personal attacks. The only reason, and I'm fine with that, the only reason that I withdrew is because I was going to be a witness, not because I cared what he said about me.
Had Mr. Markel not included in his pleadings these attacks, would that hearing have gone forward in May of 2014?
If he had not included personal attacks against me that I would have had to testify about, then I would have continued with the hearing.
Now, I want to go back to relocation. After the relocation hearing, my client, Donna Adelson, appeared to accept the court's ruling. To you.
As far as I know.
You don't know what she said privately, do you?
I do not.
Concerning Wendi Adelson's involvement in drafting of pleadings, I understood your testimony on cross to be that you'll take input from clients, but ultimately you're the one who is drafting the pleadings.
I take responsibility for my pleadings, and I've never filed a pleading based upon what a client told me I have to do. I will take input because I don't know all the facts. Sometimes I need more facts from them so that I can do it, but I'm ultimately responsible. My name's on those pleadings.
And so you're not going to cut and paste from what a client sends you?
Well, sometimes if they send me really good facts, I'll sort of go, oh, these are good facts, and then I'll take the facts and I'll put them in, but not legal arguments or anything like that, no.
So if you took facts that were provided to you by Wendi Adelson and put those in the factual statements or arguments concerning pleadings or memoranda, the law is still your own writing.
The law is, and I don't really think Wendi, I don't remember that Wendi had much input into any of it, honestly. She wasn't that client. I have clients that are those clients, and she was not that client. I get a lot of chat GBT now, a lot, telling me what I should be filing.
I don't think you're the only one there, ma'am. Had you not withdrawn to be a witness, the motion would have been heard in May of 2014.
May or June, whenever it was set. I don't remember exactly when it was set.
Okay,
whatever the docket says for whenever it was set, yeah.
So if the docket reflects, I think it was May 15th of 2014, the hearing would have gone forward.
Correct.
The judge would have been able to make a decision on all the pending issues.
I believe that's the case.
Nothing further?
Will this witness be recalled?
Just a moment. We'll retain her, but she's free to go about her business.
Thank you.
You may step down. Please call your next witness.
Your Honor, the next witness is Linda Bailey. She could be quite lengthy. I don't know if Your Honor wants to take a brief break. Jurors need one.
Do any of you need to take a break or use the restroom? Please raise your hands. A very equivocal wave, but I'll take it. The bailiff will take you to the jury room. Resume at 10:05. Good morning. You can be seated. Does the witness have anything that she needs to set up?
No, she's testifying based on her review of the file. She does have some notes with her if she can't remember something.
That's fine. All right, please stretch your legs or use the restroom if you need to. And we'll try to start again at 10:05.
Thank you, Your Honor.
All right, so we can go back to the beginning because, whoo boy. So, The defense, it starts out with not accusing the state of anything. So someone from the sheriff's office doesn't want to speak. And he said, Mr. Google. And there is a Mr. Google, Bryce Google. Unbelievable. There's a Bryce Google. He ended up being a deputy. Who knew? Who knew that there's somebody's last name is actually Google? The judge says, well, you can't call witness that hasn't been disclosed yet. The defense says, well, sometime between 12:30 and 5 yesterday, someone from the sheriff's office talked to her, which was his new witness, and convinced her it wasn't in her best interest to speak to the defense. To which the judge said, well, if someone isn't under subpoena, I can't force them to testify. To which the defense said, without the court's assistance, we can't do anything. So then they brought up Mr. Google, so he's a correctional deputy. Well, actually, he's a bailiff. So this person that they wanted to talk to, which was Deputy Franklin, she's a correctional deputy. She was approached by a captain, and Franklin said she received a phone call from Donna's attorneys and they wanted to speak to her. This was yesterday. Deputy Franklin said, if I don't need to talk to them, what do I do? So her captain said, you can speak to them if you choose to do so. So if you don't want to talk to them, they need to get a subpoena. So then the defense says, well, now Deputy Franklin is on leave. and the judge is like, I have no clue. Oh no, he asked Mr. Google, and the Google says, I have no clue about that. Is she available to be served? I don't know about her being on leave. So they wanted to have a correctional deputy testify. They didn't subpoena her, and now she's on leave. What? What? Oh my God. So then the judge asks, are there any other witnesses? Defense says, the info we provided was to be put on record, and after talking with Fulford, we won't pursue that witness given their status and the misinformation we were given. So there's another witness that they were going to have show up, but they were given misinformation. Then the judge told the guard, follow up with the subpoena. Jurors were told 3 weeks. So what's going on for today? Defense says, well, we haven't had a chance to prepare a list, but this morning we're going to have 4 witnesses, and then this afternoon is up in the air. So the judge is going to give an hour and a half lunch break. All right, so then right out of the gates, it was just insanity, right? This trial, every single morning, there is something going on. Every single morning. You're still confused? What's wrong? What's wrong? Before I move on, what are you guys confused about? Before we move on to Miss Adamson, what's the confusion, you guys? Let me see if I can help you out. What's the confusion? Type in, why are you confused? I'll give it a second. Why are you guys confused before? Are we being punked? I don't think so. Golden Girl, they're just dragging it out. Can we Google and see who she is? No, Google was the deputy. Google was the guy that was talking. You're confused too? Okay, what are you guys confused about? JRN, oh, he can't help me. I'm a lost cause. JMS is not confused. The whole subpoena thing. Okay, so Allie, the defense wanted a correctional officer, a correctional deputy to testify today. They called her yesterday. They do not have a subpoena for this deputy. The deputy contacted her superior and said, do I have to testify? Her superior, who is a captain, says, if you don't want to, you don't have to. If you want to, you can, but if you don't want to, they have to get a subpoena. So now the defense is scrambling to get a subpoena. In the meantime, now she's out on leave, right? So they asked for this person to testify. She went to her captain, said, do I have to? He said, if you want to, you can, but if you don't, they have to get a subpoena. They cannot subpoena her now because she's out on leave. So does that help you? Grampy, everything? I hope that helped. You have to have a subpoena. If not subpoena, then you don't have to, right? So she could have said, sure, I'll testify without a subpoena. But she's like, do I have to? And her captain said, no. All right. All right, so we're gonna move forward. Okay, so Kristen Adamson represented Wendi from 2012 to 2014. She would not consider Wendi's case to be a bitter custody battle. She called it run of the mill. It's common to be close to your family after a divorce. She's talking about the relocation. She does allow clients to come to court. How difficult is it to get a court approval for relocation? She says it's very hard. You need special circumstances. She advised Wendi to apply for that at the front end of the divorce. She explained all of this to Wendi. She thought Wendi had a shot at it, including her parents being in Miami. You gather and exchange financial records. Sometimes what happens is the other side has all the records, including tax records. So do you have to list all the assets? She said within reason, not clothing. She said it can be a work in progress. Then they go into non-marital assets, can be both, meaning you have, she gave an example, you could have $100,000 401k or whatever. She said $100,000 in assets. You get married, that is yours and yours alone. That's a non-marital asset, and any kind of interest that's formed from that or comes out of that, that's yours too. But when you're married and you have that time frame, then that's considered both. So Wendi had both. So Wendi, they talk about Wendi's relocation hearing. She did testify. The judge says Wendi didn't meet that burden for relocation. She did say Harvey and Donna were there. The judge denied Dan's motion to dismiss, but then they agreed to the denial of relocation. They worked through a temporary visitation, which would be for the next few months. Wendi was upset, but she was always calm. Let's see. Offering a financial incentive is not improper. Another mediation came close to settling, but settled a week later. Let's see. So Wendi's asset was a Charles Schwab. Then she talks about client-attorney confidentiality. She said Wendi waived the confidentiality. And then she's like, well, two people from this are gone. Dan is one of them. And Joe Boyd, I guess he was the mediator. He's no longer with us. So I was making faces because I didn't appreciate, she was throwing Dan under the bus left and right. It's like, nobody's there to defend Dan. She could literally say anything, and I know she's not because it's ethical and she's a lawyer, but she was still saying some pretty, I thought some pretty nasty things about Dan, and nobody's there to defend Dan. So it's basically, we just heard one side of the story. So let's see. So Dan had almost $500,000 in non-marital assets. Don't forget, Dan's estate was like $2.7 million or something. When he died, his estate was over $2 million, all of which went to Wendi, including like $2,400 for each child. Wendi's getting $4,800 a month for the two children. So, take that for what it is. Then Wendi invited her to Wendi Gets Her Groove Back in Tallahassee. So her fees were $30,000. There were no hearings, she said, just a one relocation hearing. And let's see. So here's where I didn't appreciate all of this. So Dan kept the house, and he was supposed to pay Wendi her half, which was $120,000 within 60 days. All other assets were divided equally. Well, what they failed to say is that when Dan went to New York, Wendi put the divorce papers on the marital bed, took, I suppose, half of the belongings and the kids while Dan was in New York, and then calls him and says, hey, you're divorced. He's in New York City. She's in Tallahassee. They didn't talk about that. I wish they had. So they can, there's some dirty playing going on here. So let's see. So Dan was supposed to pay Miss Adamson $10,000 within 60 days. He was supposed to sell the house, I guess, and then, no, he had $500,000. So she's saying, well, he could have easily paid $120,000 within 60 days. So then Dan did transfer $50,000 quickly, but he didn't pay the rest. He probably didn't pay the rest because he found out that Wendi went into one of their joint accounts and took like half of it, or took all of it or something. I forget. But she was probably saying, I'm sure her side of the story is, well, half of that was mine. I mean, it just gets, the more we dig into this, the more ugly it gets. So let's see. So then Miss Adamson, she did file a motion. Dan didn't pay. So Dan hired a new lawyer. Dan said that Wendi breached the settlement agreement. Maybe that's when Dan found out that Wendi took some money. Maybe that's when it was. I don't remember. Dan filed multiple motions that Wendi had hidden the money. So yeah, I think that's when he found out that she took some money from one of their accounts. Let's see. Oh, I know, Pammy. Too bad it doesn't show the entire time. I know. Remember, for 8 months. We know you've been around longer, Pammy. We know in our hearts. Let's see. So okay. So then they filed protective order. They went to court. It wasn't transcribed because it was only 15 minutes. What is that normal? Does court, just because it's short, they don't transcribe it? I thought even if they go in there and say boo, they have to transcribe that. But maybe I'm wrong. The judge didn't like Dan's motion, said it was a poke in Wendi's eye. Mom was saying potentially bad things to the kids about Dan. Dan wanted Wendi and Miss Adamson to be disbarred. So she knew she was going to become a witness at that point, so she withdrew. So Jimmy Jenkins was the new lawyer, but he needed more time. She wasn't aware that Dan hired a new lawyer. She didn't know about Dan and Donna's communication. Was Donna at the meetings? No, just spoke to her and Harvey that one time. They were in the hallway. She never emailed them, and they weren't involved with her. So then under cross, did you know Donna was drafting filings? She says, well, no, because I was drafting all the filings. Well, how about input? She's like, no, I didn't know about that. Did you know that she was drafting pleadings and motions and filings in Wendi's voice? No, she didn't know about that. Did Wendi give you input? She said, no, not a lot. Were Donna and Harvey potential witnesses? She says, yeah, I think that's why they were in the hallway and not in the court. She didn't know about how Donna felt about losing the relocation. We know how Donna felt about that. We saw the emails. We heard the voice calls. Wendi talked to her parents without her and came back and said, we're good. So Donna's emails were not disclosed to her. Dan gave reasons about not paying. He accused Wendi of noncompliance. She put Dan in contempt of court, but that doesn't mean he was thrown in jail. She says it's a multi-step process, that ultimately you put a lien on the house and a debt collector would get involved. Dan was asking for right of first refusal, and Donna shouldn't have the kids. She was supposed to be a witness for Wendi and never did because Dan was shot. And then redirect. Divorce wasn't contentious, but some of Dan's post pleadings were. She didn't think the divorce was contentious. That's interesting. But they were arguing over a tennis racket. Only reason she withdrew was she would have to testify, and it wasn't because of the personal attacks by Dan or anybody for that matter. She took facts from Wendi and put them into drafts, the law. So she would draft the law. She gets a lot of chat GPT, to which Mr. Zellman said, I don't think you're the only one here, ma'am. Then let's see, May, June 2014, the hearing was set, but Dan was shot in July. So 105 votes. Is this testimony helping or hurting Donna? 28% say helps a bit, but not much. 28% says hurts Donna a bit. 28% said Donna is toast from this, and 14% says helps due to Wendi now is the focus. Wow, we were pretty split. 28, 28, and 28. I don't think we've ever done that before.
For when we advised Ms. Bailey of this information.
Well, if whoever's listening on digital, if you can go ahead and look through the sidebars for Thursday and Friday to determine when the topic of Wendi Bailey as a witness was discussed. As I recall, I believe it was discussed that she would be permitted to be in the courtroom. Whether or not there were any other matters that were discussed along with that, I cannot completely recall at this moment, but we'll review. And at minimum, Ms. Keppelman, exclusion is always the most extreme of remedies, and that is disfavored by Supreme Court and the appellate courts.
I don't know what remedy I could pursue, Judge. That was the only one that comes to mind.
Well,
I'd like them to stop violating the rule of sequestration. That would be the remedy I would seek.
as it related to the witness yesterday, I gave instruction concerning that. Concerning Ms. Bailey, we'll review the sidebar. At a minimum, you may question this witness concerning whether she has in fact tailored her testimony based on being in the courtroom.
Judge, I'm familiar with this witness. I don't think she would do that, but as we know, the rules are in place for a reason.
Oh, absolutely.
Things can happen without us knowing they're happening consciously, so that's why we try to keep these witnesses isolated from each other.
You can let the jurors know I'm going to go to the court reporter's office to check the sidebar. From there, we will finish this matter and resume testimony.
Unbelievable. Just it just keeps this trial. I'm telling you, this trial is just unbelievable. I've never seen a trial like this before. All right, so they come right back into it, and the judge or the defense is saying Miss Bailey has stipulated to something. The judge says he's going to have to look through the transcripts for the sidebars from Thursday and Friday. The judge tells the state, exclusion is going to be your only remedy. Ms. Kappelman says she doesn't know what other remedy I can take, but I would like them to stop violating the rules of sequestration. Judge says, well, you can ask her if she's altered her testimony based on being in the courtroom. So here's a second witness who has been in the courtroom. The state says, well, I know this witness and I don't think she would do that, but, basically you never know. She may alter it just subconsciously. The judge says, well, he's going to have to go back into the chambers to review the sidebars. Unbelievable. Betty, the defense pushing boundaries again. This needs to stop. I agree. The defense is so flippin' messy. Snow Caddish says, Michelle, is the defense trying for a recap? Yeah. I hope you got a retrial. I'm sorry. Defense is... Michelle says, is the defense trying for a mistrial? Lily Wayne, I hope you caught the recap. Which I just said. Allie, I don't think it's fair that they're allowing people to testify after sitting in the room. Clarinet Girl, no, I have never been to a crime con. J.M. Stewie, how is this being allowed? I do not know. Shirley Roth, the defense is outrageous. Red Snap, why do they allow it? I don't know. Sparkling Princess, 35 minutes behind. Hope you can catch up. Snow Caddish, Pammy, exactly. This is definitely a case of ineffectual counsel. Patsy, why isn't there a bailiff outside not letting future witnesses in? There is. That's the problem. And the bailiff knew that guy, Mr. Kelly, Tim Kelly, he's the one that said, yeah, he's been here for like 15 minutes. So he knew. So a bailiff knew that the witness yesterday was in the courtroom for 15 minutes. I don't get it. Sinbad, the defense needs to be sanctioned, full stop. I just don't understand. Paula, I have never seen a trial where witnesses have violated the rule of sequestration. I don't get it. Sherry, eventually this judge is going to flip his lid. I know. JP Rabbit, Crime Con, now on my bucket list. Red Snap, I am stumped. I don't understand why they're doing this. Sinbad, they need a bouncer, not a bailiff. Those bailiffs can be pretty big, though. Psychosaurus, your Crime Con is on your list too. I really want to go this year, but seems it may have to be next year, depending on where it is. Confused and amazed about that too. Ellen is, yep. Stand for the truth, not when the defense attorney was a flippin' judge. Yeah, then there's that. Yeah, Miss Fulford was a judge in Tallahassee, no less. Probably at this courtroom. I would think so. Sally Starr, I missed something. Was this a defense witness? Yes, of course. Everything that goes south in this trial pretty much has been the defense. There's been a few little hiccups here and there with the state, but nothing on this order. Okay. Jaren, name isn't popping up again. All right. If that happens, just do a refresh. Or if you're on your phone, just close the app and then come back in. Or if that's too much, just do 3 Qs, do QQQ or something like that. Because I that's one way that I can see if you have a question. Kathy, I get it. Court keeps them from having to testify. Ellen, no, that what the judge is doing is he's looking at the sidebars from Thursday and Friday because apparently Miss Bailey has agreed to a stipulation of some sort. I don't know what she is. Let me see if I can find. It's always been Sinbad says it's always been the defense, most unprofessional team I've seen. Yes, Everett is checking the transcripts right now. Yeah. Yep, I can see that. I can see that. You went out and came back in and nothing? I don't know. I'm not sure what to tell you. I'll tag you here. All right, so I'm tagging you. See, assuming you can see that. Yeah, you could try to use the symbol. I do see the symbol. That jumps out as well. But JRN, I tagged you there. Now you have it. Okay, good. All right, stipulation. Got it. Yeah, she stipulated to something. All right, let me see. Let me look at, so Linda Bailey. Let me check my witness list here. Bennett, Corbett, Sanford, Magbanawa, Riviera, Mascaro, Maltese, Rodriguez, Hills, Google, Bryce Google, LCSO, Leon County Sheriff's Office. So Bryce Google. This guy's last name is literally Google. That's astounding. So Bryce Google. Bryce was his first name. All right. Expert witness. No. Sarah Newhouse. Nope. Nobody there. No Linda Bailey there. Any Bailey here? Murphy, Adelson, Brotman, Shargren. We're looking for a, what are we looking for? Bailey. Oh, there she is. Linda Bailey. Linda Bailey, Esquire. Expert. She's coming in as an expert. So Linda Bailey. All right, she's a lawyer, so there is a Linda Bailey on the witness list. And thank you, Sherry, for finding the witness list for the state. For the defense. Sherry found the defense witness list. So Linda Bailey, Esquire. She's from Tallahassee. She's coming in as an expert. They have her in parens, expert. So Linda Bailey, Esquire. So just so you know. Kathy says defense lawyers have a difficult job, public scrutiny. Snow Caddish, YouTube has been doing the bad YouTubey things for several weeks. I know. Psychosaurus Rex, I've always wanted someone to say, let's check the tapes, and actually do it. Yes, Sherry. Yes, Sherry is the one that found the defense witness list. Linda Bailey, Esquire. You see the, Sherry, you see the parens, right? She's circled here. Let me pull it up. We can pull it up while the judge reviews. Let's see. Is she in here? Yeah, there she is. She's L. Do you see her L, you guys? Let me blow this up a little bit. So she's L. See Linda Bailey, L. Tallahassee, expert. So she's coming in as an expert. So Linda Bailey is coming in as an expert. I don't know what her deal is, but she's coming in as a. Charlie's on the list. Yep, Charlie's on the list. Charlie's right there. He's S. See him? He's right there at the very end. Care of Ufferman Law. Charles Adelson. He's S. So they have Charles. This is not in alphabetical order. The state had it in alphabetical order. This is not in alphabetical order. So there you go. Let me just pull it down a little bit. All right. Sally, she is an attorney and didn't know better than to be in the court. Yep, they're all shady attorneys on the defense side. Yeah. Let's see, JMS, isn't it the defense responsibility to make sure their witnesses are sequestered? Yeah, well, it's up to a lawyer, and then exactly what Sally just said, right? Sally said, yeah, she's an attorney. Sally just said she's an attorney on top of it. So why would she? I mean, she should know that. Let's see. JP Rabbit, is there a reason why our names are at names and not the other way around? Yes. YouTube has been rolling that out, excuse me, for a couple years now, and we are now the latest channel to have that happen. It's a way you can go into your studio and you can change your handle. You can change that to anything you want. Just like you can change your handle or your channel name. So what YouTube did is they're rolling it out to all the different channels. We are the latest one to have this happen to us. Some channels don't have it, some channels do. So YouTube is doing it to crack down on fraud, because what was happening is you would have 10 people of the same name come in and you thought it was like Recovery Addict. And Recovery Addict would say, hey, come, I'm supporting this great cause, come give me money. And it wasn't Recovery Addict, it was somebody else. So this way it's unique, it's like a fingerprint. So right now there's nobody else in the world on YouTube that is JP Rabbit 12. There may be JP Rabbit 1, JP Rabbit 2, JP Rabbit 3, but before YouTube did this and made it unique like your fingerprint, there could have been 200 JP Rabbits. But now they're making it very unique. So that's one thing, and I think it's great. The other thing is now you can tag people on a mobile device. So you should be able, on our channel, you should be able to go on your phone and just type the @ symbol and then JP, and it should pop up, and you should be able to tag, or at the squeegee and whatever, it should be able to pop up. So you can change it in your studio. If you have the studio app, you should have the studio app. Regardless, you should have that, because you can go in and do all kinds of things. So you can go in there and you can edit your channel name, your handle name. You can edit all kinds of things. Psychosaurus, you still can't tag people on your phone? It was supposed to. I actually haven't been able to try it yet, because it's this channel. I haven't tried it on this channel yet. So not on your iPhone. All right. Well, it's supposed to. Maybe it will be happening. That was one of the things that people have been complaining about that for years, and I agree with them. I think it's silly that you can't tag people on a device. So maybe they're well, do you have Androids? Anybody have an Android? Can you do it on an Android? Everybody's saying on their iPhones. Maybe they haven't, because it's YouTube. Maybe they haven't rolled it out to iPhones yet. Anybody have an Android? Any Androids out there? Won't let you tag? Are you on an iPhone, Kelly? Let's see. Still can't tag people on your Samsung? All right. Finally pop up, yeah. Doesn't work on your Samsung, yeah. Yeah, it's never worked on an iPhone. It's never, ever worked on an iPhone. Never been able to tag on Android, still can't. All right, so I guess they said they want to. They said they want to. That's one of the things that they're doing it for. Joanne says not on an Android. Okay. Android can't tag. Okay. All right. But Android, it does work. Yes, I do. I'm on an Android, and no, you cannot tag. I can tag on my BlackBerry. Just kidding, I have an iPhone. All right. So it's something that they were talking about. So at least for now, they've got the unique signature. So they do have that to cut down on fraud. We were watching a stream, and the guy in the chat worked for YouTube, and he said, we're bringing this so that you can tag people on a mobile. It's been a complaint of mine since years ago, when we first started watching YouTube. We're watching YouTube on TV and we're chatting on our phones, and I can't tag people. It's the most annoying thing ever. So that's why I'd come and I'd sit on my computer and I'd tag people. So it's been a bone of contention for a long time, for sure. So hopefully they'll sort that out, because it's, oh, Sally, so you can. All right. I must be one of the lucky ones. I can tag on your iPhone. All right. So some people can, some people can't. All right. Michelle says, I used to be able to on a Surface Pro, but cannot do it on your iPhone or iPad. Sinbad, I tag on my phone, Android here. All right. So So there you go, guys. Some people are able to do it, some people can't. I don't know if it's the OS, if it's the version of phone, I don't know. The version of the application. I really have no idea. That I don't know. So if you type it out, it tags. Okay. Psychosaurus Rex. It is interesting you can tag people using a full-size keyboard, which is far easier than a little phone keyboard. You think they would have started with the phone. Yeah. Right? Snowcatish. I refuse to be beholden to endless iOS updates by Apple. That almost always ends in a security breach. I know, right? Sherry's asking, what's the secret? Do share. Pammy, I can tag on all things, just have to actually type it all out. It's tiring. So you can't just type in @PAM. See, on my desktop here, I just type in @ symbol P, even just PA. PA, Patsy comes up, Pammy comes up, Paula comes up, and I just choose whichever one I want. Now on my iPhone, let me do a test because I've never really tested it. Let me test on my iPhone. Hold on. Let me test my iPhone here. Let's do a test. Let's see if I can do it. I just updated my OS as well. All right, let's see. And I'm going to do @ symbol. No, not emoji. @ symbol. We'll do PAMM. Nope. Yeah, it's not popping up. I'll just do Pammy MC and see what happens. All right, let's see what happens with that. All right, Pammy, did that tag you? I just typed in Pammy MC. I didn't type in your full thing. Yeah, it won't auto-populate. Just tried to tease iPhone, but it won't auto-populate. Yeah. So it doesn't look like Pammy. It doesn't look like you got tagged. All right, so it's not working on my iPhone either. Oh yeah, I can tag if I type the whole name in. Oh, that's annoying. Yeah. Nope. All right. Yeah. Nope. Squeegee. Yeah. All right. All right. Well, it's something that they have to work on. They definitely have to work on it. Because I think the majority of people are probably on their phones. Well, if they want to chat, they're probably on their phones because if they're watching TV, they want to chat on their phones. I wish that they would sort that out. All right.
So hot from the presses from our very capable court reporters. Has everyone reviewed the transcript at this point?
Yes, Your Honor.
Yes, sir.
Please make your arguments.
Judge, I mean, I think it's clear from the totality of this that I am agreeing for their experts to review the testimony of other experts and that in reference to lay witnesses, experts are not going to listen to the testimony of lay witnesses.
Mr. Zellman.
Judge, on page 62, we specifically said Linda Bailey would like to be able to observe Kristen Adamson's testimony when she testifies, and then I addressed our forensic expert to share the transcript of Sergeant Corbett's testimony. Certainly, I see later where we're discussing as the lay witnesses, page 63, starting lines 11 through 14, as to the lay witnesses, so non-experts, other than Linda Bailey and Kelsey Guy, to be able to observe witnesses. We were not asking for that.
As to both the context and the discussion that is concerned, an adverse expert listening or reviewing or listening to the testimony of the other expert. Ms. Adamson was called as a part of your case in chief. Ms. Bailey is being called in your case in chief. Ms. Adamson was not an expert. The state never agreed to what is being discussed now. Why should this witness be permitted to testify?
Judge, the prior page specifically says that Linda Bailey would like to be able to observe Kristen Adamson's testimony when she testifies.
You brought this up, yes, but the state made no agreement as to anything but an adverse expert as to observation of testimony that would otherwise go to the rule of sequestration.
Judge, with respect to the context and the statements, we were obviously asking that...
It's in black and white. I know what you asked. What happened, though, is the opposite of that. As to that, what is your argument now?
Your Honor, exclusion of a witness is an extreme remedy, as you recognized previously. We took the court's, this conversation to authorize Ms. Bailey to be present during Kristen Adamson's testimony. And that is what we advised the witness when we spoke with her later in the week. But for this conversation, we would not have done that.
This is the second time in this trial where a defense witness has been in the courtroom inappropriately in violation of the rule of sequestration. When this was addressed at sidebar, you brought up the topic, but the state only agreed as it related to your expert reviewing an adverse expert, their expert's testimony. That has not been the case today. Why have you not been more careful with this individual or even brought up this topic to make sure we did not end up in this point and place?
Judge, we thought we adequately addressed it last week during the sidebar.
Ms. Kaplan, what are you asking for?
Seeking exclusion, Your Honor.
As to exclusion, what is your argument?
That this is not the first time this has occurred, that this issue was addressed at sidebar, the ruling was clear, that witnesses, that our experts would be permitted to listen to, and only in that circumstance and that particular exclusion, which we're all familiar with in the rules, the other side's experts. So I'm just a little miffed that here we are. I didn't ask for any exclusion the first time this happened, or really any remedy, but you did admonish the defense to not let it happen again, and now it's happened again. So, you know, does the state get a fair trial too? Do we get a remedy when it's the second time that the rule's been violated? I think it's appropriate. So.
As to your point of the state getting a fair trial, Ms. Kaplan, the court is bound by the rulings of the Supreme Court and the appellate courts. I don't get to make it up on the fly. Clearly, this has happened twice, but moving to exclusion, again, is the most extreme remedy.
Judge, if I may.
Last word.
Reviewing Earhart. Exclusion of the witness. The court may exclude the witness only if it finds that the testimony of the challenged witness was substantially affected by the testimony to be heard, to the extent that his testimony differed from what it would have been had he not heard testimony in violation of this rule.
This is why I believe you wanted Ms. Bailey to listen to Ms. Adamson's testimony in the first place.
I'm sorry?
You wanted Ms. Bailey specifically to listen to Ms. Adamson's testimony for a reason.
Our expert requested it, yes.
As it relates to what you just read in that passage, how the expert's or the witness's testimony somehow would have changed or been affected.
I think the only way to determine that is to speak with Ms. Bailey concerning her testimony.
Ms. Bailey, come to the witness stand so that Crawford can be taken on this matter. And after that, I will step down, briefly review what I need, and make a ruling. Please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth?
I do.
Please be seated. You may inquire for the purposes of the proffer.
Thank you, Your Honor. Good morning, ma'am. Can you please introduce yourself to the court?
Yes, my name is Linda Bailey.
Okay, Ms. Bailey, were you retained as an expert on behalf of the defendant, Donna Adelson, in this case?
I was.
Specifically in what area?
The scope of my requested testimony was to evaluate the divorce docket, pleadings, motions, orders, etc., in the Adelson-Markel divorce, and to opine whether or not the divorce would be exceptionally contentious or unusual within the context of a family law case.
In the course of preparing for your testimony, can you briefly summarize what you reviewed?
Yes, the primary source that I reviewed was the family law pleadings, motions, notices, orders that were provided in a prior litigation in this matter. I think it was an exhibit from the state which detailed all of the pleadings in the family law folder. So that was my primary source. Then other than that, I spoke to Ms. Adamson for about an hour a couple weeks ago just to confirm what I supposed were facts. And I have known Kristen for 40 years. We went to law school together. And I know how she practices. I practice against her often. So I had some ideas about the lack of strength of Mr. Markel's motions, and she agreed. I read her prior testimony in one of the other trials. I think it was Charlie Adelson's trial. I reviewed some exhibits, but they weren't very helpful to me. They were, one of the officers had done some sort of a PowerPoint presentation with faces and arrows and timestamps for communication, and I don't even know why those were provided. I didn't take anything from those. I reviewed.
Did you review some emails?
I reviewed texts and I reviewed emails. So I reviewed emails between Donna Adelson and Wendi Adelson. There were a couple between Donna Adelson and Charlie Adelson that were much later, but they happened to be in the tranche of documents that I had. I reviewed text messages between Wendi Adelson and Dan Markel. I read some text messages between Donna Adelson and Wendi as well.
And in preparing for trial in this case, did you request court authorization to sit in on the testimony of Kristen Adamson?
I did. And
why was that?
Just to confirm that I had the facts correct.
Okay.
And I did. And
you sat this morning through Ms. Adamson's testimony?
I did.
To what extent, if any, is your proposed testimony impacted or affected by the testimony you heard from Ms. Adamson?
It was very consistent with what I believe the facts to be, so it didn't change what my opinion is.
Nothing further for purposes of the proffer?
Mr. Kaplan, an examination for the purpose of the proffer.
You said it was very consistent with what you knew before. Was there anything new that you learned from Ms. Adamson today that you had not learned previously in your preparations?
I think so.
Okay. No, Your Honor.
Please step down, Ms. Bailey. Return in a few minutes.
Well, they just did a proffer. So she was called in to confirm that her opinion was correct, and she says yes, and it was. Well, I guess she knows what she's talking about. So Judge comes back hot from the presses of our court reporter. State says, I think it's clear that I'm agreeing for their expert to review other experts. The defense says, well, Linda would like to observe Kristen's testimony when she testifies. Judge says, Kristen and Linda were being called in your case in chief. Why should this witness be allowed to testify? Defense says, it clearly says Linda would witness the testimony. Judge says, the state made no agreement to adverse witness. The judge says, it's in black and white. What's your argument now? So apparently they had made this argument last week and the states didn't agree to it. So now they're saying, well, she should be allowed to testify. Well, if the state didn't agree to it, then why is she being allowed to testify? Oh, God. Defense says, we advised Linda of this, but for this conversation, we wouldn't do that. Well, that sounds like a you problem. The judge says, this is the second time a witness has violated sequestration. We addressed this, so we wouldn't be at this point now. And then the state says, Ms. Kappelman says, we're asking for an exclusion because the reasons that she's asking for Ms. Bailey to be excluded is this isn't the first time this has occurred. This was already addressed at sidebar. She's a little miffed, but here we are. She didn't ask for any remedy the first time, and does the state get a fair trial too? To which Judge Everett said, the state is getting a fair trial. I'm bound by the state and Supreme Courts. He says, I don't make it up on the fly. So he pushed back a little bit on her. Defense says, if I may, and judge is like, last word, the court may exclude witnesses if the testimony changes significantly. And the judge says, if you wanted Linda to listen to Ms. Adamson, that's the only way to determine is if we need to speak to Linda directly. Ms. Bailey. So they proffer her. She's an expert evaluation of divorce documents. She opines if the divorce was contentious. She reviewed family law pleadings, motions, orders, state exhibits provided to her. She spoke to Ms. Adamson. She's known her for 40 years. They went to law school. She saw a lack of strength in Dan's motions. She read a document from Charlie's trial. There was a PowerPoint from an officer with faces and arrows and communication between, and she didn't know why that was provided and didn't take anything from that. You're an expert in divorce documentation. Why are you throwing an officer's PowerPoint presentation under the bus from a previous trial? That one kind of hit me the wrong way. I didn't appreciate that, but she said it. She reviewed text and emails between Donna and Wendi, between Dan and Wendi. She confirmed the facts were correct, and they were. Her opinion doesn't change after seeing the testimony. Cross, is there anything new that you learned? She says, no, I don't think so. So now the judge is going to be looking at whether or not to include or exclude her. What do you guys think? Let's see, Brett. Brett, if the contention is that her watching the other testimony wouldn't affect her testimony, then why did the defense, 1, ask for her to listen to it, and 2, have her sit in anyway? Makes no sense. Betty says, and to think Donna said the jury needs testimony dumbed down in Charlie's trial. What must she be thinking of the dumb and dumber lawyer she has employed? Sharon, second time the defense has been busted. Well, apparently they're saying they did it specifically because they had a sidebar and they said, hey, judge, last week, Thursday or Friday, they said, hey, we're going to have somebody else sit in the courtroom because they're going to review this person's testimony and then they're going to opine upon it. So she didn't learn anything new from the testimony. So that's ultimately what she's going to say. So. Joe, I really don't think it's intentional ineffectiveness of counsel, but it's pretty darn close. Richard, inclusion rule. Witnesses are generally not allowed to watch the trial before they testify, as the court will often exclude them from the courtroom to prevent them from hearing other witnesses' testimony. CJ says they asked at sidebar. Problem is there was no yes or no from the judge or specifically from the state. The state didn't agree to it. They shouldn't get special treatment for their incompetence. The state Yeah, the state did not agree to it. And the judge, I guess, didn't make a ruling. The judge didn't make a ruling, so the defense is saying, hey, we talked about it. We talked about it. That's on you guys. If you didn't make a ruling or you didn't say anything, that's on you. That's what the defense is saying. We talked about it. It's not our fault that you guys didn't make a ruling on it or say anything. Yes, Shay, the jury no, they're not. I'm sorry. They're not in the room. That was outside the presence of the jury. Except for experts, correct? I'm not quite sure that they're not allowed to watch testimony. I'm not quite sure, Michelle. Grampy, it seems like money is interfering with this trial. Donna, can you pay all you want? Donna, you can pay all you want, but you can't pay your way out of prison. Yeah. There was no ruling. That's the point. Yeah. That's what they're saying. The defense is saying, hey, the state didn't say no or yes to this, so there was no ruling. And, Sally, can the defense attorneys be sanctioned by the bar? They can be, but it has to hit really high levels. It has to hit really high levels. I don't think they've hit that level yet. I mean, I'm not a lawyer, but I don't think they've done anything that would get them disbarred. Sarcosaurus Rex says, experts are not exempt from the rule unless given express permission. Ossie Gardner, I am back. I'm having a terrible time with your networking computer. If I fall out again, just know it's your computer. Aw, no worries. No worries. Sparkling Princess, so we just do what we want? I don't think so. Sherry, I think any expert is allowed, but only if there is a ruling can be allowed in the courtroom. Listen to another expert. I would think so. I would think there should have been a ruling. In my opinion, there should have been a ruling. That way we wouldn't be where we are right now. Even though Judge Everett just said it's in black and white. He said it's literally there. He literally said it's there in black and white. And yet here we are now. So maybe he gave a ruling, but it was kind of, wasn't wishy-washy maybe. Well, he sanctioned them for the first time around. He did sanction them for that. He sanctioned them for having Mr. Kelly, Tim Kelly, who was a realtor. He did sanction the defense for that, but I guess he did not make a ruling specifically on this. CJ says, defense didn't do anything wrong here. You have to follow the rules. Well, apparently the state, according to the defense, the state didn't say anything, and the judge, I guess, did not, even though he said it's there in black and white. He says it's in black and white. The state made no agreement to adverse witness. That was the judge saying that. And the judge also said it's in black and white. What's your argument now? So judge must have said something. I missed exactly what he said about it being in black and white. All I have down is it's in black and white. What's your argument now? Snowcatish, I thought experts were excluded from sequestration rule. I don't know the answer to that. Let's look it up. Are experts excluded from sequestration? Let's see what comes back. No, experts are not automatically excluded from the sequestration rule in Florida. However, they may fall under the exception for a person whose presence is essential to the presentation of the party's cause. The court has discretion to determine if a witness's presence is essential, and the party requesting the expert's exemption has the burden to demonstrate why their presence is necessary to effectively present the case. So in Florida, rule of sequestration was codified as part of Florida Evidence Code 1990. A party may request, or the court on its own may order, witnesses excluded from a proceeding that they cannot hear the testimony of other witnesses. Can an expert be sequestered? There is no exception that applies to experts such that an expert witness would not be sequestered. All right, the rule allows the court to exclude any witness so as not to hear blah, 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 blah. So I guess they can be allowed. They're not automatically excluded. Seems kind of amorphous. That's why we have rulings. Sure Life says, but I think the state did stipulate that she qualified as an expert. Is that the stipulation that they were talking about earlier? That could have been. That could have been when we came in. I missed the first part. All I heard was we have a stipulation with the next witness. So maybe that's what they were talking about. Shay, I know. Shay Marte. It is quite the show. Snowcatish, I'm thinking the same. That's what, yeah, when they first came back and the audio was just came back in, we didn't hear the full thing. I think that they stipulated to her being an expert. So why was she in the courtroom then? I don't know. Stipulation is the word of the day, JRN says. I'm exhausted. It's only 11 o'clock. I'm exhausted. And don't forget, we have an hour and a half lunch, the judge said. There's an hour and a half lunch because the defense needed something. Why did they need an hour and a half lunch? Okay, so he hasn't, of course, Mr. Zellman hasn't had a chance to prepare a list, but he's got 4 witnesses this morning. He's only gone through 1 so far. He has 3 more to get through. He said the afternoon is up in the air, so he's going to use the lunch to work on his witness list for the afternoon. So that's what they're going to take, an hour and a half lunch. So whenever they do break, they're going to take an hour and a half lunch. So that'll be lots of time for kitties. You can see the kittens up there, right? See little kitties? Let me go here real quick. See little kitties? Oink. Kitty kitties. That was a big hit. Is still a big hit, I should say. Not well, was and is. Psychosaurus Rex.
Concerning this issue of the testimony of Linda Bailey, the court is going to find there has been a second violation of the rule of sequestration by the defendant. The matter that was discussed at sidebar brought up the issue of the witness sitting in court. However, the state made no agreement beyond an adverse expert listening to the testimony or reviewing the testimony of their expert. With no other ruling being made on the issue, Ms. Bailey should have not sat in the courtroom. The test for determining whether a court may properly exclude the testimony of a witness for violating the rule of sequestration is whether the testimony of the challenged witness was substantially affected by the testimony that the witness heard, to the extent the witness's testimony differed from what it would have been had the witness not heard the testimony. And this is citing to a Florida Supreme Court case, Steinhorst versus State, 412 Southern 2nd 332. The same test also applies to expert witnesses who violate the rule. Concerning the proffer, the witness has indicated that in preparation for her testimony, she reviewed materials provided by the state. She reviewed testimony from the same witness from prior trials, and ultimately her opinions, whatever they may be, to be offered, have not been affected. As a member of the bar, I am going to give credibility to what Mrs. Bailey has stated concerning these matters, as I have no other evidence to the contrary. Although the state has asked for exclusion of this witness, this being a second violation, it still remains inappropriate. Concerning how the jury is to be instructed at the end of the trial as to this testimony specifically, if the state is asking for instruction for how the jury is to weigh the credibility of Ms. Bailey or the previous witness who is subject to the rule of sequestration, I believe they are entitled to based on the circumstances of this matter. Does either party need to be heard further?
As long as the instruction that the court is going to give, the state's going to specifically be asking for, ask the jury to determine whether the witness's testimony was impacted by what they observed.
We can wrangle over the language at a later point.
I have no objection as long as we can agree on the language.
Please bring in the jurors. Ms. Bailey, please come to the witness stand. there any additional matters that need to be clarified? This needs to occur so we don't have any more issues with witnesses or other problems.
All rise, jury, entering the courtroom.
Everyone can be seated. Ms. Bailey, please rise to be sworn. Ms. Bailey, please rise to be sworn. Do you swear or affirm the testimony you're about to give will be the truth?
I do.
You may take your seat. You may examine as you're ready.
Thank you, Your Honor. Good morning. Can you please introduce yourself to the jury?
Yeah, my name is Linda Bailey, and I'm a family law attorney here in Tallahassee.
Tell us briefly about your educational background.
My post-high school educational background is I have a bachelor's in psychology from Florida State University in 1983. I worked for a couple of years and went back to law school in 1985 and graduated FSU Law in 1988 with honors.
So, math isn't my strong suit, but that's
37 years.
37 years.
I went to school with Miss Adamson, so we've been practicing the same length of time.
What type of law did you initially practice when you graduated?
When I initially, during law school and then after I graduated, I initially practiced criminal defense law. Then I brought in slowly a family law practice. And then in 1994, about 6 years into practice, I shifted my focus to solely family law and went on my own and opened my own practice.
So since 1994, have you exclusively practiced family law?
Yes.
Can you tell the jury approximately how many family law cases you've handled since then?
Oh, I tried to count those for this trial, and my best guess would be around 2,000.
Do you have any certifications?
Like Kristen, I am board certified in marital and family law, and what that requires is an application that's about 3/4 of an inch thick that details all of your child practice, litigation practice, the type of cases you've handled, how many experts you've done direct exam with, cross-exam with, etc. Then once you provide your application, the bar does a peer review, and that includes sending very detailed questionnaires out to opposing counsels and judges in front of whom you've practiced. And then based upon that peer review, they will invite you to take the exam. The exam is a 6-hour exam done in Tampa. And I think the year I took it, 41 people sat for it, and I think 9 passed. So it's a pretty rigorous process.
Okay, and before we continue, the clerk had asked me to have you spell your name. Can you spell your last name, please?
Yeah, B-A-I-L-E-Y.
Thank you. How many board-certified family law attorneys are there in the state of Florida?
I believe there are about 274, according to the Florida Bar.
Okay, and do you know what percentage of lawyers in Florida are board-certified in marital and family law?
I think less than 1%.
What do you have to do to maintain your certification?
Well, ordinarily, lawyers have to do a 30 hours of continuing education every 3 years. To maintain your board certification, you have to recertify every 5 years, and you have to do 75 hours of continuing education every 5 years. So there's an enhanced legal education, continuing education requirement. And then you also have to continue practicing in the area where you have a certain number of trials of a certain length of time that you also have to do within that 5-year recertification period.
And you have to.
And they also send more peer reviews out every 5 years. So all of the other opposing counsels, other board-certified lawyers in your community get a questionnaire, and they get to fill that out about their impression of working with you, and that goes back for your recertification.
And judges also get that same peer review?
They do.
Do you have any other certifications?
I'm a Supreme Court certified mediator, and that was probably the mid-aughts, 2006, 8. I can't remember exactly when that was.
What's required to be a certified mediator?
It's a 40-hour course. I went to Orlando Monday through Friday, and then after the course you do co-mediations with other mediators, and then you have to do some supervised mediations, and then you're certified. They have the same recertification period, not as enhanced as a board certification, but you do have to take enhanced continuing education that might be a little bit different than you do for either your bar license or your board certification.
Have you maintained your board certification since you were first certified in 2011?
Yes, I have.
Have you received any other recognitions during your career?
Well, U.S. News and World Report puts out a Best Lawyers in America publication annually, and I've been recognized in that publication for many years. I'm not sure how many. They've also recognized my law firm as Best Law Firm in America, and recognized me as a woman in the law to watch. I also have been recognized as a super lawyer, which means the U.S. News and World Report bases their recognitions on peer review, and the enhancement at the super lawyer is it does peer review. It also looks at your practice, your certifications, your outside legal interests, like have you provided presentations, have you taught, have you done certain community service or pro bono work, that sort of thing.
Have you taught?
I have. I taught for several years. I'm going to estimate 5 years with the Legal Aid Thunderdome program. And that's really an incredible program where family law attorneys, now it's grown to do other disciplines, but at the time I was doing it, it was strictly to teach other lawyers who don't do family law how to do family law well enough to provide pro bono services, free services for people who can't afford lawyers. And my focus in that area of teaching was parenting plans, parenting schedules, relocation, those sorts of parenting-related issues.
Your Honor, we would tender the witness as an expert in family law proceedings.
The state wished to voir dire the witness as to their training or experience.
No, Your Honor.
In objection to her ability to provide an opinion in the fields of marital or family law.
No, Your Honor.
Members of the jury, the witness will be permitted to provide an opinion while she testifies in the areas of marital and family law.
Thank you, Your Honor. In conjunction with your being retained as an expert in this case, can you tell the jury what materials you reviewed?
Yes, my primary source was the divorce file between Wendi Adelson and Dan Markel. So everything from the petition that was initiated in September of 2012 by Wendi Adelson to the last document filed, which was, I believe, a suggestion of death.
And did you review any other materials?
I reviewed text messages that were provided to me. I believe they came through the state between Wendi Adelson and Dan Markel in the 2014 timeframe. I was provided, but didn't review thoroughly, text messages between Wendi Adelson and friends and other miscellaneous texts. There were some text messages between, I believe, her and her mother. But most of their communication, I think, was by email, and I reviewed the emails that I was provided between Wendi Adelson and Donna Adelson from maybe 2011 up through about 2017. I don't know if they were comprehensive because they were provided to me.
Did you also speak with Ms. Adamson concerning her representation of Wendi Adelson?
I did. I spoke to her for about an hour a couple of weeks ago to kind of confirm my impression of some of the motions that were filed.
Okay. Now, can you you indicated that you reviewed the court file. When was the dissolution of marriage action begun?
It was begun with a petition filed actually by Wendi, which she had a lawyer, Shannon Novi, for a brief period of time, and then she switched to Kristen Adamson. So I reviewed that petition, and that was filed mid-September 2012.
Did Wendi Adelson, in that process, file a motion for the court to determine a temporary parenting schedule?
Yeah, just about a month after the initial petition, she filed a motion for the court to order a temporary parenting plan, which is normal, so you don't have chaos pending a final resolution.
So that the filing of that motion is a typical step in a dissolution of marriage that involves children.
Well, it's very routine, because what you don't want is both parents showing up to school, picking up the kid on the same day, and the kid doesn't know where they're going, and it creates a lot of stress for the children if they don't have a plan. So it's important for the parties to get together early on and figure out what they're going to do until the court can make a final ruling.
And what specifically was Wendi Adelson's request in that temporary parenting plan concerning time sharing?
She asked for a plan that would provide 51% of the time to her and 49% to Mr. Markel, which at the time, it was much more traditional, if you will, for there to be a primary parent and a secondary parent. And it was thought at that time that having a child more solidly in one household versus splitting the 50-50 was more advantageous for the child. That thinking has now changed, where there's a presumption of 50-50, but back in 2011-12 time period, she had initially filed for majority time sharing, which was ordinary, but then actually in her motion for temporary parenting, she asked for a 59-41, which is 51-49, which is essentially 50-50.
Why would one party ask for 51-49?
Really, the only reason I can think of would be for an IRS tax advantage, so you'd be able to claim the children on taxes.
To claim them as dependent?
As dependents, yes.
Okay. Or head of household?
Yes.
Okay. Now, you indicated that a lot of times these issues, it's important to establish them early on. Did Wendi Adelson and Mr. Markel have to go in front of the judge to get a temporary parenting plan put in place?
No, they worked that out by themselves, or through counsel.
So they worked out an arrangement that was beneficial for the kids and allowed them to have time sharing?
Yes, my understanding is they worked out a 50-50 arrangement.
Okay. Now, we're using the term time sharing. We also have, during the trial, heard the term custody. Historically, has the term custody been used in family law proceedings?
Not for many years. Not for many years. Gosh, it may have been a term back when I started practicing, but then it went to primary residence and secondary residence, and then it moved to simply time sharing. So there's been a change in the way we refer to it linguistically, because you don't want a secondary parent. You want all the parents to feel like they're full parents. So.
Okay. And so the term custody is not something that is used in family law proceedings any longer?
Not between parents. There's the term custody still lingers in some grandparent cases, which aren't applicable here.
Okay. But when we're talking 2012 moving forward, the term custody was not used in family law proceedings for dissolution.
Correct.
Okay. And the term at that time was time sharing and parenting time.
I believe back then it had shifted to time sharing. It may have been primary and secondary residence, but I didn't see that in the petition. She just asked for majority time sharing, so that must have been when that law switched. It was around that time.
When Wendi Adelson initiated this dissolution, did the pleadings indicate that she was trying to prevent Mr. Markel from having substantial time sharing?
No, I didn't see anything throughout the whole file. She tried to prevent Mr. Markel from having substantial time sharing.
Can you tell the jury what is substantial time sharing?
Well, substantial time sharing, again, the definition has changed. It used to be more, in this era, it was more than 40% time sharing. And now, for the purposes of child support adjustments, it's kind of been reduced to 20% or more. But I think when we're talking about time sharing versus how it impacts child support, substantial time sharing, I think everybody would accept would be 40% or more time sharing.
So, in other words, when Wendi initiated the dissolution against Mr. Markel, she was not trying to prevent him from having 40% or more of the overnights.
I never saw anything other than the 49-51.
In your review of the family law pleadings, can you tell the jury how many contested hearings took place prior to the final judgment being entered?
From my review of the pleadings, one partial hearing occurred, and that was the June 21st, 2013 hearing on Mr. Markel's motion to dismiss the petition for relocation, and then he had filed a motion to enforce life as he would have liked to have seen it, and then the relocation was all within one hearing. The court adjudicated the first two issues. His motion to dismiss was denied. His motion for enforcement was denied because there was nothing to enforce. There was no court order that required the things he wanted to enforce. And then...
In other words, he was asking the court to enforce something that they had agreed on but hadn't been a court order?
Well, I don't even know that they had agreed on things. He had kind of a sense of the way he would like to see life, which had to do with being really intrusive at Wendi's home. He wanted to go over there often during her time sharing. He wanted to have a great deal of contact. He wanted video contact, things like that. And so, and I think there was maybe a recommendation, I could be confusing this with a later motion, where the child care owner had made a recommendation about something, and he wanted to enforce the recommendation from the owner of the child care. None of those were enforceable because they'd never been ordered by court or even put into any sort of formal document. So that was denied.
So let me understand correctly, he was asking for court authorization to be able to go over to Wendi's house?
In that particular motion, I could look at my notes, but I don't remember exactly the detail. Ordinarily, when you file a motion for enforcement, you have a court order that says the other side has to do A, B, and C. And if you don't do A, B, and C, you file a motion to enforce. But you can't enforce an email communication back and forth where you said, you know, you can have them on Tuesday, and then Tuesday you change your mind. There's no court order to enforce. They just change their mind. So he was trying to enforce conversations that he had had with Wendi that had no court-ordered basis.
Okay. Now, you mentioned the motion, Mr. Markel's motion to dismiss the petition for relocation, his motion for enforcement. Was that also the same hearing where the relocation petition was heard?
The same hearing.
Okay. And based on your review of the file, what happened at that hearing?
Based on my review of the file, the court adjudicated his motion for enforcement and denied it, adjudicated the motion to dismiss and denied it, and he was basically saying that the petition for relocation was baseless and that the court should deny it, and the court said no, it had merit, so we're not going to dismiss it. And then my understanding is before the hearing finished, Wendi essentially capitulated and said, okay, I'll agree to the denial of my relocation. And what's consequential about that is if they could have continued the hearing, finished their testimony, and appealed the order. So by her capitulating and stopping the hearing midway, she waived her right to appeal the denial of the relocation.
Subsequent to the June 21st, 2013 hearing, did Wendi Adelson and Mr. Markel resolve the other issues in their dissolution of marriage?
Yes, on July 31st, they signed a full marital settlement agreement that addressed all issues. So within 5 weeks of the denial of relocation, they resolved all their financial issues. Wendi waived alimony, they adjudicated child support, they put into place a parenting plan, which is kind of also new lingo. A parenting plan is kind of the overarching rules on how you make decisions, how you communicate, who's able to go to events for the children, plus the time sharing schedule, plus communication provisions, how often you can speak to the children. Sometimes, like in this case, it was very general language, maybe what school the children go to. So they resolved everything 5 weeks later.
Now, the marriage settlement agreement also put in place a parenting coordinator?
It did.
What is a parenting coordinator?
A parenting coordinator is a professional, generally a lawyer, but it can be a therapist who is trained. I think they do a 40-hour course too, but I'm not certain. And they have a certification. And what they're trying to do basically is teach people how to communicate, teach people how to be reasonable. There's no parenting plan that you can draft that deals with all contingencies. People are always going to come up with something, and we don't have a provision in the marital settlement agreement to deal with that. So a parenting coordinator helps people set, for example, communication guidelines. Maybe one person is calling 10 times a day, and that's overbearing and it interferes with the other parent's life in households. So a parenting coordinator may help them reach agreement on what a reasonable communication might be. Maybe it's once a day at 7 o'clock. Maybe it's every other day. Maybe it's 2 times by video and 4 times by telephone or something like that. So they help them work out the details and just keep the conflict low.
Now, can a parenting coordinator put in place provisions in parenting plan that are not already included in the marriage settlement agreement?
No, the parenting coordinator's role is to help the parties have a civil discussion and come up with a reasonable resolution. But if there's no reasonable resolution that they accept from the parenting coordinator, then they can go to the court and ask for a remedy in certain circumstances.
In certain circumstances?
Yeah, for example, the parenting coordinator is not permitted to add provisions that are not in the marital settlement agreement. In that circumstance, you can't just go to the court and say, hey, I want this provision added. You have to file a supplemental petition that requires a material and substantial change in circumstances plus best interest. Kristen talked about that earlier. And you have to, it's basically starting a case over. It's very difficult to modify a marital settlement agreement. What you can go to the court for that a parenting coordinator might be involved in is somebody's not returning the child on time chronically or violating communication provisions that are already in the marital settlement agreement. You may go to the parenting coordinator first to try to avoid court and say, hey, can you get her to stop? Can you get them to be more timely? Can we find a new meeting location, something like that? And you can go to the court for those types of issues, violations, but going to the court for modifications isn't going to happen unless you've had a material and substantial change, and the case law says that has to be an extraordinary change. So it's very difficult to get a modification or add terms.
Now, with respect to the Adelson-Markel case, other than that June 21st, 2013 hearing, were there any other, did they litigate any other issues?
During the divorce?
Yes.
Up through July 31st?
Yes.
No, they resolved everything. Temporary parenting, permanent parenting, support, property.
How many months elapsed between when the initial petition for dissolution of marriage was filed and when the final judgment of dissolution was entered?
10 months.
How does that compare with cases that have similar issues?
If you take the relocation issue out, it's probably average. If you add the relocation, it was brief. Most relocation cases take 2 years or so to get to trial.
As of the final judgment of dissolution on July 31st, 2013, would it be your opinion that this case was in any way unusual or highly contentious?
No, to the contrary, it was settled amicably, and everybody was moving on with their lives.
And quickly?
Yes.
During the underlying litigation, so between September of 2012 and July 31st of 2013, when it was when the final judgment was entered, did either party file a motion to compel against the other?
No, and what that is if you're upset with the other side because they're not providing either the required financial documents that Ms. Adamson spoke out earlier, or if you do a request to produce more documents and they don't comply, then you would file a motion for the court to compel them to provide those documents.
And that's what we call discovery?
Correct.
Were there discovery fights here?
No, there were no discovery fights. There was afterwards when Mr. Markel's lawyer was trying to depose Wendi about the money he had not paid, but prior to July 31st, there were no discovery fights at all. There were, I think, requests to produce, and there was no motion to compel or any complaint about the responses to those. I didn't see any third-party subpoenas to banks or holding companies or brokerage accounts or brokerage companies.
Can you explain to the jury what a third-party subpoena is?
Yeah, so for example, if you believe that a party has an asset that they're not disclosing, and if you know, in general, sometimes we do kind of blanket ones, but generally if you know where those documents might be held, whether it's Fidelity or Wells Fargo or Bank of America, then you can do a subpoena. You do a notice first, and then you have to wait 10 days, and then you can issue the subpoena directly to the bank or the person holding those records and ask them to provide you the records directly, so you don't have to get them from the other party. So sometimes we'll have parties who just don't cooperate. They don't provide anything. We know they have retirement accounts. I have one right now, and he will not give us his retirement account because he does not want it split. So we are having to send third-party subpoenas out to all his prior employers to get his retirement records because he's just not doing it. So it's an easier way to get those records than fighting him directly.
And so in that type of scenario, you'd have to first subpoena his records from prior employers in order to get the names of the retirement companies, correct?
If I need to do that, they could be company-held employment plans, depending on what kind of company, you know.
But potentially in that scenario where you're having to issue third-party subpoenas, there are multiple layers that you might have to go through in order to get the information that the other party is not providing.
No, it's really more direct than that. I mean, once you file your notice of intent to subpoena a third party, you issue your subpoena to that party. The difficulty comes if you don't know who the party is. Then you might have to take a deposition and find out where somebody's been working. Generally, your client knows where their spouse worked, so you have that information in that example. But there could be, like we have a case right now where there's like 140-something real estate properties all over the country. And that makes it more difficult, obviously. So we're having to go into databases all over the country in different states to look for people and then find out who the management company is and then third-party subpoena the management company. But that's an outlier.
Needless to say, you didn't have to do any of that, or none of that had to be done for Wendi Adelson's divorce.
None of that happened.
What about non-party depositions?
What I saw was there was one non-party deposition from Dr. Phelps, who was the owner of Creative Preschool, where the children went. And essentially, I did review that deposition, and it essentially said the kids were doing great. And then there was a deposition of someone who worked at the law school.
And aside from those two, were, I believe, Wendi, was she deposed?
I don't recall seeing that Wendi or Mr. Markel were deposed.
Okay. Now, you testified earlier that you reviewed emails between my client and her daughter.
I did.
Okay. Did you find anything unusual about my client, Donna Adelson's involvement in her daughter's divorce?
No. We have parental involvement, as Ms. Adamson said, often. Sometimes it's employer involvement. Maybe they're very attached to their employer and they want to nurture them. Or we'll get siblings who are lawyers involved. So family involvement, and especially moms, I see a lot.
A lot of mothers?
A lot of mothers. They're worried about their babies no matter how old they are.
Now, in the emails that you reviewed, did you see my client's use of the nickname Jibbers to refer to Mr. Markel?
I did.
Did you find that especially provocative?
No. I mean, gibbers means someone who speaks gibberish. And if you look at Mr. Markel's motions and memorandums and responses he filed in this case, it was somewhat applicable. He was very verbose. If you looked at his writings as a complete layperson, they may at first glance seem somewhat intimidating, but when you broke them down paragraph by paragraph, they were inconsistent. They didn't make sense. They referred to, in multiple situations, he was seeking enforcement of things that were not court ordered, even afterwards in the February 2014 timeframe. So he was very wordy. He would file a 16-page response, and then he'd file a 16-page memorandum that said the same thing, and then he'd file a motion related to that said the same thing. So he was, a lot of his, the things that he filed, papers that he filed, which were signed by his lawyer, but they were consistent throughout all the lawyers, so it appeared that he was drafting them, were very, very wordy and full of hyperbole.
In that same vein, the lawyers that represented him, have you litigated opposite them in the past?
I have.
The pleadings that they signed on Mr. Markel's behalf, are those consistent with the pleadings that you've seen them author in the past?
No, it appeared to me that Mr. Markel was drafting these pleadings because they just weren't drafted in a way you would draft them, and they didn't, again, make sense. They were internally inconsistent. For example, moving up to the February timeframe, he was complaining about fraud by Wendi Adelson and not disclosing accounts as if that impacted the settlement. But then he said, very shortly or in the same near paragraph, that he knew she had these accounts because he managed one of them, and he knew about the other account as well. So all he had to do was do third-party subpoenas to Schwab. He knew a Schwab account existed. That was easy. And so you can't say fraud, I made a decision without knowing, and then in the next paragraph said, but I knew these accounts existed, that's why I know she's committing fraud.
Okay. So in reviewing those particular motions, the one that he filed February of 2014, what was your opinion about the strength of that being granted?
Well, Wendi filed a motion for enforcement at the end of October 31st, I believe, 2013, which complained about the $80,000 or so. I think there was some question whether he paid $50,000 or $51,000 or $52,000. But anyway, he was essentially just around $80,000 underpaid. He hadn't paid his obligation. So she filed a motion at the end of October. Then there was no response, nothing. His lawyer withdrew. There was nothing in November. There was nothing in December. Then January 31st, so 3 months later, he filed a response that basically said, he didn't deny not paying, but he said, her bad behavior, her unclean hands, give me a valid excuse for not paying her, essentially is what he said. And that is not legally I don't think it was a very strong legal position.
Okay, and we'll come
Then-
back. We'll come back to that.
Okay.
I want to back up to the June 21st hearing when relocation was denied. Did my client, in the emails you review, appear to push back on Wendi and try to get her to do certain things?
Well, what I saw from what I was provided in the hearing, I think was on the 21st, and there was a couple of days, maybe the 23rd through 26th, something like that, where Donna Adelson, maybe the reality of the relocation had set in, the denial, and she was upset. So she was sending emails going like, how can we undo this? Or is it possible to undo this? And then Wendi responded, I think at the end of that, Mom, I'm at peace, I'm good. And then they dropped off. There was no more communication that I saw
And then
between them.
certainly after the July 31st final judgment, was there anything else where relocation was attempted or discussed?
Not that I saw.
Now, when you are representing clients, how do you handle the involvement of their parents or loved ones in your client's divorce?
If I know that they're very involved, I'll ask to meet with them and bring them in, because what I don't want is our third parties interfering with my advice, frankly. So if they misunderstand the law or they're giving advice to my client contrary to my advice, then I want to talk to them. I want to hear their point of view, and I want to give them my point of view. And I find it's easier for my client to have everybody around them on the same page. So I just want to educate them. If it's a mediation and I feel like they're involved, I'll ask the other side if I can bring the mother or the brother, whatever, whoever it is, into the mediation, because if they're in the mediation process, then they see how it changes over the course of the day, because other facts might come in, other considerations might come in, because mediation is not just an opportunity to reach a resolution. You learn a lot of information out of mediation. So it's always helpful to have, if there's a family member who's very involved, it's helpful to have them there so they learn as you learn, and they understand how you reached an agreement, and then the litigant, the party, doesn't go home and have to explain what happened.
Do you have situations where clients, family members, or friends are offering advice and it's passed on to you?
Sure.
How do you address that?
I ask them to call me. You know, sometimes I say, you know, if you don't trust my advice, maybe you should get a second opinion, and generally they don't. And I say, this is why I don't think that advice is valid or is going to help you, and we can have that dialogue. And if they're really strong about it, then I'll definitely ask to say, let me speak to your boss, your brother, your mother, so we can kind of talk through this, because I need them to understand my position, and maybe theirs will change.
Now, you were provided with a number of emails that Wendi was sent by her mother. Did you see evidence that Wendi shared those with Kristen Adamson?
I saw no evidence that Wendi shared them.
Okay. And did you speak with Ms. Adamson about that?
Yes.
Okay. Did she receive any of the input from Donna Adelson?
My understanding from Ms. Adamson is she really didn't understand that Donna Adelson was involved at all. I mean, she was there at that one hearing, but that's very common.
Did Wendi Adelson get the parenting plan that she was requesting in her settlement agreement?
She did. The entire marital settlement agreement was very beneficial for her from all the way through. She actually got a parenting plan that was more, I think it was more like 45, 55, something like that. It was instead of 7 days out of every 14 days, he was getting 6 days out of every 14 days, with 5 days and then 1 day in the off week. So it was split up a little bit. which was a typical parenting plan for that time period. So she got more parenting than she had really asked for, and that was to last 3 years, and then it went into 50-50. I think that got the youngest child to school, maybe. So they did, until the youngest child went to school, she had about 55% parenting time. Child support, the division of child care, that sort of thing.
And without going into too much detail, child support is a mathematical calculation.
It's a formula.
And it's based on a number of factors: income, child care, insurance, health insurance, and parenting time.
Exactly. And then Mr. Markel had asked for sole decision-making, for example, because he was upset if the children didn't eat kosher or whatever his complaints were. So he wanted sole decision-making, which is extremely difficult to do. The only time a parent gets sole decision-making is if the other parent is just incapable of making decisions, like drug addicted or seriously mentally ill, something like that. So that was really also telling that he was drafting that, because I don't know that either of the lawyers that filed on his behalf would have asked for sole decision-making. That's just rarely granted. And so she got shared parental responsibility. He didn't get any superior decision-making that he requested. He also requested for more than 50% of the marital assets, because he said he earned more and he created the assets more than she did, which is not a valid legal position. And she got what appeared to be equal value of assets.
Of the marital estate.
Of the marital estate, which was part of that $120,000 he was supposed to pay her.
Did Mr. Markel get the 50-50 time sharing he was requesting?
Not immediately. He had to wait 3 years for that, by agreement.
And you mentioned keeping the boys kosher. Was Wendi Adelson required that the boys keep kosher?
That I don't know. I think there were some issues about that.
In the marriage settlement agreement, was that required?
No.
Was she required in the marriage settlement agreement to allow Mr. Markel to come over to her home during her time sharing?
No. That would be extremely unusual.
In the marriage settlement agreement, was she required to have the boys available for video calls?
No.
Was Wendi Adelson, throughout the litigation, requesting that the boys be available nightly for her to speak with them when they were with their father?
No.
Was Mr. Markel granted every Jewish holiday?
No, I think he had requested that, but he was not. They alternated the Jewish holidays.
Was Wendi Adelson required to continue counseling with Mr. Markel and follow the advice of those counselors?
No, and that would be an improper order. The court can't delegate decision-making to a third party like a therapist. The court can't say you need to go to your therapist and follow their advice.
Was Wendi Adelson required, pursuant to the settlement agreement, to equally split time on each of her children's birthday with Mr. Markel?
No, there was a general provision that each parent would get some time on birthdays, but there was no requirement that it be equal. And I really try to dissuade my clients from putting birthdays into agreements, because kids don't want to see their parents fight every birthday. Were either parties prevented from allowing the children to see anyone else unsupervised in the marriage settlement agreement? No. I mean, the general premise was shared parental responsibility, which is what they have, meaning they have equal rights to get information, make decisions. The whole crux of that is you trust the other parent to make decisions that are healthy for your kids.
Now, pursuant to the marriage settlement agreement, was Mr. Markel ordered to pay both Wendi a lump sum and Kristen Adamson a lump sum?
Yes, he was ordered to pay $120,000 directly to Wendi Adelson and $10,000 towards attorney's fees to Kristen Adamson.
In what types of cases is one party ordered to pay or agree to pay part of the other party's attorney's fees?
When there's a disparity between assets and income, so it can be assets or income or assets and income. I think in this situation, Mr. Markel's income was twice or so Wendy's, and his assets, from what I understand, including the non-marital assets, were more substantial than Ms. Adelson's.
In your opinion, was the marriage settlement agreement that was incorporated into the final judgment favorable to Wendi Adelson?
Yeah. Yes.
Now, later,
But it's very fair. It was measured. I say that favorable only because he was asking for things that would have made it unfavorable and that were unusual requests. And at the end of the day, he gave up on those, and they got a very typical marital settlement agreement.
so from September of 2012 until the final judgment, July of 2013, as far as the litigation is concerned, it was not very contentious.
Not at all.
Now, after July 31st of 2013, did either side file any enforcement actions?
Just the 3 months later, the payments for Mr. Markel were due within 60 days, so that would have had them due at the end of September. And so, taking Kristen Adamson at face value that she tried to work this out during the month of October, on October 31st, she filed a motion for enforcement of the 100, what's left of the 120, 70-ish, plus the 10 for fees.
Okay, so Mr. Markel had 60 days to pay those amounts.
Correct.
And Ms. Adamson waited until 90 days after the agreement was entered, the judgment was rendered, and 30 days after the deadline, she waited to file.
She did.
Okay.
And even that was a pretty ordinary motion. It didn't ask for any drastic sanctions. It didn't ask for jail time, anything like that, which couldn't have been ordered. It would have just, she's looking for a judgment that she can execute on. So you have to get a formal civil judgment from the court, and then you can execute on that by attaching other assets or garnishing wages, that sort of thing. I've had the court open up and get retirement assets and kind of claw them back from the marital estate to make the person whole who doesn't get paid.
Okay. Now, in reviewing the emails between my client and her daughter after the relocation hearing, did you see any correspondence trying to encourage my client, I guess it was after July 31st, to encourage Wendi to do anything about relocation?
Not that I recall.
From your review of the emails and the pleadings, did it appear my client accepted that Wendi was going to be staying in Tallahassee?
Yes, it was done.
When you say it was done, what do you mean?
I mean, Wendi waived her right to appeal that by agreeing that the relocation be dismissed. So,
now, prior to final judgment being entered, would Wendi have been able to attempt negotiating with Mr. Markel to try to get relocation even though the judge denied it?
she could have.
Would there be anything improper with Wendi or her family through Wendi offering some sort of financial incentive to Dan Markel to convince him to agree for her to relocate?
I see that all the time. I mean, I had a client pay $850,000 to somebody who didn't, to get her to not relocate. I've seen $35,000 to get a, whatever parenting plan you want, or to get less time. So depending on your financial circumstances, that number can be wide-ranging, but it's common. And in mediations, it's often common to see where the pain points are. If the pain point is money, then you use that pain point to get what you want on parenting. It's a negotiation, so that's routine.
Nothing unusual about
routine.
that. Okay. Now, you testified earlier that you were provided text messages between Wendi Adelson and Dan Markel after the divorce was finalized.
Yes.
Although they didn't agree on everything, did it seem to you that it was amicable?
Yeah, I was only provided, I think, what the state provided to you, which was between maybe April of 2014 through June of 2014, so it's a few months period, even after these motions had been filed that kind of up the temperature a little bit, and they were working well. I saw some communications where Mr. Markel was inviting her to join him and the boys for ice cream. I know that there were many occasions where he was traveling and his travel plans adjusted, and she adjusted exchange times based on his travel. I think he did the same for her. They were swapping days. It was actually much more amicable than many cases I see. They were very flexible with each other.
Now, you indicated earlier that October 31st, 2013, Kristen Adamson filed a motion for enforcement.
Correct.
Now, you mentioned a motion for enforcement and contempt. What is contempt?
Well, in this context, I think that's just the title of her motion, because in the body of the motion, she didn't ask the court, I don't believe, to find him in contempt of court. She was just looking for a judgment so she could execute on the judgment and collect her money.
So although the motion itself may have been entitled enforcement and contempt, the prayer for relief didn't include any request that the court find him in contempt?
I don't recall seeing that at all. I think the court said make him pay, ask the court to make him pay. And what that means is give me a judgment so I can enforce on that judgment, however that may be. It's just a collections issue.
You indicated that you don't think it would be helpful to see the pleading itself.
Sure.
May I approach the witness? Approach with courts 1 states demonstrative A, specifically page 338. Is that the October 31st, 2013 motion that Ms. Adamson filed?
It is.
Okay. And the body of the motion, does it seek anything concerning contempt?
In the body, which does not control the ask of the court, which is called a wherefore clause, and under the wherefore clause is where you say what you want the court to do. Above the wherefore clause, it sets out the facts. He was required to do this. It was due by here. Here's what he's done. Here's what he owes. She's incurred attorney's fees. And then she says attorney's fees pursuant to this agreement are a form of support. The former husband should be required to show cause why he should not be held in contempt for failing to pay a form of support. So that's accurate in the sense that the money owed to Wendi is not enforceable by contempt. The $10,000 fees can be enforceable by contempt. So she says that above the line, but then the wherefore, what she asked the court to do is enforce the marital settlement agreement, require him to immediately transfer to the former wife the remaining amount due to her pursuant to the marital settlement agreement, together with statutory interest on the same. Order him to immediately pay the wife's attorney's fees of $10,000 and award her attorney's fees for this action. So all she's asking, she's not asking the court to hold him in contempt here. She's just asking the court to order him to pay it immediately. And the sanction for him would be he'd be required to pay the attorney's fees to Kristen for having to file this motion, and he'd be required to pay statutory interest on the unpaid amounts from the date it was due until the date it's paid. So that's his full exposure.
In the scheme of this dissolution and the circumstances of this case, was the amount of money that Ms. Adelson was seeking through this enforcement motion an enormous amount?
I didn't view it that way. I viewed it as kind of an annoyance that she had to go through these hoops to get the money because he had the money and he owed the money, but it wasn't going to put her out on the street.
Did you believe, is your opinion, that that motion for enforcement that was filed on October 31st, 2013 had merit?
Absolutely.
And what were the possible repercussions to Mr. Markel?
He would have to pay more. He'd have to pay more in fees and more in statutory interest and more to his lawyer to fight it. That was it.
Were you provided with a series of emails in mid-December of 2013 where Mr. Markel emailed the parenting coordinator and Wendi Adelson complaining about a host of issues?
I did.
Okay. Was one of those issues one where the boys allegedly said that Grandma referred to him as stupid?
Yes, he brought that complaint up to the parenting coordinator and to Wendi in the same email in December 18th, maybe, of 2013. From
your review of that correspondence, what did he want to happen?
My recollection is he was asking Wendi to be mindful of that and to be alert and make sure it didn't happen.
Did he ask that my client not be around the children unsupervised?
Donna Adelson, no, he did not ask for that relief.
According to what you reviewed, when did those quote stupid events allegedly occur?
According to the email, he said there were 2 or 3 occasions in November where the kids said something like, "Grandma thinks you're stupid," or something like that.
Did Mr. Markel file any action, any motions or supplemental petitions in November or December of 2013?
Related to that allegation?
Yes.
No.
Now, the motion for enforcement filed October 31st, when was that set for hearing?
It was initially set for hearing in February, and I believe that was set in December, and it was the certificate of service, which is the bottom of the motion. You file a certificate that says where you have sent this document, to whom you've sent this document, and it went to Mr. Adelson's new lawyer in December.
Mr. Markel?
I'm sorry, Mr. Markel's new lawyer in December. And then nothing happened. All of January went and nothing was filed. And then the end of January, which at this point is 3 months after the motion was filed, a response was filed. And then the response basically said, yes, I owe the money, but I don't have to pay it because Wendi had these other financial violations. And then she referred to the Schwab account that you've heard about, a retirement account, I think. And then 2 weeks later, I think it's February 14th, he filed a motion for contempt against Wendi. In that February 14th, it was kind of a companion document to the January 31st response. Again, he would do multiple filings on the same issues. He again just addressed, but a little more vehemently, the allegations of financial fraud. It was only a financially focused document.
What defense did he claim to have to avoid paying Wendi Adelson as he'd been ordered?
My recollection is his defense was that she did not put on her financial affidavit a certain non-marital asset, but he knew that an asset existed, but it was fraud. It was kind of circular. And there was, he said he didn't have a updated document at the time of the marital settlement agreement or something like that to know what the then value was. But those are all pre-divorce issues. So he had ample opportunity during the divorce to do third-party subpoenas or motions to compel or other ways to get those documents. And then according to Chris, all of those were dealt with in the marital settlement agreement anyway, and I don't have any reason to doubt that. But yeah, he was just trying to say one good breach deserves another or something like that, and it wasn't legally supportable.
That's not a valid defense.
Pardon?
That's not a valid defense.
I wouldn't make that defense, no.
Okay. Now, if a party in an action believes that there has been fraud in the underlying, securing the underlying agreement. Is there a way in which they can contest that?
There is. If you're alleging fraud, and if it's fraud in the financial affidavit, you don't even have to do it within the first year. But there's a rule that Ms. Adamson referred to. It's called 12.540, and that's where you can move to set aside the marital settlement agreement based on fraud. So if you find out later that they had won the lottery before you and didn't disclose, or that they had some stash of gold bars somewhere or whatever, you can come back in and say they didn't disclose that. But it has to be material. And so the case law is pretty clear that the fraud has to be an actual fraud that impacted the agreement. For example, I think there's one case that talks about maybe there was a minor $3,000 to $5,000 tiny IRA or something like that was never disclosed. They just had forgotten about it. It was very small in relation to the rest of the assets. And the court said that didn't really impact anything, that we're not going to set aside an agreement based upon that.
In other words, it's a high hurdle
sure,
to overcome.
And it had to have impacted you.
Okay.
In this instance, it was clear from Mr. Markel's own motions he knew about these assets. So I think his fraud allegation was completely baseless.
Now, in some of his emails and filings, he was asking for 100% time sharing, more restrictions, more access to the kids. Did he ever present a proper pleading to the court to try to get those things?
No. What happened was he did the January 31st response, and then he did the motion against Wendi on the financial issues February 14th. And then towards the very end of March 26th, after Kristen had filed a motion to dismiss his fraud motion as being a sham pleading, essentially, I guess he kind of ramped it up a little bit. So he filed a motion complaining about parenting. And it had maybe 10 different points. It was very long. Each point was maybe a page long of different paragraphs. And in that motion, almost all of the related violations were not violations at all. There were no court orders requiring her to do what he wanted her to do. So he wanted a certain number of video calls, and she didn't give him enough video calls. Well, video calls weren't required. He asked for a certain number of phone calls, and a number of phone calls wasn't required. He was asking for there was some right of first refusal. He didn't like that when Wendy's parents would come to town, that she would maybe go to dinner with friends and let them spend time with the kids. Or she would let them stay home from school so her parents could spend time with them. And they were little babies. And he didn't like that because he wanted to be able to go to the child care during her parenting time so he could see them every day. And I think the child care person had asked him probably not to do that, but he wanted to do that. And he wanted her to go to like a therapist and follow the therapist's advice on basically doing what he wanted her to do. So it was a lot of noise trying to enforce something that wasn't a provision to enforce. There was no underlying court order to enforce.
And is that the pleading that Ms. Adamson filed a motion to dismiss about?
That may have been, I was thinking she filed it against the February 14th, but I could look at my notes and clarify if you'd like me.
If it would be helpful.
It would be helpful. Yes. Yes, it looks like on April 11th. Nope, that's his response. Let's see. Yes, it was before my recollection was correct. She filed the motion to dismiss on March 10th, to dismiss the motion regarding the fraud that he alleged on February 14th. And then I think as a response to that motion to dismiss, then he kind of amped it up with this motion to enforce that dealt with the parenting issues.
And the motion to enforce that dealt with the parenting issues, is that the March 26, 2014
Exactly.
motion?
Correct. And then that was all set for hearing for May 15th.
Okay. The complaints that he raised in the March 26, 2014 motion, you indicated there were things that he was asking for that hadn't been ordered. And are you referring back to the marriage settlement agreement? There were conditions that he wanted that weren't actually in there?
Right. He was trying to enforce his view of what this post-divorce parenting should look like. But there was no court order that required her to make the children available to him during her parenting time. I think one of the complaints was he wanted one-on-one time with the kids, and she should be ordered to let him take the kids during her parenting time one-on-one. There was a couple of different provisions about communication. I think like the 8th point he made well into this very long motion was he brought up the stupid allegation from November, and this was the end of March. So I didn't see anything in his allegations that had any recent problems with him being disparaged or by anybody calling him any names. So he mentioned that. I think it was his 8th of 10 points in that motion.
Was it in that pleading that he was asking for sole decision-making authority?
Yeah, I believe it was.
Would there have been a basis for the court to grant that?
No, he would have had to go through that supplemental petition that we talked about earlier, where he would have had to show material and substantial change in circumstances and that it was in the best interest, and there's no indication he would have been successful there. And he didn't plead it correctly anyway.
Now, with respect to the complaint about my client allegedly saying that she hated Dan Markel or she called him stupid, was that allegation a feature of his motion?
No, it was buried, like I said, 8 points down, 8, 10, 12 pages down.
Just a few paragraphs of his motion?
Yeah, 3 paragraphs.
Was there any indication that those claims were true?
No, and I don't think he could have proven that because he's talking about what purportedly a 4-year-old may have said to him. And I think even in his motion, he says, I don't know if this is true or not. I don't know if Wendi was present or not. But I would like Wendi to make it stop if it's true.
Did this motion, the March 26, 2014 motion, that the state has called the grandmother motion, did that request that my client not be permitted time with the children?
No.
Did Mr. Markel request that my client's time with the children be restricted?
The only thing he requested, and he had the first right of refusal, maybe point 4 or 5, and then he kind of tied in this grandparent thing on point 8. But what he appeared to be upset about mainly was when she came to visit and they kept the children home from school, that he couldn't go visit the children at school, so he didn't want her having unsupervised time as it related to the first right of refusal. He wanted the kids to go to school and not be left alone with the grandmother because he wanted to see them. The same thing with the evenings. If she went out to dinner because her mom was in town and it gave her a chance to run out and see a friend or something, he wanted Wendi to have to call him so he could watch the kids even though mom's there to watch them, which that's not the purpose of a first right of refusal.
I was just about to ask that. What is the purpose of that?
Well, the purpose is if a parent is unavailable and can't provide care for a child, then you offer the other parent the first right to take care of the child. It's not if, my rule or what I tell my clients is if you can't make it to the hospital, if you can't meet the ambulance at the hospital, it's a first right of refusal. You need to have a parent available who can take care of any emergency. It's not to prevent the kids from having sleepovers or spending nights with grandma or anything like that. That's a normal part of a kid's upbringing, and so you don't want them to never be able to spend the night with grandma grandma and never be able to go to a friend's house because they happen to be in a divorced family. Those are just decisions each parent makes within their own household. So a first right of refusal typically is triggered when the other parent is unavailable, out of town, that sort of thing.
Okay. Now, have you ever seen a scenario where a court prohibited a grandparent from having unsupervised time with their grandchild?
Only in one occasion I can think of, and he was a convicted child molester.
What is your opinion about the persuasiveness of the March 26, 2014 motion that Mr. Markel filed?
I think it would have been similar to what Ms. Adamson described the judge saying in the middle of the relocation hearing, which is, don't file things like this. I don't think it would have been well taken by the judge at all, because it was a complete waste of everyone's time and money and emotion, because it was baseless. It didn't tie to anything.
Now, even if his allegations have been true, would the court have been permitted to modify the terms of the marriage settlement agreement based on his filings?
No.
Why?
You have to do a supplemental petition if you want to modify terms of the marital settlement agreement. You can enforce terms, but you can't modify terms.
In reading the motion, does it appear to be intimidating?
No, I think when I was making notes, I put insert eye roll here. It was a lot of words, and he was obviously wanting life to look like what he wanted it to look like, but that wasn't reality. So it's just a matter of breaking down each allegation and addressing them.
Should Wendi Adelson or my client Donna Adelson have felt threatened, or would they have felt threatened based on that motion?
They shouldn't have, and that's one of the reasons I wanted to call Kristen, because again, when I read that motion, I was kind of taken aback that a lawyer would have signed that and allowed that to be filed. And I thought it was kind of nonsense, and I wanted to get Kristen's take on that and see if she agreed, and she did, and she said that she had advised Wendi of that, and that's what I would have expected from her.
Okay. In the emails or text messages that you reviewed, did you see any communication that indicated that my client Donna Adelson was aware of that March 26, 2014 motion?
No, not what I was provided. I saw early during the divorce period that Wendi had sent her mom a couple of documents. I know the petition for relocation, that Donna helped make suggestions to beef up the facts, which I thought were pretty helpful suggestions, because, like Ms. Adamson said, relocation is extremely difficult, and you really have to have as many facts as you can to support yourself. So I saw that there was some editing and some input on that petition. But after the divorce, I didn't see any communication about sending pleadings. I don't even know that I saw any reaction from the financial motion, but certainly not from, I saw nothing either that she communicated the motion to her mother or that her mother reacted to it in any way. I didn't see any responses.
Would Mr. Markel have been able to sustain his burden of proof for that motion?
I'm sorry, say that again?
Would Mr. Markel have been able to sustain his burden of proof for that motion?
No, I don't think so at all. If you're talking specifically about like point 8 about calling him stupid, his only evidence is a 4-year-old child. Otherwise, it's hearsay, and I don't think a judge is going to talk to a 4-year-old child about whether their grandma thinks their dad's stupid. It's just, there's so much worse that goes on that's not significant.
In your experience, what do judges typically do when this type of allegation is raised?
My experience is the judge tells everybody to behave themselves and sends them on their way.
So we've talked about this not being a hotly contested case or a high conflict case. How many pages are in the court file?
I think there's roughly 570. And again, a lot of those pages are kind of repetitive documents filed by Mr. Markel that might say the same thing. Like he'll do a motion, then he'll do a memorandum that says the same thing, then he may do a response that says the same thing, or in different orders. So 570 though.
Okay. Do you know how much in attorney's fees Wendi Adelson incurred, attorney's fees and costs, for the dissolution of marriage and the enforcement proceedings that began afterwards?
I only know what Ms. Adamson said, which is around $30,000.
Now, in your career, have you worked true high conflict custody cases?
I have.
Okay. In particular, do any come to mind that involved an attempt to seek relocation?
Yes, I had a particularly conflictual relocation case that started in 2018 and went through 2021.
So about 3 years?
Yes, including an appeal.
Your Honor, may I show the witness the demonstrative?
You may.
Volume 1, Volume 2, Volume 3, Volume 4, Volume 5.
There's a question for the witness.
Do you recognize this file?
Yes, I think I forwarded this to you.
And these 10 volumes a example of a hotly contested relocation case?
Well, I just count 500 pages per binder, so that looks to be about 5,000 pages. I think the actual pages were over 10,000, so this doesn't appear to be all of it.
Okay.
And there were 2 volumes on the record on appeal, so perhaps only one of those volumes got printed.
So the clerk's file in the case that we're referring to as the demonstrative is twice as big as what we have in front of you.
Yes, based on just assuming 500 pages per notebook.
Thank you.
Please sit down, Ms. Whitman.
Can you tell the jury what the issues were in that case?
Gosh, Judge, what's the relevance? Object.
Sustained.
Judge, may we approach?
No.
Judge, we're entitled to make a record. I believe I have the...
Members of the jury, the bailiff will take you to the jury room. Seated. The relocation issues within this case are certainly relevant as to a separate other case. What is the argument that you're seeking to make for the record?
Your Honor, the relevance of this proceeding is the witnesses identified this as a hotly contested custody and relocation matter. I think we're entitled to have her explain what the issues were, what was involved in litigating that, as well as the amount of her fees that were incurred and the expenses that were incurred, so that we can make the comparison to the case that involved Wendi Adelson and Mr. Dan Markel.
Kappelman, any other argument on this issue?
Just relevance, Your Honor.
As to the point on relevance, the court's ruling remains the same. As to issues of relevance, again, the relocation that is disputed within this case as it relates to the divorce files certainly is an issue. As to any other case files, this witness may testify concerning her experience, but we're not going to go through this case file in its entirety. Please bring back in the jurors.
Your Honor, that was not my intent to go through the case file in its entirety.
Ms. Bailey, please step down, step out of the court or the courtroom doors. If you can radio Deputy Bunk to leave the jurors in the room, please approach.
Wow. All right, let's get through it. So 146 votes. Does this testimony help Donna? 2% say yes, Dan was terrible to Wendi. 97% said no, Dan is dead because of this. She's supposed to step down, but she's still in the court. She needs to leave the court. Yep, get out. Get out, Miss Bailey. All right, so they're making Miss Bailey leave. So she's trying to stay there in the court, but she needs to leave. All right, she's an expert evaluation of divorce documents. She basically trashes Dan this entire time. She basically just throws Dan under the bus.
To remind you, do not make any gesturing, do not make any comments, do not make any expressions in front of the jury in any way that would be intended to inappropriately influence them. Are the jurors using the restroom?
They are.
Please use the restroom or stretch your legs if you need to. We will continue with the witness after that.
All right, jurors are going to the restroom. All right, so she trashes Jan, right? Trashes Dan pretty much this entire time. They talk about the temporary parenting schedule filed as routine because you don't want both parents showing up at school to pick up the kids. 51% of time goes to Wendi, 49% goes to Dan. At that time, it was typical, and now it's changed to 50-50. So Wendi and Dan had worked out a schedule, which was 50-50. She didn't see anything in the files that Wendi was trying to keep the kids away from Dan. July 31st of 2013, the year before Dan was shot. July 31st, 2013, they both signed a full marital settlement agreement. Everything was resolved, property, custody, support, everything. Then 10 months from initial dissolution to final judgment. It took 10 months from Wendi to file initial dissolution to final judgment. She said it was not contentious. It was highly amicable. Were there any motions to compel? She said no. There was no discovery fights prior to July 31st. Neither Wendi nor Dan were disposed. She didn't see anything unusual from the emails between Donna and Wendi. She goes into gibberish. She didn't find that provocative. It means somebody who speaks gibberish and is somewhat applicable. So she finds Dan was talking gibberish. Do you have clients that ask others for advice? She says, well, if you don't trust my advice, then get a second opinion. There's no evidence that Wendi shared the emails with Miss Adamson. Adamson said she didn't think Donna was involved at all other than that one time in person. Dan wanted sole decision-making, which is unusual, and that's not going to work. Dan had to wait 3 years to get the 50-50 by agreement. So maybe it was Dan that called Catherine Magbanawa and said, hey, can you send Sigfredo up to shoot me? Maybe? Just throwing it out there. Because he had to wait 3 years because he didn't get what he wanted. Keep kosher wasn't in the settlement agreement. Boys weren't to be available via video calls. That wasn't in the settlement agreement. Dan requested every Jewish holiday, but they agreed to every other one. General provision that each parent get time on birthdays, and neither party had unsupervised visits. Here's the one that I starred this and I put it in the chat as well. Trust the other side to make healthy decisions for the kids. You trust the other side to make healthy decisions for the kids. To me, that's the thing right there. That Dan didn't trust Wendi. Dan didn't trust Donna. That's why he was saying no unsupervised visitations. So she talks about the $120,000 payment to Wendi, $10,000 going to Adamson. Was it favorable to Wendi? She says yes. Dan was to pay in 60 days, but Miss Adamson pushed that out to another 30 days. So Dan actually got 90 days to pay, which he still didn't pay. The text from Wendi and Dan from April to June, she says seemed to be working well together. She didn't view the amount of money Wendi was asking for as enormous. Dan asked Wendi to be mindful about the kids, saying the whole thing about Donna was saying that Donna was saying that the kids were saying he was stupid. Wasn't awarded that Dan. February 14th, Dan files motion and addresses the financial fraud. Dan's defense not pay was Wendy's didn't put non-marital assets even though he knew it existed. She said the 8th out of 10th point Dan made well into this very long motion. There she is throwing Dan under the bus again. This is where Dan put in sole decision making. She laughs at that. He didn't plead it very well. Again, trashing Dan and his intelligence. There was only one occasion that she knows about a grandparent being restricted from seeing a grandchild, and that person was a predator. She said it has a lot of words. Dan put a lot of words into this motion, and I would insert an eye roll here. I wouldn't call it threatening. Again, trashing Dan. She was taken aback that a lawyer would have followed it, and she called Adamson about it. So I don't know. She's calling Miss Adamson about, I guess they were allowed to talk to each other. Well, we'll see what Ms. Kappelman has to say about that. Let's see, the March 26 motions, she saw Wendi sent Donna documents and saw Donna's suggestions about beefing up the facts. So right there, Donna is making suggestions to Wendi. Donna is saying this is what you have to do. Non-negotiable it's not a non-negotiable thing is relocation is non-negotiable. So right there, Donna is involved in Wendi's life. Donna is involved in Wendi's divorce proceedings. Donna is involved. I don't know how much more it needs to be clear. The only evidence, what a judge believe that grandma said you're stupid. Well, the only evidence is a 4-year-old child saying grandma called you stupid, so not going to believe it. Wendi's cost was $30,000. It was highly okay. So then Mr. Zellman has his moment. He's so proud of himself. He was walking up with his little boxes. He was smiling. He has two big boxes of documents. He brings them to the stand so much so that you can't see Miss Bailey. She's hiding behind this box of documents. So many documents. Now this was a highly contested divorce. 10 volumes, hotly contested. 10,000 pages. And Miss Kappelman's like, objection. Gosh, Judge, what's the relevance? And then Zellman asks, can we approach? Judge says no. Judge says relocation issues are certainly relevant as they were in the other case, meaning Charlie. Defense says the state has said this was a hotly contested custody issue. The judge says, the state says, I still have the same objection about relevance. Judge says his ruling remains the same. Relocation is an issue and not going through the case file entirely. Defense says, well, that wasn't my intent. Then they ask for a sidebar. So that's where we are right now. All right. Does this testimony help Donna? Dan was terrible to Wendi. Now we have 4%, 160 votes. 4% of you said Dan was terrible to Wendi. 96% of you said, does this testimony help Donna? No, because Dan is dead because of this. All right. So there we stand. Sinbad, can we tell Annie and Ron to stop voting in our polls? Yeah, no. It is what it is. Everybody has an opinion, including Superball. Superball's back there growling at one of the kittens. All right. Stop. Just stop. All right. Aussie, this was awful to listen to and watch. Awesome potamus. And that Dan was highly controlling of Wendi again, glazing over any role Wendi played. Mike says, what a show. Just let's just get her convicted and send her to her new home. Then we move on to Harvey. Paula, this is pure torture to those jurors. Caffeinated teacher. I think the jurors should be given a piece of paper back in the room and asked to list any questions about Wendy's divorce. JP Rabbit, what is the next trial? We have one coming out of Tampa.
Everyone can be seated. Please continue with your examination.
Thank you, Your Honor. Ms. Bailey, how did the Adelson-Markel divorce compare across the variety of cases that you've handled?
Simply, it was routine, it was amicable. I've done similar cases that have had anything from 2-day to 7-day trials. I've had them range from $200,000 to $500,000 in fees and costs. I've had multiple financial experts, child development experts, vocational experts, all retained, deposed, testifying. I've had cases with multiple discovery issues, discovery over psychological records, financial records, third-party subpoenas, 2 full days of deposition of just one party. This was an easy case compared to many.
Did it look worse than it was because of the way in which Mr. Markel's pleadings were drafted?
Yeah, I mean, he drafted pleadings, motions, I think responses would be more appropriate than pleadings, but that's kind of technical. He drafted them like he was drafting a law review article or something. They weren't technically correct. They were verbose. They were hyperbolic. He used a lot of inflammatory language, but when you really looked closely at his requests of the court, there was no there. There was no foundation for his asks.
Nothing further, Your Honor.
Cross-exam.
What is it you were asked to do in this case?
I was asked to review the documents I was given and to opine about whether this was truly a highly contentious custody case, essentially.
And why would your opinion about whether it was a highly contentious custody case matter?
Well, that's for somebody else to decide. I mean, I've done 2,000 cases, or give or take 100 on each side, and I think I have a pretty good judge of where this falls as far as contentiousness.
Sure, but you're somebody that has vast experience with a ton of divorces, right?
Sure.
The parties only have experience with one divorce, right?
I don't know how many they have experience with,
So
but
isn't
sure.
the contentiousness in the eye of the beholder, in the sense that to you it might not seem like a big deal, but to the parties it might be the most important thing in the whole wide world? Do you agree with that? Do you agree with that?
Ms. Kappelman, Ms. Bailey, wait for the question, wait for the answer. Do not speak over each other.
Do you agree that a case, as a lawyer, might be routine, whereas to the parties it's the most important thing in the world?
To some degree. That's one reason I called Kristen, is Ms. Adamson, in particular, of the lawyers in our community of the family law bar, is extremely measured and calm, and I find that when I litigate against her, we reach resolutions, that people stay measured and calm, and we get things done. She's not one of the other lawyers in town who may stir cases up or play on those emotions. So our job as lawyers is to explain to our clients when we get emotion. If I get something, for example, that, although I've never had, something similar to what Mr. Markel would file, the immediate response is to call your client and go, I know you're going to read this at first glance, so it's going to seem messy, but there's no legal basis for this, so don't worry. And my understanding is that is what she communicated to Wendi.
And when you communicate these things to your clients, hey, this is no big deal, this is no problem, this is a bunch of gibberish, do they always accept that?
Well, that's not the way I would present it, but...
Do they ever get upset about the gibberish in the pleadings, the offensive materials in the pleadings, regardless of whether or not it's going to impact their chance of success in court? It can be emotionally charged, can it?
Well, I would say annoying more than emotionally charged.
You would not say that divorce and child custody issues are emotionally charged?
They can be, but in this case, they weren't.
They weren't? How do you know?
From the pleadings, because I don't have 10,000 pages in front of me.
You're not in the mind of the people whose lives are impacted by these pleadings. It's not just about pieces of paper and a binder, is it?
I don't think that's what I said.
People's lives are impacted by the decisions that go on in court, which for you are routine. Would you agree?
In this instance, they reached agreement on all issues, so they had complete control of what was coming out of the court.
Ma'am, could you please answer my question? Are people's lives impacted in drastic ways by routine matters that we see in court as lawyers?
People's lives change after divorce, certainly.
So, like, I may think I've got a bag of stinky garbage, but the garbage man might not think it's stinky at all. Do you get the reference?
I don't.
What is no big deal to us is a big deal to these litigants, right? You can't agree with that. You can't agree with it. Strike the question. You were asked, let me ask you this. Let's go on to something else. Have you ever had people get murdered or commit suicide based on the issues that are going on in your family law litigation?
I've never had anyone murdered. I had in one instance a Middle Eastern person committed suicide just because there was a divorce, and that was shameful. So nothing was it was literally the day after the petition was filed, and he had threatened, if you file, I'm going to kill myself, and indeed he did.
And to you, divorce is not shameful, is it?
To me, divorce is not shameful.
Divorce is not a basis to commit suicide, is it?
Not according to me, but I didn't grow up in Iran or wherever this custom or feeling.
Exactly, Ms. Bailey.
derived.
To that person, it was a reason to commit suicide, right?
Apparently so.
aren't these issues raised in these pleadings potential fuel to make people upset?
Potential fuel to possibly make people upset?
Yes, ma'am. For example, you were asked about what we've called the grandma motion. You say, oh, it's no big deal, it wouldn't be granted, it was buried in there. But the allegation is, grandma is disparaging me to these kids, and I won't tolerate it, right? Couldn't that be upsetting to grandma?
You'd have to ask grandma. I don't.
Exactly.
It shouldn't have been. There was no proof.
It shouldn't have been, in your opinion.
In my opinion.
But in your opinion, divorce is no reason to commit suicide, right?
True.
Gibbers, according to the evidence in this case, means Jew in boots. It's not a flattering term by that definition or by your definition of someone that speaks gibberish. Can we agree it's not a flattering term?
No, it's probably not flattering, but I've seen far, far worse.
You've seen worse.
I have.
If Mr. Markel wasn't paying by the deadline, isn't that something that would be potentially upsetting to the parties or their family members?
I don't know how upsetting $80,000 would be. I don't know.
$80,000 is a lot of money, isn't it, Miss Bailey?
It depends on who you are.
Exactly. So we'd have to ask the parties, right? Right?
Sure.
Okay.
I think on that issue, he clearly had the assets. So at the end of the day, he was going to pay. It was just a matter of jumping through hoops to get the money.
He was either going to pay, or he was going to get sanctioned by the court, or he was going to end up in jail, right?
I don't see any possibility he was going to end up in jail.
Okay, well, you sat in the courtroom during Ms. Adamson's testimony,
I did.
didn't you? And Ms. Adamson said that that was one alternative, an extreme alternative, obviously, but that's what contempt means, right?
But that
ultimately.
Wouldn't even come into play until the motion for enforcement, and then he didn't abide by that, and then the judge asked him to do something else, and then he didn't abide by that. I think jail was pretty far-fetched.
Well, as long as he pays. Ultimately, the teeth is you go to jail.
No, that's not true.
It's not true. Okay. Ms. Adamson was incorrect on that point, I guess.
Objection, Your Honor. It's not a question that we would strike.
I'll rephrase it.
Was the objection again?
It's an improper comment on the witness's testimony.
Stay and please rephrase your question.
I said Ms. Adamson was incorrect on that point when she said jail was a potential option. Is that correct?
Well, I could break it down. There's two different matters in that financial motion on October 31st. Mm-hmm. One was the $70,000 still due to Wendi. Jail is not a possibility on that. But you don't send people to jail for failure to pay money. We don't do that. The $10,000 in fees to Kristen was more debatable because that could have been in the specter of support, and if you don't pay alimony or child support after repeated chances, I guess you could say, jail might be an option, but there's always a purge to that. So I've seen many times in child support, if you don't pay child support, then the judge says, bailiff, get Mr. So-and-so or whatever, and then all of a sudden he comes up with money out of his pocket and he pays and he never goes to jail. So you always have the key to the jail when you owe a support obligation. So technically, if he wanted to go to jail rather than pay Kristen the $10,000, eventually there may have been a hearing where that happened. I've seen one person in my career go to jail over child support.
Right, because they pay because they don't want to go to jail. If there was no jail and no consequences, they would never pay, right?
Some people wouldn't.
Right.
And that's just support. There's no jail consequence to the $70,000 due Wendi. It was only the $10,000 due Kristen that could have possibly remotely been a possibility.
Did you see evidence in this case of Wendi taking her mother's suggestions, cutting and pasting them into an email as her own, and then forwarding those questions to Ms. Adamson?
No, I didn't see any.
And did you see, in your review of the evidence in this case, Ms. Adamson responding to those questions and Wendi then forwarding those answers to her mother?
I don't recall that. I don't recall seeing that.
Did you review the communications from Donna Adelson, both in the form of email and text messages, that suggest that she was in fact extremely disappointed and upset about the outcome of the relocation motion?
I did. In probably the 5 days after the relocation, which was, say, 4 weeks before the ultimate settlement in July, there were a flurry of emails where she was obviously upset.
Did you review Mrs. Adelson's communications after July 31st that suggests she's consistently still upset about this?
I wasn't provided.
So you were, I'm sorry, finish your answer. You weren't provided any?
I wasn't provided after the flurry, right after the relocation, before the final judgment was entered in July of 2013. After July 2013, I don't recall seeing any emails from Miss Donna Adelson about the relocation.
Did you see any emails from her at all post-settlement?
Not until maybe December. It was a while. October maybe.
Okay.
Several months.
If Dan Markel had agreed to the relocation post-denial, post-stipulation, post, it could still happen, right? I mean, if he agrees, it could happen.
Sure, if he agreed, she could have relocated.
All right. And if he was murdered, it could happen, right?
Well, obviously.
So you categorized Dan Markel's pleadings in a lot of different ways: baseless, untrue, unenforceable, gibberish, nonsense, suggestion of unethical filings on the part of his lawyer to sign off on them. Are you saying, I think what you're saying is that those things wouldn't amount to much in court because it's not really effective filings. Is that what you're saying?
What I'm saying is his motions post July 31st were not based in the law, and I don't think that allegations about accounts he knew of not being on an early filed financial affidavit would amount to fraud, and it certainly wouldn't excuse him not paying what he was supposed to pay under the terms of the court order. And the motions related, the motion in March 26th related to parenting, he was trying to enforce things that weren't in the marital settlement agreement. There was no court order to make her do the things he wanted her to do. So there's no basis for the court to have granted his motion.
Right, so they weren't going to be successful. It's your opinion they weren't going to be successful.
Yes, that's my opinion.
But would you agree that the things he was putting in there are inflammatory?
I would agree that they were inflammatory.
And they potentially could make the parties or their relatives upset to read those pleadings and those inflammatory accusations.
Sure, nobody wants to read those allegations, true or not, about themselves in a public record.
You were shown a bunch of binders on a case. That case has nothing to do with this case, right?
No, it was a relocation case.
All right. And that case, was anybody murdered in that case?
No.
Okay, so if somebody had been murdered in that case, there might have been a lot less paper, right? Case would have been shorter if somebody had gotten murdered, wouldn't it, Miss Bailey?
If there wasn't a party, the case would have ended.
And if our case, we hadn't had a murder, we might have a lot more paper in our case, wouldn't we?
No, because the divorce was over in July.
Divorce was over in July, but they kept filing papers, didn't they?
Well, and the case was set for hearing May 15th, 2014. So the motion that Ms. Adamson filed in October and the motion that Mr. Markel filed in February, and then the motion he filed in March, were all set for hearing May 15th. And then Mr. Markel amped it up again, and on May 5th, he filed the motion that accused Kristen of fraud. So she had to withdraw, so they had to move that motion. So had that not been filed, they would have had a resolution on May 15th.
We don't know that. How do you know it was going to go on May 15th? Could have gotten continued for any zillion different reasons, couldn't it?
It was set for May 15th, and it was noticed for May 15th.
Set for May 15th, but at the time of Dan Markel's murder, litigation was still ongoing in this case. Yes? Yes. And even after that was resolved, there would be nothing stopping them from having a bunch of other time-sharing issues or whatever come up, and they might have ended up with reams of paper, right?
Objection, Your Honor, calls for speculation.
Overruled. The witness has provided an opinion. The state will cross-examine.
I guess my response to that would be, I think it would have been to Wendy's benefit to proceed with those hearings, because nothing makes someone stop filing nonsense pleadings and motions better than having them ordered to pay the other side's attorney's fees. So had they gone to the hearing on May 15th, and had Wendi have been successful, he would have very likely had to pay Wendy's attorney's fees. And I really encourage my clients in these situations to take it to hearing. So once the other side gets kind of slapped down, if you will, by the court and made to pay your fees, then they tend to back off.
But that hadn't happened yet.
It had not happened yet.
And we'll never know when that was going to happen, because we never got to that point, right?
Clearly.
Because he was murdered.
Clearly.
May I have a moment to confer, Judge?
Go ahead. Redirect examination.
Briefly, Your Honor. Ms. Bailey, you sat through Kristen Adamson's testimony earlier today, correct?
I did.
Did that in any way influence your testimony here this morning?
No, there was no new information.
Nothing further.
Will this witness be recalled at any point?
Potentially, Your Honor, but she's free to go about her business.
You remain under subpoena. Please do not discuss your testimony with any other witness in this matter. Have a good day. Members of the jury, at this point, we are going to take our lunch break. Once again, I will instruct you not to discuss your testimony with each other or any other person. Do not review or seek out any information outside from this courtroom. We will resume with the trial this afternoon today at 2:20. Please report by 2:15. Enjoy your break. Everyone can be seated. Any discussion that needs to take place concerning whether the defendant will testify does need to occur during the extended lunch break at this point. Are there any other matters that we need to address?
From the state, Judge.
Judge, I'm still hearing reactions from the gallery over my right shoulder during witness testimony. I heard it again after the court, cautioned the gallery again. I don't know what steps the court needs to take in order for that to stop, but the fact remains that they're doing this in front of the jury, could have an impact on the jury, and it could impact my client's right to a fair trial.
Well, this is a public trial. I cannot clear the courtroom. However, who do you believe you heard making comments or in some way doing something that was intended to distract the jury? That person can be removed. Are you able to identify them?
They're behind me, Your Honor. No, all I can identify is this coming over my right shoulder.
Please be seated. I want to make this crystal clear for everyone who is observing the trial today. Should I or the bailiffs in any way notice that you are engaged in a disruptive behavior that is intended to improperly influence the jury, you are going to be removed from the trial and subject to contempt. I cannot make this any clearer at this point. Please report back at 2:15. Once the jurors are assembled, we will continue with the trial. Ms. Desclazo, I believe, is still to be called by the defense.
Yes, Your Honor. Mr. Scalzo and Ms. Newhouse are slated.
Concerning the rule of sequestration, the remaining witnesses understand they are not to be in the courtroom.
I'm not aware that they have been, Your Honor.
Please scan the courtroom to make sure none of your witnesses are present so we do not have any continuing violations of the rule of sequestration.
I don't see any witnesses in the courtroom, Your Honor.
Please return at 2:15.
Well, just because they're not in the courtroom now doesn't mean they won't be in the courtroom when they come back. Oh my gosh. Wow. This trial, I'm telling you, Erin's just pumping out short after short after short. She's like keeping busy with the shorts. Holy smokes. What a day. What a day. All right. So cross on Miss Linda Bailey. Georgia gets up and she comes swinging. What is it that you were asked to do? I was asked to review the documents and opine whether it was highly contentious. Why would your opinion matter? Oh my God, I love it. What were you asked to do and why would your opinion even matter? It's like, why are you even here? Well, that's for someone else to decide, and I have a pretty good judge of all the trials all the cases that I've looked at. I'm a pretty good judge of that. But the parties only have experience with one divorce, and you have years of experience. So she was really trying to hammer that home, meaning Ms. Kappelman was trying to hammer that home. Do you agree with that? She's like, to some degree, that's why I called Adamson. So she goes on and on about if we as lawyers view things differently than what the layperson does. Somebody who comes to trial just once may view their case as one thing, but we as lawyers see this day in and day out. We, of course, are going to have a different opinion. So she was trying to get Miss Bailey to come around to that. If I received what Dan sent, my first reaction would be to call my client and say, hey, this is no big deal. Then Miss Kappelman asked, do they ever get upset at the gibberish? And Miss Bailey says, I would say annoying and not emotionally charged. And Miss Kappelman, they weren't emotionally charged. Why not? She's like, Georgia Kappelman was really getting into it. And Georgia continues, it's not about pieces of paper in a binder, is it? And then she's like, could you please answer my question? Are people's lives changed? Or do people's lives change? And she says, yes, they do. And then she goes, I might think I have a stinky garbage, but the garbage man might not think it's stinky. You can't agree with it, right? You can't agree with it. And then she throws up her hands. She's like, I'll strike the question. We'll just move on. Let's move on to something else. She asked, have you had someone get deleted? She's like, no, but once they did commit self-deletion the day after. They were from some Middle Eastern, the way she says it, some Middle Eastern part, some country. So to you, divorce is not shameful and not a basis to commit. But she's like, well, I didn't grow up in Iran or wherever this person was. So are these issues raise potential fuel to make people upset? Such as grandma is disparaging me to the kids. And she's like, well, you'd have to ask grandma. Exactly. So Georgia was just trying to get her to admit that what you find disparaging or what you find not disparaging or what you find as annoying or what you find as not annoying might not be the same for somebody else. You being a lawyer, your job is to be calm. Your job is to be neutral. I mean, you're on the side of your client, obviously, but you're also there to give them the best advice and say, hey, don't worry about it. We got you. This is not going to work. This is going to work. Whereas somebody on the other side may say, hey, grandma's calling me an idiot. Yes, Dan was a lawyer, but he wasn't versed in family law. So let's just throw Dan under the bus for the last 2 hours. So disrespectful. But I guess that's allowed in court, is to disrespect the people that are not there to be able to counteract. All right. So let's see. Is your opinion, let's see, gibbers means Jew in boots by the evidence. It's not flattering. She's like, it's probably not, but I've seen far, far worse. So even that, she can't even say that that's not flattering. So 80,000 is a lot of money. It depends on who you are. Dan was going to pay. He was either going to get sanctioned or end up in jail. She goes on and says jail was pretty far-fetched. So Ms. Kappelman says Adamson was incorrect on that one, I guess. That was objected to. So they kind of talk back and forth. So jail was the potential option, correct? And then she says, instead of saying yes or no, Ms. Bailey says, I'll break it down. We don't send people to jail for failure to pay. For Wendi, no. For Adamson, yes, because it bordered on child support. Did you see the evidence of Wendi taking Donna's suggestions and cutting and pasting? No, she didn't see that. Did you review communication from Donna suggesting she was extremely disappointed? She says she did see that. However, she didn't review communications after July 31st from Donna. She said she didn't review until October or December. If Dan had agreed to the relocation post the settlement agreement, then everything would have been fine, right? She's like, yeah, if he had agreed, then relocation would have happened. But if he was murdered, it could happen. And she's like, obviously. Dan's filing wouldn't amount to much in court. She says Dan's motions post July 31st were not a basis in law, and the allegations about the accounts wouldn't excuse him from paying. Dan put in inflammatory accusations that could have made a family member upset. So with the other case, no one was deleted. That had less paper, and the case would have been shorter. If we didn't have a murder, we would have had more paper. Or we would have had more paper, right? And she's like, well, the divorce was over. How do you know it would have ended May 15th? So again, she's making these assumptions that she's just making assumptions that because the settlement was on July 31st of the previous year, and that the last filing that Dan made was the 15th, doesn't mean he would have continued to make filings. But she says, and Miss Bailey says, well, it would have been to Wendy's benefit to proceed because it would have stopped the nonsense filing. So she's calling Dan's filings nonsense. All right, then as we were leaving, defense says they're still hearing reactions from the gallery and doesn't know what steps can be done. The judge says this is a public trial. I can't clear the courtroom, but that one person can be removed. So can you identify them? Defense Elman says no, but someone behind my shoulder. Judge says, let me make this crystal clear. You will be removed and you will be subject to contempt. Then he talks about the rules of sequestration. Why can't I say that word right now? Sequestration. Oh, I can't say that word. Sequestered. Sequestration. Wow, sequestered. I'm having a tough time saying that word. I gotta calm down. He asked the defense, please calm the court to make sure they're not here. He scans the court and he doesn't see any. All right, you guys. That was a very aggravating morning. That was a highly aggravating morning. All right, you guys, we have until 2:15, so you're going to get a lot of kitties. I got to feed them. I got to make food for myself. I got to make food for Erin. She's working on shorts. We have things to do. So I'm going to be back, and I'm going to put some music on, and then I'll get some kitty action going. So just give me a moment.
Abbiano scicare tu, davvero saporito, amami l'ammazzaro, povero cieco mio, chi me da voce via, pari a grandi nudi, scicare tu di lume al cuore, come io t'hai a scordare, scicare tu di lume al cuore, come io t'hai a scordare. Subito luce ascoltare. Quando cantava vagia io scicare tutti lume cori come io dai ascoltare. Abbiamo scicaretto davvero saporito a mia mila mazzato povero cieco mio chi me da voce via pari a grandi nudi scicaretto di lume cori come io tai a scordare scicaretto di lume cori come io tai a scordare. Quando cantava vagia io scicare tutti lume cori come io dai ascoltare.
All right, welcome back, everybody. Thank you for rejoining us. Trial should be starting any minute. They're at lunch until 2:15. Yeah, 2:15. So they're reporting back at 2:15 to start at 2:20. So we should be starting any minute. Let's see. All right, so Riker and Sid. All right, so Sid has the little mohawk. That's why we call her Sid. Sid Vicious, even though Sid Vicious didn't have a mohawk. But that's the first name that popped into my mind. So Sid has the little tuft. Hold on, let me get her. So this is Sid with the little tuft of tan on her head. So that's Sid. So Riker does not have that. Yikes. So Sid has that little tan tuft. So JRN also never gets Sid and Riker right. Also, Riker has darker boots, I think. Right here, they're messing around with each other right now. Let me see if I can. So this is the two of them right now. So
Sid's on the outside.
Yeah. So Sid is on the outside there. She has her little paws are a little lighter. And I think just overall she's a little lighter too. Yeah. Meaning, yeah.
Riker's
more
black
tan.
and white.
Yeah.
She has like tan on one arm here.
Yeah. So Riker's in the basket right now and Sid is right there. So all right. Shrink back down. All right. What are you guys talking about? You like the mic? Yeah, Sid is a little bit lighter. Yep. So let's see, which is the darkest little one? Riker is a little bit darker. Yes. Yeah, it's a fun mic, right? Changes. If we have a Mac and if we had a PC, I could make it stay a certain color, but because we have Macs, it just kind of goes in and out. So. Okay, so Chris, the third grayish one is Houdini. She's Houdini. She was actually, I think, one of the first ones to be named because she was always escaping. She was the first one to escape, so we called her Houdini because she was like the little escape artist. Yes, Kate, Riker was the firstborn. So Will Riker, Star Trek, Will Riker, number 1. It seems like they were forever ago they were born. They were born June 5th. So June 5th they were born. So we're looking at 3 months. So June 5th they were born. So as far as weeks are concerned, 1, 2, 3, 4, 5. 1, 2, 3, 4, 5. 6, 7, 8, 9, 10. Hold on a sec. 1, 2, 3, 4, 5. 6, 7, 8, 9, 10, 11, 12, 13. There'll be 13 weeks tomorrow as far as weeks are concerned. But if you just go the 5th to the 5th, so 1, 2, they're 3 months. But they're 13 weeks or 3 months. So, Kate, you remember that day? I know. It was an amazing day. Yeah, it was one of those moments you remember forever. Aaron was texting me. We were streaming and I saw that Polly was starting to go into labor, but I had to come and deal with a stream. And Aaron's texting me, we got the first one. So I ran in and saw, we got the second one, third one. So it was Riker and then Roger Federer was next. And then we're not quite sure if it was Houdini or Sid were next because they were both pretty dark. So we're not quite sure which one was after that. It was a Thursday. Yes, we will be, Betty. We will be. Yes, Houdini, Deanie, that's a good nickname. Mallory, yes, seems like yesterday they were all blind in a box and we were all obsessing, making sure they were all nursing. I remember Mallory. Sounds like court is back. Okay, they put that mic on in the room. What was I saying? Oh, the very first time we did Kitty Cam, I remember we were watching them, and they were like nursing, and like some were like over here and some were over here, and we're like, oh, can you just please go over and nurse, please? They're gonna die. They're gonna die. And then I remember one time, I think it was Fed. He was nursing, and then Paulie flopped over, so he's on her back, and he's just flopping around trying to find her stomach. And I remember we were in chat, you know, if you guys were watching that, we were like, oh my gosh, is he gonna be able to, is he gonna survive? You know, I mean, they were just like, we streamed that weekend, I think, because they were born on Thursday. I think we streamed that Saturday and or Sunday. And then we streamed, I think, the following weekend too. So they were so cute, so cute. Excuse me, Kelly, yeah. That last defense witness was hard to take. I agree. I got very upset at that. Sure Life, well, I guess we will be here in a minute whether Donna will testify or not. They were supposed to decide at lunch. Judge will be asking next. Actually, they were only to decide what witnesses they were going to call up. So he was supposed to have 4 witnesses in the morning. He only got through 2. So he still has to go through 2 more witnesses. So this morning, Mr. Zellman said, let me get to it. Gosh, so much happened today. My notes are like, sometimes I don't take any notes. Well, hardly any. And other times it's just like, all right. So he hadn't had a chance to prepare his list. This is Mr. Zellman. So in the morning, he named 4 witnesses. So he still has 2 more witnesses to go. And then he said the afternoon is up in the air. That's why Judge Everett is giving him the hour-and-a-half lunch break. So he still didn't have his witnesses up. So he's technically 2 witnesses behind because he was supposed to have 4 this morning, and he only got through 2. Yes, Paula, they have 2 more. Will Donna testify? We should find out soon. Yeah. Well, they've gone through 10. They have 2 more, which would make 12. And how many did I say they have on? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31, 32, 33. They have roughly 33, but they've got custodian of records. Then they have all witnesses identified by the state. They're not going to call all of them. So they have about 30. They also have Bryce Google, who they talked to already, but they didn't really. The judge just asked them some questions. So they've gone through 10. Theoretically, well, if he had his say, he would have gone through 12 already. But they still have 2 to go for the morning, which obviously is now the afternoon. Sorry. Yes, Tanika's 2 cents had that, Michelle. Charlie is in town, watch the transport. I think that was like from the 18th, right? Wasn't that from the 18th? Mo Freedom, last witness, was not an actual witness. She was a Donna defense advocate. Sinbad, Kitty Cam saved my brain during the Karen Reed trial. Nice. Yeah, Lori, no more Wendy's for Charlie. Last meal, buddy. Wasn't that weird that they stopped off at a Wendy's? Did you guys watch Jay at all? J-Bo? He was saying Charlie's eating Wendy. Poor joke, but John, what trial are we covering next? We have got a fantastic new trial coming up. It's sad. All trials are sad. I say fantastic because we know people. Let me just put it that way. We know people. I'll just leave it at that. It starts, jury selection is right now. It's in Tampa, and it's going to start Monday. They're going to do 3 days of jury selection. It will be televised, so I'm very, very excited about it. I'll tell you more about it once more information comes in to me. Michelle, I watched it on Tanika and saw him eating his chicken nuggets. Yeah, we watched it too. Tanika's great. If you guys don't know Tanika's 2 cents. She's great. We did a stream with her and Joe Schmo and Florida PI Sam. And Florida PI Sam's another one, you guys. If you guys don't know Florida PI Sam, check her out. Check her channel out. Sherry, the judge did say he needs to know if Donna will testify. So he said that, so he needs to know it now. Interesting. I thought the judge gave them extra time at lunch to talk to Donna if she will testify or not. I may have missed that then. I guess I missed that. I'm just going off of what my notes said from this morning. Sure Life, I want to see Georgia cross Donna. Ooh, here we go. Here comes the judge.
All right, 2 matters to briefly address before we bring the jurors on. The first concerning the waiver of attorney-client privilege as to the testimony of Mr. Scalazzo. I am going to need to place the defendant under oath concerning this. Ms. Adelson, please rise. Raise your right hand. Raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth?
Yes.
You can lower your hand. You understand with your former, or I guess I don't know the relationship exactly, but someone who has previously represented you, concerning their testimony today, are you waiving attorney-client privilege concerning what they will testify about?
Yes, I am.
Concerning that, Mr. Zellman, do you wish the court to make any further call to it?
Yes, Your Honor. The waiver is specific as to the counsel that our client received from Mr. Scalazzo.
Well, if you need to discuss with her what she's waiving, that's fine. I don't believe you can waive on her behalf. Mrs. Adelson, do you understand the scope of the waiver that you're providing? Do you understand the scope of the waiver that you're providing of attorney-client privilege?
I do, Your Honor. What
is that scope?
The information that we discussed after my son's trial regarding my travel and my state of mind.
Is the defense planning to examine this witness on any other topics than what has been identified as the scope of the waiver?
No, Your Honor.
Very well. If any matters are inquired into that exceed the scope, at that point, we are going to have to send the jury out of the room. As I previously stated before, the state is permitted to cross-examine as to all topics that are inquired to on the defense direct, and also as well matters of impeachment and bias. Does the state need to be heard in any way?
Yes, sir.
As to the other matter concerning whether Mrs. Adelson will testify as a part of the defense case in chief, Mr. Zellman, were you able to speak with her as to a final decision?
I'll allow, the short answer is we were allowed 20 minutes during lunch break to speak with Ms. Adelson.
In addition to the time that you had yesterday and other times?
Yes, Your Honor.
If I may, Judge, the issue is that we...
Well, one moment. Who's handling this matter? We're not tag teaming any arguments of any sort.
Your Honor, what Ms. Fulford and I had discussed was the factual issues that are concerning our client's decision. She was more involved in than I was. So the only thing that I intended to address was the time that we had during the lunch break. Aside from that, I'm asking that Ms. Fulford be allowed to address the court.
Ms. Fulford, go ahead.
The issue that we're facing, Judge, is this was 6 days of testimony from witnesses for the state and a great deal of evidence that they have entered. We have discussed with our client, of course, her right to remain silent or whether she wants to testify or not. We have not had an opportunity to go through all of the evidence that's been entered in this case and have a full and frank discussion with her about that evidence. If there are any issues that she thinks need to be addressed for her testimony, whether she thinks she needs to testify or not, and what her decision is on that.
When we had the break yesterday at 2:45 in the afternoon, you did not speak with your client concerning whether she wished to testify or review
Absolutely.
the evidence?
Yes, Judge, and that's what I said. We have discussed with her whether she wants to testify or not.
The defendant in every single case, Ms. Fulford, is faced with this moment as the defense case in chief ends. What are you asking for?
I'm asking for additional time to be able to go through all of the testimony and evidence with our client so that she can make a fully informed decision as to whether she wants to continue to remain silent or testify in this case.
Ms. Fulford, concerning that has been provided by the court. If she wishes to testify, we do need to go through the colloquy. If she does not, it's a simple matter. But there has been time pre-trial to prepare for this moment. There's been time during trial, and specifically, we recessed court early for you to address any issues of witnesses or whether your client would testify.
Yesterday, when you allowed us to recess early, Judge, Mr. Zellman and I spent time going through the evidence that was admitted, making sure that we understood everything that was there, because there was some confusion during the trial about things being added and things being removed, so we wanted to make sure we understood completely what there was there. We left here, went straight to the jail, and had the issue with the potential new witness and spoke with our client. But that's not an ample time to discuss with her what has actually come in the state's case.
Your client is in a no different position than any other defendant who has to decide whether they wish to testify or not. I will give you 5 additional minutes to discuss this matter. From there, the defendant is going to have to make a decision whether she is going to testify or exercise her right to remain silent. Please check with the jurors. Let them know that we will get started momentarily.
All right, how many times have I said this? This trial just keeps just offering things that are just what? Every single day, every single moment, it's just like, what? All right, so the judge comes back. We have 2 matters to discuss. The first is for the next witness, waiver of attorney-client privilege, and he then places Donna under oath. This is involving your former representative concerning their testimony and waiving of privilege. So Zellman says the waiver is specifically to, the judge interrupts him, and those two speak together. He asks Donna, do you understand the scope of the waiver? She says, I do. He says, what is it? She says, the info we discussed after Charlie's trial and him traveling to Florida. So the second is, will Donna testify? The second matter is, will Donna testify? Mr. Zellman says, well, we were allowed 20 minutes to speak at lunchtime. Judge says, well, in addition to the time yesterday and all the other times. And Fulford jumps in and she says, Your Honor, and the judge is like, whoa, we're not tag teaming arguments. Who's going to address this? To which Zellman says, Fulford was more involved than I was. So then Ms. Fulford jumps in. The issue is this was 6 days of testimony from the state, and they presented a great deal of evidence. We've talked about it with Donna and haven't had opportunity to go through all the evidence. The judge says, well, we broke yesterday and you didn't talk to Donna then? And Ms. Fulford says, yes, we did. Then Judge Everett says, well, what are you asking for? She's asking for more time to go through the evidence so Donna can make a full decision. Judge Everett says that has been identified and there has been a pretrial. You've had chances during trial. You've had court recessing early. So Ms. Fulford says, yesterday we spent time going through the evidence because things were added and removed. We went straight to jail and then we had issues with this witness. The judge says, well, Donna is no different. She's in no different position than any other defendant. You get 5 more minutes to decide. Wow. JMS, I don't think the jury knows. We want to think that they are, but to be quite honest, I don't think they know.
The response from the audience concerning things that are said by the defense. And although the proceedings are public, that has not stopped Peanut Gallery from their comments and laughter. We are respectfully requesting that the court allow Ms. Adelson to participate at sidebar as she is entitled, and for the court for us to address additional issues that are weighing on Mrs. Adelson's decision.
Please approach. We are not going to do this for very long.
All right, so he's calling them the Peanut Gallery now. So Zellman says, things that are being said by the Peanut Gallery and laughter. We respectfully ask Donna to appear at sidebar. Additional issues that are weighing on Donna for her to decide. Judge says, well, approach. We are not going to do this for very long. And then they go to a sidebar. Go into the sidecar. What do you guys think? Well, she has the right, Mo Freedom. She has the right. We've seen that multiple times. You are allowed to go to the sidebar. We've seen Murdoch did that. I think Ashley Benefield did it. Todd Mullis, I think, did it. Yeah, I mean, we've definitely seen it. It's not unusual. He wants her to go to the sidebar now because what they're talking about specifically concerns her. Not that this entire trial doesn't, of course it does, but right now this specific thing concerns her because it's whether she's going to testify or not. So stall some more. Jaded says, Alice, they are stalling, but why? Karen, Donna could have gone up for the sidebars all the time. Yeah, absolutely. Shay says the jury is not hearing any of this. No, they are not. GM, who are they accusing of laughing? The Peanut Gallery. Yeah, the Peanut Gallery. Somebody in the Peanut Gallery. Psychosaurus Rex. We're peanuts. Yes, we are peanuts. They're laughing at the lawyers, Shirley. That's pretty much what's going on. Yep, Karen went up for the sidebars, Clarinet Girl. Yep, Karen went up for the sidebars. But not all of them, right? I thought she stayed in on a couple of them. Maybe not. All right. Barry, yes, Jackie and Zellman, you go ahead and arrange those deck chairs on the Titanic. Stephen Roger, who's the Peanut Gallery? Lucy, Snakes Will Hiss, good to see you. They are laughing at you, pair of jokers. Little country, little hood. Did I get that right? All right. Anyway, why does she need headphones for sidebar? That's a really good question. Why does she need the headphones for the sidebar? Oh, because they're whispering, and she is hard of hearing, so they're probably whispering. Ken says trial may take 15 years. GM, they are like kids in a playground. Sparkling Princess, just another few minutes for her to decide. Who's he referring to? Somebody in the Peanut Gallery. He doesn't know who. He says it's just coming from behind his shoulder. He hasn't specifically said. Drama Donna has lackluster attorneys that are running in the negative. Let's see. Karen did go. I didn't really watch the second one. So, Joanne, proud member of the Peanut Gallery. This is the oddest defense case I've ever seen. I agree, Golden Girl. This is, yeah. To quote that great lawyer up north, yeah. What is a Peanut Gallery, Betty? Basically, just a bunch of people that it's a derogatory name, word, phrasing, It's not like terrible, but it basically just means a bunch of, bozos. Peanut gallery in the days of vaudeville, a nickname for the cheapest and ostensibly the rowdiest seats in the theater. So basically it's the cheapest seats, the most rowdy. It's like the bleacher seats in baseball or football. It's the peanut gallery. So what does it mean in slang? It's a group of uninformed or critical spectators whose opinions are considered to be of little value. So it stems from the peanut gallery, which was the cheapest and most distant. So yeah, when people say I don't want to hear from the peanut gallery, they basically are saying, you're uninformed, you're a bunch of mokes, that kind of stuff. So Woke's joke, I'm in the cashew gallery. I like cashews. I'll go for that. We are, hold on, basically saying the idiot sitting behind me. That pretty much sums it up, Mallory. Heather, we are being gibbers. Little country, they used to throw peanut shells at the stage. Yeah. Among other things, right? Onions, tomatoes. How rude. Ed, that sounds like chat. Oh, hey, Ed, we're watching The Son of Sam, David Berkowitz documentary. And Aaron looked up all the prolific serial killers in history. And of course, your name came up. D, basically the less thans. That pretty much is it. Basically the less thans. GM Stewie, thing is, if she was innocent, she really wouldn't need to prepare much. Insignificant is what it means. Psychosaurus Rex, that's the second time vaudeville has been referenced today. Ooh, what was the first time? I missed the first time. Bella, thanks for the explanation. I never knew. Yeah, if somebody says a peanut gallery, I used to say it. I had it said to me. For me, it was just like a joke, like somebody's like razzing you, like, somebody's calling you a bozo. It's like you're not being called a terrible, terrible word. You're just being joked upon. And it was never, to me, it was never like, you a-hole or you MF. It was just like, I don't want to hear from the peanut gallery. So I personally never took it anything other than, you're just being, just basically shut up. Woke's joke, peanut gallery watchers and Monday morning quarterbacks, totally. Yeah, Son of Sam, good doc. We're 2 of 3. We've watched 2 of the 3 episodes. I remember that as a kid. I remember David Berkowitz. I found out his real name yesterday. David Berkowitz, he was adopted. I'm finding out all kinds of things from this documentary. But I remember that. I remember Son of Sam. I remember the summer of 77. It was, and 76 it started, but summer of 77. It played a part in my growing up. CCGTV, feel for these lawyers. Not all money is good money. That is true. Sinbad, yeah, the bus stop people for Maya, for sure.
You can bring the jury. Everyone can be seated. Members of the jury, I hope you had a restful lunch break. We are going to continue at this point with the defense's case. Please call your next witness.
Before we call our next witness, we laid the foundation through Luis Rivera for Defense Exhibit 50. At this point in time, we'd like to introduce that into evidence.
Any objection from the state?
No, Your Honor.
Defense 50 is admitted.
Thank you. At this point in time, the defense would call Marisol Descalzo.
Please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth?
I do.
You may be seated.
Thank you.
You may inquire.
Thank you, Your Honor. Good afternoon, ma'am. Can you please introduce yourself and spell your last name for the jury?
Marisol Descalzo. My last name is spelled Descalzo.
And Ms. Descalzo, can you tell us how you're employed?
I'm an attorney,
Okay, what type of attorney?
a criminal defense attorney,
And how long have you been practicing?
since 2003.
During a period of time ending shortly after her arrest, did you represent Donna Adelson?
Yes, I represented her sometime in 2022 through maybe 3 months after she was arrested.
Okay. And I want to direct your attention specific to the late October and beginning of November of 2023. During that time period, was her son on trial?
I'm not sure about the dates, but it sounds about right.
Okay. During that time period, when her son was on trial and shortly after, did you have some concerns based on statements that she was making?
Concerns about Mrs. Adelson's mental state, yes.
Yeah. Can you tell us what those were?
She had made numerous statements about terminating her life if her son, Charlie Adelson, was convicted.
Did that cause you to take any steps or actions to determine what you needed to do?
Yes.
And what were those?
Well, first, I conferred with Daniel Rashbaum, who represented Charlie Adelson. So we discussed it, and we decided that we needed to call Ethics Council and call the Florida Bar to determine if we needed to take any additional steps, such as Baker acting her, or Baker acting is putting her in a mental institution, or anything else.
Okay. After doing that, did you have further discussions with Mrs. Adelson about her mental state and what she was going to do to try to clear things up?
Mr. Rashbaum and I spoke to her further, and, you know, she told us that what she really wanted to do was she wanted, to get away on a vacation with her husband. Her husband agreed that this would be good for her mental state, and so we discussed a potential vacation.
Okay. At that point in time, was there anything preventing Mrs. Adelson from traveling?
As far as Mr. Rashbaum and I knew, there was not.
Okay. And specifically, there were no warrants for her arrest?
My understanding from speaking to Mr. Rashbaum, that Mr. Rashbaum had communicated with law enforcement and that there was no outstanding warrant. I had been in touch with the prosecutor of this case, and I apologize because I only remember your first name, but with Georgia. And we had discussed previously, not around this time, we had previously discussed that I represented Mrs. Adelson, so I assumed that if anything would happen, that if there was a warrant or if Miss Adelson was going to be arrested, that I would be contacted.
Did you advise Mrs. Adelson that if a warrant was issued, that you would provide her with that information so that she could self-surrender?
So the discussions I had with Mrs. Adelson weren't exactly like that. Mrs. Adelson discussed what would happen if there was an arrest warrant, and the potential things that might happen. The prosecutor had never guaranteed for me that Mrs. Adelson could self-surrender.
Okay. Did you tell her did you tell Mrs. Adelson that self-surrender was something that could happen?
Yes, I did.
Okay. And on November 6th, her son was convicted. Did you speak with her after that, specific as to her ability to travel?
I don't remember the dates, but there was discussions about her traveling after the conviction, because around that time was when she was making the serious threat, was when Mrs. Adelson was making these serious threats about her life.
Just a moment, Your Honor. Nothing further, Your Honor?
Cross-examination.
Yes, sir.
Good afternoon.
Good afternoon.
Now, if someone has a warrant, is it up to the defendant or the suspect, the person who has the warrant, to dictate their terms of surrender?
I don't think so. It's up to the law enforcement.
It's usually up to law enforcement to decide how or where to apprehend that person, right?
Yes.
But, so it's not a requirement of law enforcement to notify someone when they have a warrant, but that is sometimes a courtesy that's extended, is that right?
That's correct.
And that is a courtesy that's sometimes extended in situations where, let's say, someone is not a flight risk, right?
It's in all sorts of situations you can have self-surrender extended to, I wouldn't limit it to only people that are not a flight risk.
Okay, would that be one situation?
I would assume so, yes.
Okay, and you were told that by Georgia, by Ms. Kappelman, that you wanted to know whether she had a warrant, she could turn herself in. That was some amount of years ago?
It was before, definitely before Charlie Adelson was convicted. It was on a phone call that I had. I offered it, and as I stated, Georgia Kappelman did not guarantee that.
Okay. But that was before Charlie's trial or verdict?
Correct.
Okay. After the verdict, or I guess during the trial or after the verdict, did you disclose to anyone in the state attorney's office that Ms. Adelson was suicidal?
Of course I didn't.
Okay.
No, I had an attorney-client privilege relationship with her, and I don't think that would have been appropriate.
Sure. And why was she suicidal?
Because her son had just been convicted, and she was worried he was going to spend the rest of his life in prison.
Was she also worried about getting convicted herself?
I don't believe that was even crossed her mind. She was only worried about her son.
Okay. Are you aware of a text message where she said that she was afraid she was next, but don't worry, she would take care of that?
I'm not. I'm sorry. Was that a text message to me, or?
I don't believe so.
Yeah, I don't have any knowledge of that.
Okay. At the time of, were you present when Dan Rashbaum told her that she may make it to the airport in time, or she may get to the airport and not be able to make it out?
Mr. Rashbaum and I don't believe that was a telephone call. I don't believe that was in person. And I was on a call, and I myself also told Mrs. Adelson that we did not know whether there was, that we understood there wasn't a warrant, but that didn't mean she couldn't get arrested at the airport.
Okay. When you suggested, I guess, was the suggestion that you said that she take a vacation?
I don't believe I suggested it. I believe that that's something that was being discussed between Mrs. Adelson and her husband as something that would help her with her mental state.
Okay. So that's something they suggested, but not you?
Correct. I did not suggest that they take a vacation.
Okay. Did you know at the time that the vacation that they were suggesting, they were considering Vietnam, China, or Korea?
I did not know the location of where they were going.
Okay.
And it was never discussed with me.
So at that time, you didn't have knowledge that they were specifically looking for non-extradition countries?
I did not know one way or another where they would vacation to.
If Donna Adelson was overheard by law enforcement debating between either committing suicide or fleeing to a non-extradition country, do you think that would change law enforcement's stance that she could turn herself in?
Objection. Your Honor, calls for speculation.
Overall, the witness has opined on this matter.
I'm not law enforcement, so I'm not sure, and I've never been in law enforcement, so I'm not sure.
I can rephrase it. Would you expect that to change the stance?
If I was law enforcement and I heard a target of investigation discussing a flight?
As her attorney,
Okay.
would you expect if she's overheard debating either committing suicide or fleeing to a non-extradition country that she wouldn't be expected to be able to just turn herself in on a warrant again after that?
I don't know. I think it would take, to be honest with you, I'm a criminal defense attorney, so it would be case by case. Probably that would make the bond hearing a little bit more difficult if those conversations were overheard. But every prosecution is different, and maybe the prosecutor would agree. I don't know.
Okay, 1 second. Specifically, though, about self-surrender, would you expect that to change law enforcement's stance as to self-surrender, not as to a bond?
Again, I think that that's specific to each case, and I don't know exactly what was overheard, so I apologize, but I don't really have a concrete answer for you, other than what I said before, that it would come up at a bond hearing.
Thank you.
Redirect examination.
Thank you, Your Honor. Mr. Scalzo, prosecutor asked you about fleeing the jurisdiction. My client talked to you about a vacation, correct?
That is correct. It was not fleeing the jurisdiction.
And the state also asked you about fleeing or going to a non-extradition country. Have you, in your career, dealt with extradition from foreign countries?
Yes, I have.
Okay. And merely because someone is in a non-extradition country, does that prevent the United States from attempting to seek their return or their extradition to the United States?
It absolutely does not, especially if you're a U.S. citizen.
Nothing further.
You may step down. Is this witness going to be recalled for any purpose?
No, Your Honor. I believe she might be able to get the early flight this evening.
You are released. Please call your next witness.
Just a moment, Your Honor. Defense would call Sarah Newhouse.
Please come up to the witness stand. Raise your right hand now. Do you swear or affirm the testimony you're about to give will be the truth?
Yes, sir.
You can take your seat. Please speak loudly and clearly. You may examine.
Thank you, Your Honor. Good afternoon.
Good afternoon.
Can you please introduce yourself to the jury?
Yes, my name is Sarah Newhouse, and I am currently the Behavioral Wellness Coordinator for the Police Department. Back in 2014, I was the victim advocate.
You're a victim advocate for the Tallahassee Police Department?
Yes, sir.
Okay. And in your role as a victim advocate, what does that entail when you work for the police department?
Typically, it's following up with victims that are victims of crime, usually persons crimes, homicides, suicides, sexual batteries, domestic violence, things of that nature. And it's providing support, kind of being a middle person between them and the police investigation team.
And in that role as a victim advocate, were you working on July 18th of 2014?
Yes, I was.
Okay. Did you have occasion to get assigned to be the victim advocate for Wendi Adelson?
Yes, I did.
And were you present for the vast majority of her interview with law enforcement?
I was.
Were you also present when Wendi Adelson called her mother, Donna Adelson, towards the end of that interview?
I was.
And did you have an opportunity to listen to the portion of the interview where Wendi Adelson called her mother?
I did.
And I'm going to show you what is marked for identification purposes as Defense 71. Did you have an opportunity to listen to this exhibit?
I did.
Okay, and is the portion of the recording true and accurate reflection of what you remember from July 18th of 2014 when Wendi Adelson called her mother?
It is.
Okay. When Wendi Adelson called her mother, do you recall Donna Adelson's reaction to being told that Dan Markel had been shot?
Yes.
Okay. Did this upset her?
She sounded shocked, I guess would be the word that you'd say.
And it appeared that this was the first time she was hearing about it?
Yes.
And did she make any statements that you could hear from where you were sitting?
I don't recall if I could hear other than reviewing the video, but it sounded like a normal amount of upset given a crisis situation.
Your Honor, at this point in time, I move into evidence Defense 71.
Any objection?
Judge, I haven't reviewed this exact item, but based on what the defense has represented to me is on there, I don't have an objection. I do want to review it on the break and reserve the right to object. So subject to that objection.
A lot of qualifications.
Well, there's just...
Members of the jury, we're going to take a brief break. The bailiff will take it to the jury room. You can be seated. If anyone needs to stretch their legs or use the restroom, please do it now.
This shouldn't take long because it's like maybe a 2-minute phone call. It's pretty quick. Pretty quick. So first up was Maricel Descalzo. She represented Donna in 2023. She had concerns about Donna's mental state. Donna had made numerous statements about terminating her life if her son was convicted. So she conferred with Rashbaum. They called the Ethics Council, the Bar Association. They were thinking about Baker acting Donna. Donna wanted to get away on vacation with Harvey, and he said it was a good idea. There were no warrants, and Rashbaum had talked to law enforcement and thought it would be okay to leave. They talked to Don about the self-surrender. November 6th, Charlie was convicted, and she spoke to Donna about traveling. So then cross, it's up to law enforcement to decide where and how to apprehend. You don't have to be notified by a warrant. Like, who gets notified? It's kind of like just a courtesy thing. You don't have to. How many people are served warrants and never told? I mean, come on. Donna Special, she needs to be notified. Was she? She was going to self-harm herself because of Charlie. She only worried about him, and she was not worried about herself being convicted.
It includes Wendi Adelson saying this was the worst day of my life before the call connects, and then it includes the witness telling Ms. Adelson she did an awesome job on the call after the call disconnects. So I would object to those two comments. I'm fine. I understand I don't intend to publish it right now, so subject to those objections, no objection to the exhibit once those things are removed.
As I indicated to Ms. Dugan, when Ms. Kappelman was watching it. I got to remember how I snipped it, but I don't have a problem removing the comment before and the comment after before it's published for the jury.
That defense 71 will be admitted. The proper redactions will need to be made. You can bring back in the jurors. Everyone can be seated. Defense 71 is admitted at this time. You may continue with your examination.
I have no further questions for this witness, Your Honor.
Cross-examination.
Did you hear any weeping or wailing going on at the other end of the phone during this phone call?
Not that I recall, no.
Did you know Donna Adelson?
No.
Have you ever met her?
No.
So you don't know what her normal demeanor is like?
Correct, I don't.
Okay. But Wendi Adelson, her daughter, presumably does know?
Correct.
And do you remember Wendi Adelson making the comment after that phone call that she handled that well?
Objection, Your Honor. That's hearsay. That's exactly what was asked to be removed from the report.
Please sit down. As to the hearsay, sustained.
No further questions.
Redirect.
Your Honor, move to strike the question from Ms. Kappelman.
Members of the jury, you are to disregard. The last question of the prosecutor is to be struck from the record. You may step down. Will the witness be recalled?
No, Your Honor.
As to your exhibit, do you wish to publish or just leave in evidence?
Not at this time, Your Honor. I do need to make the edits that were requested outside the presence of the jury so that it removes the two references. That could just take a few minutes.
Well, the jury will have a brief break. The bailiff will take you to the jury room once again. Everyone can be seated. Please make all necessary redactions and changes at this time.
No, not a recess. Zellman. Mr. Zellman is making edits. And he's talking in, let's hear what he's saying. I don't know why they're not letting us hear that. All right, Mr. Zellman's making changes. So the state wants him to take out, wait, hold on.
If there are no other witnesses for the defense, it is time for the decision to be made.
I can tell the court that co-counsel and my client are deep in conversation. I'm sorry,
I am capable of seeing that, Mr. Zellman. No narration is needed. Mrs. Kappelman wants the defense rest. Is the state intending to place or put on any rebuttal case?
I think not. If they rest without calling any further witnesses, that could change if Mrs. Adelson decides to testify.
Very well. At this point, I do need a decision. Mrs. Adelson, please rise. You've been placed under oath earlier this afternoon. Mrs. Adelson, I will advise you concerning your rights. You understand that you have the right to remain silent, and the jury will be instructed that your silence cannot be held against you in determining the merits of this case. Do you understand this?
I do understand.
Do you also understand that you have the right to testify as a witness in your case in chief on your own behalf?
Yes, Your Honor, I understand.
You understand if you do choose to take the witness stand, you will be cross-examined by one of the prosecutors.
Yes, I'm aware of that.
You understand that your credibility will be placed before the jury like any other witness.
Yes, Your Honor, I understand.
Have you been able to discuss with your attorneys the two rights that the court has placed before you?
Yes, we've discussed the rights.
Concerning those rights as to whether you will remain silent or whether you will testify, have you made a decision concerning this matter?
I haven't. I'm not prepared to make that decision. This decision affects the rest of my life.
Mrs. Adelson, you're in the same position as every other criminal defendant who faces trial. Ultimately, you must decide whether you will testify or whether you will not. I cannot make you testify. Your attorneys cannot make you testify. But ultimately, you must choose whether you will testify or not.
I don't have to choose. I was hoping I would have some time to speak to my attorneys.
This has already been discussed, ma'am. What is your choice?
Judge, since I was handling prior witnesses while Ms. Fulford was speaking with Ms. Adelson, can I have a few minutes, please?
What exactly are we going to accomplish that we have not been able to since the trial started, pre-trial, the long recess yesterday, or even the lunch break today?
That's what I'm trying to determine, Your Honor.
I will give you exactly 5 additional minutes. From there, Mrs. Adelson has to make a decision whether she will testify or whether she will not.
Thank you, Your Honor.
If anyone in the gallery needs to use the restroom or stretch your legs, this is your opportunity at this point.
All right, we got a new poll. Will Donna testify? Yes or no, will Donna testify? So, we heard from Sarah Newhouse. She's a victim advocate. She was assigned to Wendi. She heard the call from Donna, or to Donna, I should say. Donna's reaction, she sounded shocked. Appeared to be the first time she had heard about Dan. The state has no objection, but they haven't reviewed it yet, meaning Ms. Kappelman hasn't had a chance to review it yet. So the jury left. The state says, well, it includes Wendi saying this is the worst day of my life, and the witness says you did a great job. Defense, Zellman says, I don't have a problem removing those comments before the jury hears it. So the jury comes back in, And then cross. Did you hear any weeping or wailing on the other side? No. She had never met Donna, so she doesn't know how she sounded normally. Wendi says, Mom handled that well. Objection. That's exactly what they said they wanted removed. So then defense moves to strike that last comment from the state. Judge strikes that from the record. And then the defense, Selman, wants to make those 2 edits outside the presence of the jury. So the jury leaves. Jury left. Jury comes back. Jury leaves. Jury comes back. So then Fulford and Donna were talking to each other, and Mr. Zellman's like, my co-counsel and client are deep in conversation, to which Judge Everett says, I can see that, and no other narration is needed. Oh my God, this is just unbelievable. For those that said this was going to be Charlie 2.0, I challenge you on that. This is way better than Charlie 2.0. There were people out there that said, I'm not going to watch this because this is just going to be Charlie 2.0. To which I say, boy, you guys were wrong. All right, so then they talked. Then they kind of went no audio for a little while, and then it came back, and they were talking about the state resting. So the judge says, "Will the state put on a rebuttal if the defense rests?" And the state said, "I think not, but it could change if Donna testifies." So then the judge says, "I need a decision. Miss Adelson, please rise. Have you made a decision yet?" She says, "I haven't made a decision. I haven't had a chance yet, and this could affect the rest of my life." And the judge says, "Well, you're in a position just like everyone else." She would like more time. So the judge says, defense asks, "Can we have a few more minutes?" Judge asks, "What will that accomplish now?" Mr. Zellman says, "Well, while I was doing the edits, Ms. Fulford and my client were talking, so that's what I'm going to try to determine, what this will accomplish." So Judge Everett said, "Very well, I'll give you 5 more minutes, and then we need a decision." Wow. Just a text in, I wish Judge would hold her in contempt. Crazy Mary Jo, Donna is wanting to talk. Thank you for your $1.99 support. Appreciate that. Donna is wanting to talk. They had wait. Green Eye Cat, they had a 3-day weekend. Come on. Judge has brought that up several times. They had pre-trial. They had during trial. They had...
Zellman, Ms. Fulford, Mrs. Adelson, the extra time that you have been provided, that has come to a conclusion. We are not finished with the colloquy quite yet. I am not talking for the sake of talking. Before we have to move into any contempt, we do need to move on. Mrs. Adamson, the question remains, as it relates to your right to remain silent and your right to testify, what is your decision concerning these 2 rights?
This time I don't want to testify.
Very well. As I've previously stated, the jurors will be instructed that your silence cannot be held against you in any way. We will bring the jurors back out. The defense will rest its case on the record. Ms. Kappelman, you indicated the state will not have rebuttal.
Didn't say that, Judge. May I have a moment to confer with co-counsel?
Go ahead.
Thank you, Joanne Jedi Platypus. We were behind you, Donna. We were behind you. We were throwing money at you. Donna, we were throwing money at you. All right, I have to end the poll. Will she testify? I have to end the poll because we just found out. Will Donna testify? Oops, hold on. So now the state is taking a moment to see if they are going to put on a rebuttal. So 143 votes. Will Donna testify? No way. 64 said no way. So now the state is conferring. Sorry, I'm typing. So the state now is conferring if they're going to have a rebuttal, but it seems like the state is the defense is going to testify. Paralegal Mindy, I knew she would chicken out. Yeah, at this time, is there
There's
another
one matter, Judge, that I thought we might be able to reach an agreement on, and we have. I will need to prepare a written stipulation for Your Honor to read to the jurors, or we can decide the language now if you find that more acceptable. It's a one-liner. The parties have stipulated or agreed that Patricia Bird was never listed on the defense witness lists.
As to that, prepare the stipulation in writing. It needs to be signed by counsel for all parties and the defendant. From there, the stipulation will be read prior to the court going into further instructions. The preliminary copy of the jury instructions was sent to everyone this afternoon. Did everyone receive it?
We received it, Your Honor. We have not yet had a chance to look through it.
All right. We'll bring the jurors back into the room. The defense will rest. We will send them home for the evening. And we'll give you a few minutes to look through the instructions. We'll go through the charge conference. And then tomorrow we will move into instructions and closings.
Your Honor, can counsel have a moment to confer concerning whether or not we are going to rest at this point?
Do you have another witness to call?
That's what we need to discuss, Your Honor.
We've done a lot of conferring. Please quickly come to a decision as to whether there is another witness, in fact, for the defense.
Man, I can't type fast enough. The things are changing so quickly. All right, so she decides not to. Okay, so I need a decision. Please rise. We're not finished with the colloquy yet. I'm not talking for the sake of talking. And before I put you in contempt, we need to move on. That's a short. We got to make a short out of that. This day has been nothing but a bunch of shorts. So then Donna, so she says, at this time, I don't want to testify. So at this time, what does that even mean? At this time, I don't want to testify, right? They're deciding on Charlie, maybe. Yep. Oh, wait. Who just gave a bunch of gifted memberships? Did I miss something? Oh, Lazy Boy, thank you. 50 Trial TV Live gifted memberships. Holy smokes. Wait a minute. Let me try and, I can't pull that up. Lazy Boy, thank you. That's beyond generous. Thank you so much for the 50 Trial TV Live memberships. That's just absolutely amazing. Thank you so much. Wow. Lazy Boy, that's beyond. Thank you. Yeah, this is epic. I hear you, Hellrider. I'm glad that we're sharing this moment together, you guys. This has just been an unbelievable day. And I'm glad that you're with us. I'm so glad that you're with us today. We will forever remember this trial and this day. That is for sure. All right, so we voted. Will Donna testify? Are you kidding? No way. 64%. 35% said, hell yeah. So the state needed to confer about rebuttal. They reached an agreement. They need to write a stipulation to read to the jury. Basically, Patricia Bird was never listed on the defense witness list. Defense, we need to discuss if we will rest or not. So now the defense needs time if they will rest or not. The judge said, well, we've done a lot of conferring, and please come to a decision on another witness. Seagate in the house. This is epic. Yeah. Great job, Lazy Boys. You're great. Sherry says. Jaded Wonder.
Is there another witness to be called?
Your Honor, we are going to be tendering 2 exhibits to the court to introduce. I believe that both qualify under hearsay exceptions. The state's indicated that that they're objecting. If I could just have a moment.
Boy, that was a big sigh from Judge Everett there. So Zellman says he wants to tender 2 exhibits, and the state is going to object to that, so he needs a moment. Another moment. Steve, how do you gift a membership? All right, hold on. They're trying to introduce 2 exhibits, and the state's going to object. Steve, there's where you chat, there's a little emoji icon, and then there's a dollar bill icon. If you click on that, it says super stickers, super chat, membership gifting. So that's how it looks on a laptop. I don't have my phone with me, so I'm not quite sure. There were 2 exhibits. Mallory, thank you for the $4.99. Really starting to wonder if defense is doing this on purpose, like to win an appeal based on her rushed decision to testify or ineffectual counsel. I think any appellate panel that sees this is going to be like, no, she could have decided. She had multiple opportunities. Judge Everett gave her multiple opportunities. Lily Wayne, judge is fed up with this.
Mr. Zellman, concerning the items, we do need to move on so a ruling can be made.
Yesterday, the state, or sorry, not yesterday, but earlier in the case, the state introduced excerpts of the 2014 calendar that belonged to my client, as well as the 2023 calendar for my client. Under the rule of completeness, we are asking that the court admit the complete 2014 calendar, as well as the 2023 calendar that is I believe it's States 51. No.
What's the question?
Councilman, concerning these items was the state's argument.
State's objection is hearsay, Your Honor. The portions that were admitted by the state were for very specific purposes. The rest of this item is not needed to add context to those individual entries. It's a day calendar. It's not a narrative. I don't think there's any argument for completeness. There's tons of self-serving hearsay in those documents. The state objects.
Your Honor, with respect to the 2023 calendar, the state introduced a few pages that listed my client identifying items that she was going to sell. Based on the questions that were asked, the implication from that is that my client was selling these in anticipation of fleeing the country. Contrary to that, there are a ton of pages going back to January 9th of 2023 where my client lists those very same items to get prices to sell. So it is misleading to just put in those couple of pages that the state put in on the 2023 calendar for purposes.
Who was going to lay the foundation concerning the items that you wish to admit?
Foundation's already been laid by the state, Your Honor. It was seized by...
I believe as the inculpatory matters, yes. As to whether or not she was planning to sell something in January of 2023, what witness testified concerning that?
Judge, the implication from the state's admitting those pages is that my client was selling these in anticipation of fleeing. Under the rule of completeness, we should be entitled to introduce the additional entries from the calendar showing that it didn't just start around the time that she decided to travel to Vietnam, but it happened previously. Not for the truth of the matter asserted. Not that she was...
Hold on. These are not recordings. A book with several entries is somewhat different from a recording. As it relates to recordings, the rule of completeness, I believe, serves a different purpose in the manner that you're describing. As to each page of this planner, all of the information is not inculpatory. So to that end, what witness has laid a foundation for the pages that you seek to admit that are separate from the inculpatory information?
All we're seeking to admit are the pages from the 2023 calendar that list those additional items. List the items that the state has already put into evidence as my client intending to sell them prior to leaving the country. I've printed out the specific pages and I prepared a copy with highlights to be able to present to the jury during closing. But it's not the entire, we don't have the entire 2023 calendar. It's been marked for identification and it's in the clerk's possession. These are just the pages with those entries.
As to that, I will reserve whether the rule of completeness will drag across the pages that you're seeking to admit. I'll do some additional research, but again, every item that appears in the calendars does not have a relevant or probative hook to this matter. If there is not a witness that will testify or lay a foundation concerning this, I will reserve for now. Depending on the court's ruling, you may argue it in closing. It's the same argument as the 2014 calendar.
Just a moment. Excuse me, Your Honor. The argument for the 2014 calendar would be the same under the rule of completeness. Obviously, there are things in here, and I said this to Ms. Kaplan earlier, that include personal information that would have to be redacted. Prior counsel provided a scanned copy of this to the state. If they could send that to me, I could identify the items that I think should be redacted. The specific purpose of offering the 2014 materials has to do with planning the 70th birthday party of our client's husband and the specific entries that she made identifying the tasks that she was going to carry out for that.
Again, is there any witness who will testify to these matters, or you're just offering them as rule of completeness?
Rule of completeness, Your Honor.
Ms. Kappelman, any additional argument that you might already made?
The only entry from the 14 planner that was admitted, has been admitted so far in this trial, is the page that shows
The license plate
the
number.
license plate number, sir. And so I don't see how birthday party planning adds to the completeness of possessing the license plate numbers. I would object. In addition, I think this exhibit is in a little bit different posture because the 2014 planner in its entirety has not been identified at all. Only that page was identified. The 23 planner was identified as by a witness as they're being seized from the residence.
I will reserve ruling as the 2014 planner as well. Beyond that, if the court does permit these items to be admitted, the defense will be able to admit them prior to any instructions and closings, and you'll be able to argue them if they are admitted.
Yes, Your Honor. And for the record, what I've done is I've marked the 2013 excerpts as defense, the 2023, sorry, as defense 51, and the 2014 as 76.
Please leave them with the clerk.
Judge, if Your Honor does rule that those items are admissible, the state would request complete redactions of all the items that are not related to the specific purposes the defense articulated.
Certainly no objection to that, Your Honor.
Please bring in the jurors.
And Judge, the state has made I want to check the redactions on this video.
I believe this is just being admitted without being published, correct?
That's correct, Your Honor.
Yep. Jurors are fine to come in.
All right, you're entering the courtroom.
Everyone can be seated. Defense may call its next witness.
Your Honor, at this point in time, the defense rests.
Members of the jury, with the defense having rested, is the state planning to recall or call any rebuttal witnesses?
No, Your Honor.
With both the state and defense having rested their cases at this time, we are going to go into recess for the evening. I have some matters that I need to discuss with the parties, and from there tomorrow you will receive your instruction on the law and the closing arguments will take place. Once again, do not discuss this case with each other or any other person. Do not seek out any additional or outside information from what has been presented to you in this courtroom. Please report tomorrow at 8:45 and we will get started at 9 o'clock, or at least attempt to. Have a good evening. Everyone can be seated. Please open your copies of the jury instructions. My custom in going through the jury instructions is to go through each one. Any requests or changes that are being asked for by either party, we will address as we go through each instruction. Let's start with 3.1, Introduction to Final Instructions. Are there any requests or changes being sought?
No, Your Honor.
No, sir.
3.2, Statement of the Charge. Any requests or changes?
Not from state.
Your Honor, the only request that I would make is that the name of my client and the names of the charges not be in all caps.
So stylistic changes.
Yes, Your Honor.
State, do you wish to be heard?
No, sir.
I will make that change. Let me make a note. Moving on to 7.1, Introduction to Homicide. This is a mandatory instruction in all murder cases. As to the first paragraph, Donna Adelson is accused of first-degree murder in count 1 of the indictment. Is there any request or change?
No, sir.
As to the next paragraph concerning lesser includeds, is the defense asking for all Category 1 lesser includeds?
Confirming my recommendation being approved by our client, Your Honor. Your Honor, the defense would request the manslaughter lesser.
As to the second degree lesser, are you requesting that as well? It's Category 1.
With the although it's a Category 1 lesser, it still carries the same penalty. So we are not requesting second degree.
Is the state requesting second degree as a Category 1 lesser?
Yes, sir. We would be requesting all lessers.
Well, all Category 1 lessers will be given. Second paragraph will read in the introduction, first-degree murder includes the lesser crimes of second-degree murder and manslaughter, all of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. I believe the indictment refers to the victim as Daniel Markel. Does either party have a preference?
To conform to the indictment, we would request his full name, Your Honor.
Acceptable to that.
If you find Daniel Markel was killed by Donna Adelson, you will then consider the circumstances surrounding the killing and deciding if the killing was first-degree murder, second-degree murder, or manslaughter, or whether the killing was excusable or resulted from the justifiable use of deadly force. The definition of justifiable homicide and excusable homicide is either party seeking these. Not entirely certain we have any evidence in the record that would support giving them, but as either party requested.
Just a moment, Your Honor. I would agree with the court's conclusion, Your Honor.
Mr. Evans, Ms. Koppelman.
No objection removed.
The definitions of justifiable and excusable homicide will be removed. As to any other degrees, I believe the evidence remains the evidence. I do not find where there is a basis to give either set of instructions as to the lessers. Final paragraph of the introduction will read, I now instruct you on the circumstances that must be proved before Donna Adelson may be found guilty of first-degree murder or any lesser included crime. As to count one, the state is only proceeding on the premeditated theory. Is that correct?
Yes, sir.
Any reference to felony murder will be removed. The elements of first-degree premeditated murder. Element 1, Daniel Markel is dead. Element 2, the death was caused by the criminal act of Donna Adelson. Element 3, there was a premeditated killing of Daniel Markel.
Just the stylistic issues that we raised previously.
Very well. Instead of caps, they will be in upper lowercase. Moving on to the definitions. The definition of an act will be given. Killing with premeditation, that will be given. The question of premeditation, that will be given. The portion that will be omitted, give only if there's evidence the defendant acted in the heat of passion on legally adequate provocation. That will be removed. All right, instruction 3.4. This deals with the lessers. Is there any objection or request other than the stylistic issue previously raised?
Yes, sir.
Your Honor.
All right, 7.4, second-degree murder. Introduction to homicide will be given. This portion of the instruction will be removed. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. Element 1, Daniel Markel is dead. Element 2, the death was caused by the criminal act of Donna Adelson. Element 3, there was an unlawful killing of Daniel Markel by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. As to the definitions, I believe act is repeated. Is there any objection to this stating an act has been previously defined above?
I don't have a legal objection to that, Your Honor.
Mr. Evans?
No objection.
The second definition, an act is imminently dangerous to another and demonstrating a depraved mind. That must be given. In order to convict of second-degree murder, it's not necessary for the state to prove the defendant had an intent to cause death. That will be given. Give only if there's evidence the defendant acted in heat of passion on legally adequate provocation. That will be removed. The next lesser, 7.7 manslaughter. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. Element 1, Daniel Markel is dead. As to element 2, which theory is the state proceeding on? Well, A and B will be split by an or. Donna Adelson intentionally committed an act or acts that caused the death of Daniel Markel, or Donna Adelson intentionally procured an act that caused the death of Daniel Markel. Right. Concerning the State versus Spencer italic, that will be removed.
And my understanding, Your Honor, is given the fact that the defense has not requested that instruction, has agreed there's no legal basis to give the instruction, there is a concession that the homicide of Daniel Markel was not excusable or justified.
Zellman, do you need to be heard concerning the concession that it's not excusable or justified?
Not in the facts of this case, Your Honor.
And the defendant agree with that concession.
Very well. Mrs. Adelson, do you understand what is being omitted from the jury instructions?
Just 1 second, Judge.
Go ahead. Mrs. Adelson, do you understand what is being omitted concerning whether this homicide was justifiable or excusable?
I do.
As to that concession, do you need anything else that you need to discuss with your attorneys?
Yes. She said yes.
Please discuss it with them now.
Thank you.
Adelson, you understand the concession that is being made as to justifiable and excusable homicide.
I understand that, Judge.
You are giving your consent to this.
I am.
Let's move on at this point. The paragraph that states every person has a duty to act reasonably toward others if there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act. I believe the period needs to go there because there will not be any discussion of justifiable or excusable homicide. Does either party wish to be heard?
We concur, Your Honor.
In order to convict of manslaughter by act, that paragraph will be given. The last portion. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, and which caused death. The justifiable and excusable portion of the sentence would be removed. Does either party wish to be heard?
No.
No, Your Honor.
The definition of procure will be given, and all other references to culpable negligence will be removed. Moving on to 3.5 sub A, principles. The two elements are static. As to the portion below that is italicized, or any of the italicized portions being requested. As to the first paragraph where it says attempted homicide cases.
We're not, let's hold up. Completed offense.
Say that one more time, Mr. Evans.
We're not asking for the attempt, we're just asking for
Correct.
Completed offense.
I believe that instruction must be given for first-degree premeditated murder. And all references to attempts of any other sort will be removed. The state must prove the defendant intended that the killing of Daniel Markel occur. As to the paragraph that concerns second-degree murder, felony murder, or other attempts, I believe this paragraph needs to be given as it relates to the lesser as well. For second-degree murder, it is not necessary for the state to prove the defendant intended the death of Daniel Markel.
Your Honor, I think under that, the manslaughter instruction, or manslaughter needs to be included.
Concerning whether an intent was necessary for manslaughter as well, Mr. Evans.
Yeah, you have to intend the act, but you don't have to intend to kill.
As to that inclusion within the principal instruction, does the defense wish to be heard?
Just a moment, Your Honor. Not sure that manslaughter is included in that, Your Honor.
It's not included in the standard instruction, no.
Can I have some time to research that to make sure that I'm not inviting error?
That's fine.
And Mr. Zeldin can get in contact with me on that, Judge, and I'll let you know the later this evening.
Right. If given to the jury as requested by the state, it would essentially mirror what it states as a second-degree murder. For manslaughter, it is not necessary for the state to prove the defendant intended the death of Daniel Markel. All right. No weapon enhancement is being sought by the state. I believe that paragraph needs to be removed entirely. Does either party wish to be heard concerning those?
Are you asked?
For cases where the criminal statute includes a higher degree because of a firearm.
Yes, sir. I skewed down, moved down the principles already to the next size. Yes, sir. No, there's no evidence that the defendant in this case actually possessed a firearm, so no, we're not requesting it.
It will be removed. .5 sub B, principles when active participant hired by defendant. If the defendant paid or promised to pay another person or persons to commit a crime, the defendant is a principal and must be treated as if she had done all things the person who was promised or received the money did if the state proves beyond a reasonable doubt. And then elements 1, 2, and 3 are to be given. As to the bracketed portion of element 3, the offense that the state is asking for to read in element 3, would this be first-degree murder?
I'm sorry, Your Honor. Can you say it again?
Element 3, the bracketed portion, it says crime or attempt. The crime that the state is requesting, is that first-degree murder?
Yes, sir, but I don't believe that, I don't think it asserts crime. I think you just leave the crime was committed by another person.
So not a specific crime, just crime?
Yes, and I think that's why they have attempt.
Unless you want the offense to be named, I will leave it at crime.
I don't believe this crime is the appropriate one given the standard of show.
I'm going to look at the standard briefly, Your Honor.
The other person that is referred to in the bracketed portion, or any specific names being sought, or just the other person?
Just the other person, Your Honor.
I would ask that the individuals, Secretary Garcia and Luis Rivera, be named.
I believe within the indictment, the named co-conspirators are Charles Adelson, Catherine McManawa, and or other persons.
For count 1, Your Honor, there's no one identified.
Mr. Evans.
You, for principal construction.
3.5 sub B, element 3.
Yes, sir. But what I'm saying, for principal instruction, you do not have to allege it in the indictment in order to be entitled to principal instruction.
Well, we'll read the crime was committed by the other person. As to the persons who committed the crime, I believe the evidence in the record is clear. It can only be argued that Luis Rivera and Sigfredo Garcia were the actual trigger men, although who may have put them up to the act as a conspiracy, that is for the jury to determine. Any other matters that need to be addressed with 3.5 sub B?
Just doing away with the firearm part of it.
That will be omitted.
And Your Honor, there's something I wanted to address briefly on 3.5A.
Go ahead.
By my reading, this is the new instruction.
This is straight from the Florida Supreme Court on the Florida Bar website instruction.
Well, we are making the affirmative election to use the current instruction rather than the instruction that existed in 2014, which my client would be entitled to request.
This is the current instruction.
I'm sorry, yes.
This is the current instruction.
Yes, we are making the affirmative request for this rather than the old instruction. I want to make that clear for the record.
Moving on to count 2, conspiracy to commit murder. To prove the crime of criminal conspiracy, the state must prove the following 2 elements beyond a reasonable doubt. Element 1, the intent of Donna Adelson was that the offense of first-degree murder would be committed. Element 2, as to agreed, conspired, combined, or confederated, which are being requested by the state.
All 4.
In order to carry out the intent, Donna Adelson agreed, conspired, combined, or confederated with Charles Adelson, Catherine McBanawa, and or other persons to cause the first-degree murder to be committed, either by them or one of them, or by some other person.
Your Honor, on that, I think I understand the way it is written, but in order to avoid confusion, because the and or would apply between the Charles Adelson and or Catherine McBanawa and or other persons. So I think it could be.
You're just requesting an and or between names.
Yes.
Defense wish to be heard.
Your Honor, I always have a heartburn when I see and or in a jury instruction.
Going back to the indictment, these are the individuals that are in the charging document.
I understand that it's in the indictment. I think it leads to potential confusion with the jury. We would ask that and or not be included.
And if that's the case, then you could put simply or. So and or, my understanding and or are, it can include, basically, if you put something, or, I mean, this one, or this one, or this one, or this one. And so in this case, if it's Charles Adelson or Catherine McBanawa or other persons, that would be acceptable to the state.
I don't have a legal objection.
Conjunction?
Yes.
What's your function?
Yeah.
Very well, Charles Adelson or Catherine McBanawa or other persons. It is not necessary that the agreement conspiracy, combination, or confederation to commit first-degree murder be expressed in any particular words, or that words pass between the conspirators. Then lastly, it is not necessary that the defendant do any act in furtherance of the offense conspired. As to the affirmative defense, I am not aware of any evidence in the record that would require this to be given. Does the defense have any argument?
We agree, Your Honor, there's no evidence of it.
It will be omitted. Count 3, solicitation to commit murder. To prove the crime of criminal solicitation, the state must prove the following 2 elements beyond a reasonable doubt. Element 1, Donna Adelson solicited Charles Adelson, Catherine McBanowa, and or other persons to commit first-degree murder. As to this, are the parties asking this to read with the same or that it does for conspiracy to commit?
Yes, sir.
Yes, Your Honor.
Very well. Element 1, Donna Adelson solicited Charles Adelson or Catherine McBanowa or other persons to commit first-degree murder during the solicitation, and which are being requested by the state.
All 4, Your Honor.
During the solicitation, Donna Adelson commanded, encouraged, hired, or requested Charles Adelson or Catherine McBanowa or other persons to engage in specific conduct which would constitute the commission of first-degree murder. It is not necessary that the defendant do any act in furtherance of the offense solicited. The crime of first-degree murder has been previously defined in these instructions. The definition of solicit must be given as well. The affirmative defense will be omitted based on lack of evidence.
Your Honor, I believe we're also entitled to a principal instruction on solicitation. I think the only area...
Go ahead.
I think the only area principle doesn't apply is for conspiracy.
Do you wish for me to move then the 2 principal instructions to the very end, and then they can be argued as to counts 1 and 3 is necessary?
You could put it there, or you could simply state the principal instruction applies to solicitation with murder as they have previously been defined. Or do we need to...
Defense?
We would object, Your Honor. How can one be a principal to solicitation? I'm not sure that that's correct. And as with the previous issue, I want an opportunity to look at that. That's not been requested in previous co-defendants trials, or at least it hasn't been given.
I think the easiest way to settle this would be to move the 2 instructions to the end of the counts, and then that way they can be argued as necessary for which counts they apply to.
The concern that the defense has, Your Honor, is whether or not it's legally appropriate. That's what I'd like the opportunity to address.
As far as that, you can research the matter whether it can be argued that someone is a principal and solicitor.
Thank you.
For now, I will just move the 2 instructions to the end of the counts.
If they're in the counts, it just needs to be clearly stated that conspiracy, it does not apply to the conspiracy count. I think we're all in agreement on.
I can add it, but ultimately no instruction can be argued as to a defense that it does not apply to. Does the defense wish for me to add at the end of the principal instructions that this does not apply to conspiracy?
Yes, Your Honor, and that might be a moot point depending on the research that I do later.
I'll just add at the bottom the principal theory. Or actually, this instruction does not apply to. And I can do that for both principal instructions. Moving on to intent as a standalone instruction. This is not a standard instruction, but comes from standard jury instruction 13.1 burglary, which gives a definition of intent. This was given in the prior trial for Charles Adelson, and I have given it previously in murder cases. Is either party requesting it, or do you wish for it to be removed?
We're requesting it, Your Honor.
The intent instruction then will remain.
We would object, Your Honor.
What is the basis?
The basis is it's not a standard instruction.
100% speaks to the facts and evidence in this case as to how the jury must determine whether your client had intent. Over objection, it will be given. 3.7, plea of not guilty, reasonable doubt, and burden of proof. All standard language from the current instruction. Does either party wish to be heard?
No, sir.
No, Your Honor.
3.9, weighing the evidence. The opening paragraph will be given. As to the witness testimony, 1 through 5 will be given. As to the give as applicables, which are being requested.
It's probably number 10's the only one we're not requesting. So 6, 7, 8, and 9.
Does the defense have any argument for the giving of number 10?
No, Your Honor, we agree.
Number 6, has the witness been offered or received any money, preferential treatment, or other benefit in order to get the witness to testify? Number 7, had any pressure or threat been used against the witness that affected the truth of the witness's testimony? Number 8, did the witness at some other time give a statement that is inconsistent with the testimony he or she gave in court? Number 9, has the witness been convicted of a felony? Or a misdemeanor involving dishonesty? Whether the state has met its burden of proof, that will remain. To the next set of give as applicables, law enforcement witness, is this requested?
Yes, Your Honor.
No objection.
The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration. Expert witnesses. Experts are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. As to the issue that came up earlier with the testimony of Linda Bailey, is the state requesting any instruction to be given to the jury concerning that testimony?
Yes, Your Honor.
What is the requested instruction?
I have it typed out for you. Would you like to?
Yes.
Copy to the defense. Sorry about the typo in the title. And the certificate of service. It's all on Mr. Evans.
Right, as to the requested instruction, was the witness present in the courtroom during the testimony of another witness or other witnesses? Did the witness violate the court's order not to be present in the courtroom during the testimony of another witness or witnesses? What is the defense's position?
This one. I have an objection to the first one, but the second one we do.
What is the objection? Is the second?
Your Honor, it's based, the witness's presence in the courtroom is based on our apparent misunderstanding of the discussion that we had at sidebar last week. As a result, we think that the first one is an accurate statement of the law, but under the facts, the second one would be inappropriate.
Kappelman, what is your argument for the giving of the second?
I'm fine with just the first one, Judge.
Well, after the expert witness instruction, the next instruction will be, was the witness present in the courtroom during the testimony of another witness or witnesses? Accomplices and informants. You must consider the testimony of some witnesses with more caution than others. For example, a witness who claims to have helped the defendant commit a crime, has been promised immunity from prosecution, hopes to gain more favorable treatment in his or her own case. I believe we have number 3 of the bracketed portions. Are any others being sought?
Your Honor, it has just dawned on me where you're sticking the previous requested instruction about the witness was present in the courtroom during the testimony of another.
Yes.
That's probably better under weighing the evidence as opposed to, because
You're asking for this then to be inserted into the 10, or what would be the 9 questions and make it 10?
Yes, because I don't know how much sense it would make if we read, like other witnesses, you may believe, disbelieve all or any expert testimony, and then was the witness present in the courtroom during the testimony of another witness or witnesses. Certainly it's hanging out there as to what does that mean?
I understand what you're getting at. Does the defense wish to be heard as to the position?
We don't have a legal objection, Your Honor.
Then it will be question 10. Let me move that now. All right. Going back to accomplices and informants, for example, a witness who hopes to gain more favorable treatment in his or her own case. Are there any arguments for claims to have helped the defendant has been promised immunity?
Not from the defense, Your Honor.
Those will be admitted. You must consider the testimony of some witnesses with more caution than others. For example, a witness who hopes to gain more favorable treatment in his or her own case may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So while a witness of that kind may be entirely truthful when testifying, you should consider, and I believe this would just be her testimony.
Yes, sir.
Your Honor, can we go back to the first bracketed language, please?
Which is being requested?
Claims to have helped the defendant commit a crime. I think that would apply to Ms. McManila and to Mr. Rivera.
State.
Stop here. So for the record, as I understand it, of the bracketed languages under accomplices and informants,
who claims to have helped the defendant commit a crime or hopes to gain more favorable treatment.
All right, yes, sir.
So while a witness of that kind may be entirely truthful when testifying, you should consider her testimony with more caution than the testimony of other witnesses. However, if the testimony of such a witness convinces you beyond a reasonable doubt of the defendant's guilt, or the other evidence in the case does so, then you should find the defendant guilty. There have been no children witnesses. The defendant has not testified. Witness talked to lawyer. Is either party requesting this?
Yes, Your Honor.
That will be given. And be given all cases, you may rely upon your own conclusion about the credibility of any witness. That will be given. Defendant not testifying. This will be given in full. And we'll just change the pronouns to all feminine. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove her innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by her decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. As to defendant's statements, I do not believe there was ever a statement given by the defendant to law enforcement. This specifically goes to whether the statement was freely and voluntarily made. As to that, as there is no law enforcement statement, this will be removed. Does any party wish to be heard concerning this?
No, sir.
No, Your Honor.
Rules for deliberation. Standard instruction, this will be given. Does either party wish to be heard?
No, sir.
No, Your Honor.
Cautionary instruction, does either party wish to be heard?
No, sir.
No, Your Honor.
Single defendant, multiple counts, does either party wish to be heard?
No, sir.
No objection.
3.12 verdict. Any objection or request?
No.
Moving on to the verdict form. Count 1, we the jury finds as follows. As to count 1 of the indictment, first-degree murder, Check only one letter choice as to this count. Option A, defendant is guilty of first-degree murder. Option B, defendant is guilty of the lesser included offense of second-degree murder. Option C, the defendant is guilty of the lesser included offense of manslaughter. Option D, the defendant is not guilty as to count 1. Any objection or request?
I'll make the same request that I make in all cases. We would request that not guilty be the first option since she has the presumption of innocence. We would also request that the words guilty and not guilty not be in all caps and bold.
As to replacing the order, I believe the standard instruction not only identifies guilty, not guilty, but the state is the plaintiff in this matter and has brought the action. They are entitled to the first option. That is overruled. As to the options being in bold or not, does the state have a position at which is the raise?
The only thing I would suggest if we leave them in bold, it makes it clear for the jury to differentiate between each of the counts, but I don't have any real strong opinion, but I see why they would be in bold.
So you are requesting for it to remain the same or to not be bold?
I request they remain the same simply because I think it makes it much clearer to the jury to identify what is what. It's not suggesting anything, it's just making sure they recognize which box they're checking.
Very well. It will remain in bold. This is for the purpose of clarity. No other purpose is involved. As to count 2, we, the jury, finds as follows as the count 2 of the indictment, conspiracy to commit murder. Check only one letter choice as to this count.
Your Honor, what about all caps for the guilty, not guilty words in count 1?
This is stylistic because ultimately this has no bearing on how they're evaluating the evidence, correct?
I think the same reason why I'm asking for the names of the charges to be in regular caps, not all caps throughout the instructions. It's the same principle.
State, do you have a position?
Your Honor, I think it's, to me, and when it comes time to sign the verdict, we want it real clear which boxes they are checking. I think this makes it the most clear. That's the reason I think the all caps and the bold are appropriate. The only stylistic change I would suggest, and like count 1, probably need to move the degree murder that's up under it over to fully under B, under subsection B, and manslaughter fully under subsection C, so it's not up under the check box. But other than that, I think throughout the verdict form we're going to be asking the same thing. Leave it as is because I think it makes it much clearer to the jury when they're looking at it. You know what you're checking.
As to the body of the instructions, we'll grant the defense's request for the verdict form itself. Again, the object specifically is to have clarity as to what verdict the jury is reaching and why. The form will remain as it's currently presented. 2 options, guilty and not guilty for count 2. Same 2 options for count 3, guilty and not guilty.
We suggest, Your Honor, for count 3 that you move it off page 16 to the top of page 17.
I've been making several edits, so my pages aren't the same, but it will flow to where it's not being broken up between pages.
Thank you, sir.
All right, closing argument 2.7. Any objection or request?
No, sir.
No, Your Honor.
How much time is each party anticipating for their closing argument?
2 hours, Your Honor.
We would say the same, Your Honor.
Very well. Both parties will have 2 hours to present their arguments. Ms. Kappelman, yours will be broken up based on what the law permits between your initial closing and any rebuttal that you wish to give to the defense. You'll need to be mindful of the time. I will help you in that regard as well. 2 hours.
Don't tell me too much.
Submitting the case to jury, just with the time. Nothing else. Any objection or request?
No, sir.
The items that are going to be sent into the jury room, I believe we have photos, discs, jump drives, written reports. Is there anything that the parties are not asking to go back into the jury room?
Just the demonstratives, Judge, all the exhibits, I think.
A demonstrative is not admitted, so yes, I would agree. It is not to go back into the jury room.
Ms. Dugan and I spoke earlier during the trial about going through especially 73 and 73 and make sure it complies with the court's ruling, so we'll do that before they're sent back.
All right, and I will just leave it then. Photographic discs, jump drives, reports, and document exhibits will be sent to the jury room with you when you begin to deliberate. If you wish to see any other exhibits, please request that in writing. And the final instruction, when we reach the end of the case, instruction upon discharge of the jury. Standard language once again. Any objection or request?
No, sir.
No, Your Honor.
I believe the remaining edits that I need to make within the body of the instructions concern the capitalization and the names. I believe the state has requested within 3.5A for manslaughter, it is not necessary for the state to prove the defendant intended the death of Daniel Markel. I believe the defense is reserving any objection as to that instruction. That will remain for now. Also added to both principles, this instruction does not apply to count 2. The defense was asking for time to review that as well. Or was it specifically as to count 3?
It's specific. Principle applies to count 1. There's not disputing that in any way, shape, or form. I wanted the opportunity to look at it as to count 3.
As to the language, this instruction does not apply to count 2 appearing in both principal instructions. Does the defense wish to be heard?
No, Your Honor.
All right. Once I've made my edits, I will send through my assistant an updated copy of the instructions. I will also rule on the items that were submitted by the defense prior to the end of its case. And then from there, we will roll into the instructions and the closings tomorrow morning. Please report by 8:30. We will await the jurors. Any issues that can be resolved concerning the exhibits, certainly confer and advise tomorrow. We're in recess.
All right, both sides get 2 hours. 2 hours for the state, same for the defense. So both sides are going to get 2 hours. So the state's going to break theirs up. So the state is going to break theirs up. All right, so the defense rested, no rebuttal. Clearly something's still going on. I wish we could hear this. But yeah, I don't know, Sharon. Well, the judge said they're done, so that means the court turned their audio off. I wish maybe they'll turn it back on. There's really no reason why we can't hear this. This is still all on the record. Yeah. All right. Well, we'll stay here. Maybe they'll come back. I mean, the judge is still talking and ruling on stuff. Missy, you'll take Z over Jackie. So that new guy that was talking, he was in the Henry Segura. If you guys remember that, we did a rewatch of Henry Segura, and it's Eddie Evans. So he was, and Sarah Dugan was in Henry Segura. So, and he was in, I guess he was in Tallahassee? Yeah, he must have been, because he had that judge, the same judge that had Catherine Magbanowa. So that happened in Tallahassee too. So funny, you watch trials long enough, you get to see, okay, now we're showing the seal. So now it seems like they're done. All right. So now it seems like they're done. All right, so they went over jury instructions, potential jury instructions. The defense asked the name of Donna and the charges to not be in all caps. So the judge is like, so stylistic. So there's going to be lesser crimes. There's going to be second degree and manslaughter. They will be lesser included. Culpable negligence will be removed. Donna, do you know what is being omitted concerning justifiable and excusable homicide? And she said yes. All right, seems like they're done. I'll put up the thumbnail. Let's see. And the judge says, so Zellman says, I have heartburn whenever I see and or. And so the judge says, conjunction, junction, what's your function? I love Schoolhouse Rock. As a kid, that was, oh man, I love Schoolhouse Rock. That was so much fun. And I know exactly what he's talking about, conjunction, junction. So let's see, law enforcement statement will be removed because Donna did not give one. She didn't give a statement to law enforcement. So count 1 is going to be first degree, lesser is going to be second degree and manslaughter, and then count 2 is going to be conspiracy to commit. And again, defense asked for them to remove the all caps for guilty or not guilty. He wants all caps to be removed. I mean, if both, I don't understand that. Both, it's not like guilty is all caps and not guilty is, that just is weird. That's just weird. And then, okay, so then judge asked about the times. Judge Everett said, what are the times? And the state asked for 2 hours. The defense said the same. So he said the state will be broken up, and judge is going to rule on all the items from the defense, and then they're going to start into instructions. 8:45, they are coming to report, so we'll go on at like 8:40ish, maybe 8:30. Well, to be determined, but yeah, we'll say 8:30. We'll go on at 8:30, talk a little bit, because I want to be able to hear what the judge has to say, and I want to have, well, we always hear what the judge has to say, but I want to have a little time with you guys before it starts. All right, if you haven't had a chance yet, we do have a poll going, so I'll close that in a few minutes. So if you're listening and you have not had a chance to vote in our poll, when do you think we will have a verdict? We have Thursday, Friday, next week, and never. Those are your 4 options. So take a moment before we close that poll. And let's see, what else do you guys have? We may have a verdict tomorrow if it starts early. I agree, Missy, since Charlie's verdict was about 3 hours, I hope it's within the same time frame. Yeah, I'm just a bill. I'm sitting here on Capitol Hill. Boo, 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 boo. Oh, I love that. Saturday morning. Yep. So much. Kathy, no, closing arguments will be tomorrow. They were just doing potential jury instructions today. So tomorrow will be closing arguments, and they will do, actually, they're going to do the instructions, he said, first, and then closing arguments. So if instructions take an hour, closing arguments take 4, so you're at 5 hours. So if they start at 9, they'll go 3 hours till 12. That will probably get them to lunchtime. Let's see, they have an hour from, say, 9 to 10 is jury instructions. 10 to 11 will be Georgia's closing. And then 11 to 12, 12:30 will be, well, actually till 1. They may break for lunch, and then they'll come back and they'll do 3 hours of closing. So it could be, yeah, I would be surprised if they come. I don't think they'll come back with a verdict tomorrow. I think it'll probably get to them around 3 at the earliest. 3 at the earliest. They may just pick a 4-person. They've done this before. We've seen this often, where they pick a 4-person at like 3, and then they go home, and then they come back in and they start deliberating the next day. They are allowed to deliberate until I think 5, at least 4:30 for sure. No, wait. This goes to 5:30. They are allowed. They could stay. Yeah, I mean, if they get it by 4, let me rethink that statement. They may. Yeah, let me rethink that statement. They could get the forms. They could start to deliberate by 3. Even 4. That would still give them an hour, a solid hour to deliberate. It depends on how many lines of instructions there are. You know, if there's like 20 lines of instructions, that's going to take them at least a half an hour, right? At least a half an hour. They could stay till 7, yeah, and they could stay. Yeah, with Sarah Boone, they came back late. They came back at like, it was nighttime. I think it was like 8:30 or 9. Yep, Missy, yep, Sarah Boone stayed late. Absolutely, yep. Does Florida allow jurors to stay as long as they want? They have to, with Sarah, Judge Kranick had to get permission from the judge above him, and they had to ask for the bailiffs, and they had to make sure that they had guards there and bailiffs there. So they can stay late. They can stay late, but they need permission. They can't just do it because they want to. They need permission. Judge Kranick needed permission from his boss, essentially, and then they needed to make sure that they had enough bailiffs and guards and whatnot. So they can't just stay just because they want to stay. They need to stay. They need to get permission from the superior judge. Yeah, victim statement might be interesting, Kathy. But Charlie was a different day. They didn't do Charlie's straight away. Charlie was a different day. Charlie was a different day. Or they could be like Black Swan and stay late. So curious why state didn't call Charlie, Chris asks. Yeah. They have to ask the courthouse. Yeah, that's what I guess what I was ultimately getting at, Shirley. Yeah. You have to make sure the bailiffs are going to be there. The courthouse needs to be open, so you have to make sure somebody's going to be manning handling the doors. So you can't just stay late just because you want to stay late. You can do it, but you need permission. They need permission. Lily Wayne, they close at 5:30. This was a 9 to 5:30 or 8:30 to 5:30, maybe 9 to 5:30. That's what Judge said at the beginning. This was going to be a 9 to 5:30 trial. So the jurors know that they could potentially stay till 5:30. But if they stay past that, they need to keep the courthouse open. And as I was explaining earlier, they need to make sure they have personnel. Sure Life, maybe they were scared with the way Charlie talked so much of what he might say on cross. That's true. Green-eyed cat. All right. See you tomorrow. Oh, well, thank you for being with us, Green-eyed cat. Have a good one. We will see you tomorrow. And we'll start at like 8:30. Because the jurors are supposed to report at 8:45 and then they're starting at 9. So we'll go on at 8:30. Shay, you're out as well. Love ya, mean it. Aw, thank you, Shay. Have a good one. And Joanne is saying, hearts back to you. Missy's saying, have a good night. All right, considering Charlie was found guilty, a liar, and Georgia's skills, yes, I would. That's minor to what they can prove. All right, Mike, you're going to be here. Fantastic. Sinbad, see you tomorrow. Lawyer Knows going live. Awesome. Yes, that was fun. I met Peter at Sarah's, at Sarah Boone. That was fun. Jules introduced us. All right, let's see. Hold on a sec. All right. So I'm going to close our poll in another minute or so if you haven't had a chance. When do you think we will have a verdict? Thursday, Friday, next week, or never? All right. And what do you guys think about going over? What do you guys think about going over to Peter's stream? Let me see if Sinbad, you're saying he's, let's see here. All right. So he is live right now. All right, Aaron's checking into that. All right, Sally, have a good one. We're going to go drop in on Peter. What do you guys think? Should we go do a raid on Mr. Tragos? Shay, you lied. I'm still here. In my divorce, we got a 2-for-1 and used the same attorney. All right, Ms. Holmes, see you tomorrow. You're going to go finish with Emily. All right, I hear you. Well, I never met Emily, but I did meet Peter, so I'm going to go say hi to Peter. All right, we're going to go do a raid on Peter. All 144 of us, let's go do a raid on Peter. Let's go do a raid on Peter. Peter Tragos, lawyer you know. Let's go do a raid on him. All right, when do you think we will have a verdict? 60% said Friday, 19% said next week, 18% said Thursday, 2% said never hung jury. All right, Peter. Peter is a lawyer you know, Peter Tragos. He's out of Tampa. I met him at the Sarah Boone trial. You guys will love him. We will portal you over. We'll portal you over, but here's the link in case you need it. Here's the link. Lawyer, hold on a sec. Lawyer you know. Let's drop some cats in his chat. So there it is, lawyer you know. No more kitty cam, not for tonight. So lawyer you know, Peter Tragos. I met him during Donna Adelson, I'm sorry, during Sarah Boone's trial. He's got 500,000 subscribers, so we're small peanuts, but what the heck? Let's go and give him a raid. Why not? All right. We'll see you guys tomorrow. Thank you, our mods. Thank you to all of our mods. Thank you. Chris K. Thank you so much. Let me read your, let me pull this up. What did you say? Why can't I pull that up? All right, Chris K says, Peter, I know you have said, oh wait, no, that's somebody else. I'm reading the wrong thing. All right, thank you, mods. Thank you so much for doing all that you do for us. Thank you, chat. Thank you to Aaron. And I always leave you with some kitty love. Oh, you guys have to see. Okay, look at these two back here. Look at those two. Look at Rafa and Paulie. Oh my goodness, how cute are they? Little Rafa and Paulie back there. Little Rikers in the white box there. And we got these two little guys here. We got Houdini and Roger Federer. I don't know where Super Ball is. Oh, Super Ball's back there. Super Ball's over there. So there's Super Ball. All right, guys. Thank you so much for joining us. We'll see you tomorrow at 8:30 Eastern. And have a wonderful evening. Thank you, mods. Thank you, Aaron. And we will see you guys tomorrow. And let's go hit up Lawyer You Know. Let's go say hi to Peter. See you guys. Bye.